Уважаемые коллеги, еще пару минут, я думаю, мы подождем, потому что не все наши участники первой сессии пока присутствуют. Я не вижу Михаила Львовича Гальперина, а он у нас пойдет первым докладчиком. У нас небольшие изменения в программе, о которых сейчас я тоже объявлю. Ну что, Халар Рашадович, может быть, будем начинать потихоньку? Да, я думаю, что остальные присоединятся, коллеги, пока мы будем открывать конференцию. Уважаемые коллеги, доброе утро. Мы открываем нашу пятую сессию двухдневной конференции по примирению процедурам и правосудию, кумулятивный эффект. И наша пятая сессия сегодняшняя посвящена процедурам мирного урегулирования споров в международном правосудии. И наша задача максимум была в том, чтобы показать изменение перспективы, в том, что касается понимания мирного урегулирования споров в международном правосудии. Потому что, как мы понимаем, изначально в классическом международном публичном праве судебное разрешение споров относится как раз-таки к мирным способам разрешения споров, да? В противовес вооруженным конфликтам как мирным способом. Поэтому в самом названии нашей сессии на самом деле заложена определенная тавтология процедуры мирного урегулирования споров в международном правосудии, да? Поскольку международное правосудие как раз является одной из таких процедур, согласно классическому пониманию международного права. Но мы хотели сегодня показать как раз-таки изменение парадигмы, изменение понимания примирительных процедур, изменение их места в международном правосудии, изменение последствий и в целом смещение фокуса именно на этот компонент дружественного урегулирования, на этот компонент примирения между сторонами до вынесения судом, международным судом какого-то решения по существу или заключения по существу. Значит, мы сегодня постараемся с помощью наших докладчиков эту перспективу проследить. И у нас тематически получается две сессии, две подсессии, точнее, две части нашей сессии. Первая сессия целиком сфокусирована на процедурах дружественного урегулирования и first session will focus on the procedures for amicable settlement and consequences of such procedures under the European Convention of Human Rights. And we have three presentations for today because changes have been made to the agenda of our conference. And obviously, so we are going through hard times, I mean, at the moment, and Mr. Kovler just cannot attend our conference, and another colleague of ours, and who is Chris Ivana, just send a message during the night that she also has some health-related reasons for not being able to deliver her presentation. So we are looking now at the European Convention for Human Rights, but also from the perspective of the application of these procedures. And this is a more focused approach. And from this focused approach, we'll switch to a broader perspective. So, and we'll try and trace this dynamic across international borders. So, at the stage prior to the trial of the case on the merits. So when the court would intervene and hear the case appropriately. So our session is not that long, so I hope it will be followed by very lively discussion by all the participants. And we have Hanlar Izhadovich Gaji, who will be co-chairing this session today. So if you would like to add something, probably to set the main points for our discussions today, then we'll do that, and then we'll proceed with the presentations. So as I said, so this order of presentation will slightly change. So we have Mr. Galperin as one of our speakers. So if he doesn't connect now, then I will first give the floor to Mr. Gaji. So it's over to you.
Не слышно, нет звука. Не слышно вас.
Сейчас слышно?
Сейчас слышно.
Can you hear me? Well, yes. It was. I apologize for this. And first of all, I would like to welcome all of the participants of the conference. I would like to thank you for the invitation to take part in this session, because obviously this is a very specific area of operations of international courts. And obviously all courts will be involved in the resolution of conflicts, and presumably judges are adequate and reasonable people. So being reasonable people, judges should try and seek first justice, and second peaceful or amicable settlement of disputes. And obviously you will not be able to satisfy all of the parties in dispute. And at the same time, we have the European system that is based on goodwill of the parties and their willingness to abide by the court decision. So I have some insights to share, and these will be presented during my report on international disputes. So, and rather than some claims relating to political considerations. So, because I'll be talking broadly about judiciability and those disputes that can be submitted for adjudication to international courts. So I would like to thank the organizers for putting together this excellent program for the conference, and then for this opportunity to focus on the very field-related points during our discussions.
Большое
So,
спасибо, Ханна
thank
Рашадович.
you
И
very much,
поскольку
Mr.
Павел
Gadeev, for
по-прежнему
your
пока не появился,
introductory remarks. So
тогда я предлагаю
we
начать
see
все-таки
that
с вашего доклада,
Mr.
как у нас с
Galperin
руками
has not
в
joined us
программе.
yet. So I
И
suggest we'll
насколько я понимаю,
start
у вас
with
есть
your
презентация, да?
report. And I
Вы
think that you
будете.
had prepared a report in the form of a presentation. Is that correct? Yes, that's correct. I put together this brief presentation to share my ideas with you. And just from the outside, when I received your invitation, I put this ideas presentation, and I would like to apologize for the scripting voice because I could barely speak several days ago, but God helped me, and now I can talk easily to you. So one more time, I would like
Я
to
прошу прощения,
thank you for
представлю, прошу
giving
прощения,
me
Ханна
the
Рашадович, потому
floor.
что я как
So,
модератор свою функцию не
but
выполняю. Представлю
I'm
вас
being a
как
chair. I
положено.
need to
Ханна
introduce
Рашад
yourself.
Гаджиев,
So,
доктор
Hanlar
юридических наук,
Ishadovich
судья
Gaji,
Европейского
Doctor
суда по
of
правам
Law,
человека в отставке, в
Justice of the
настоящее
European
время
Court of
заведующий
Human
отделом
Rights, retired
Института
judge,
законодательства и
and head of
сомнительного
Department of
правоведения с докладом
Judicial Practice and
«Европейская
Law
система
Enforcement
прав
of the
человека в
Institute
мирном
of
урегулировании международных споров».
Legislation,
Пожалуйста, Ханна
and
Рашад.
his topic will be European Court of Human Rights and the peaceful settlement of disputes. So obviously, any international court will try and do the justice in the resolution of disputes and cases, and so based on the basic agreement that should be followed. So when we look at the practices of the European Court of Human Rights and its role in resolving disputes, so we see that sometimes not all of the judges share this point of view, and uh, uh, they just don't distinguish it conceptually. For instance, it's a Geneva Convention of 19 or 1907 and 67 that says that this convention can still be employed during the period of armed conflicts. But on the other hand, so we can clearly distinguish a new trend in the court jurisprudence. So on the other hand, so we see that it is court decisions that say that some decisions or actions violate provisions of the convention. So it is used as a tool to determine the scope of rights and responsibilities during armed conflicts. And the court itself is not actively involved, and it is Article 9. So from the Convention on Treaties that is usually referred to, and that this article says that treaties should be abided by Assange versus United Kingdom and others versus Turkey. So this case was heard by the ECHR, and the decision was that if needed, the convention should be interpreted in accordance with the international standards, including humanitarian standards. And secondly, the European Court referred to the norms and provisions of the international humanitarian laws in cases where we see some provisions that go beyond the standard interpretation of conventional rules. So, and these can be used in order to decide the fact of violation of Article 7, and that it is also possible that the standards of international humanitarian law can be made part of domestic legislation. And this situation is different from the instances where international humanitarian law would be used in order to interpret conventional provisions. So they can be also used in conjunction. So detention during armed conflict just leads to a situation where the convention needs to be interpreted in the light of international humanitarian law in order to decide on the conditions of this detention. Thirdly, the court would also rule on imposing liability for any violation of international humanitarian law in case of occupation, Iraq and others versus Armenia, Sarkisyan versus Azerbaijan, Algeria versus United Kingdom. So these are just some of the cases to quote. So the court also referred to the judgments of your Strasbourg court and the case of Congo versus Uganda, and another case, Kilkenny and others versus the United Kingdom. And so the idea was to decide on the scope of Article 1 of the Convention, that's application and the jurisdiction of any state in particular that has been involved in the dispute. Plus, it demonstrates that the European Court of Human Rights would rarely refer to international human law, and then ECHR jurisprudence nevertheless uses this um, law as a tool of an interpretation in order to set a scope of violation in case of international disputes, and it further helps decide the legality of actions and whether these are truly based on law, and plus the extraterritorial aspect of convention application is at play as well. So we are just looking at international courts, so ECHR, so it relies on the convention. So therefore, ECHR will just establish that there's violations of other material rights or non-material rights. So it would rely on the convention, but if it is a dispute between the states, so then it should you know, use a different approach. For example, when an individual complaint is received by addressing some issues of relationships between the states, so ECHR would realize that it's more of an interstate complaint, even if the person seeks to find or attain its property that is based abroad. In any way, for a court, it is important to establish who is de facto controlling the territory in question. That goes down to the jurisdiction. So finding. And so there's another point that is important, and it's not very well covered in the literature. And the point this is following. So this the state that defines its jurisdiction just tries and employs some methods to restore this jurisdiction. And one of the methods would be filing a claim with the court. So this is therefore, so we see that the ECHR could also be used by some of the countries in order to um, ex- extend the scope of their jurisdiction. And there are other international courts, for example, International Criminal Court, like UN Court. So these some actions can be sought through those courts, but not all of the countries ratified those international courts, so they cannot apply until they're ratified. Next, these are cases involving military crimes and also occupation, whether it can be applicable. So there's one case, Marcos versus Croatia. It was amnesty for military crimes and for war crimes that was not acceptable. So the court referred to international humanitarian law and also provisions that regulate the operations of Red Cross and the Inter-American Court for Human Rights, as well as the jurisdiction of other international courts. Vintry case, so that was Article 47 of Red Cross on the prohibition of any attack on peaceful population. So these are just some selected judgments of the European Court of Human Rights that demonstrate how these decisions can be interpreted in finding violation against human rights, but at the same time, ECHR will make its contribution to the resolution of international disputes. And this mission is very important. It is under examined, and it should be further studied. Now, also, I would like to add a couple of remarks regarding this threefold nature. That it's Jeffrey Donovan and Mark Poland. So they have embarked on a very intensive judicial investigation, and the American Journal International Law of Cambridge University published this paper in September 17, and the article is entitled Judicial Dilemma. So the dilemma that they raised was as follows: what was the purposes of the international community in terms of setting up an international court? So they see that it is like pursuing these three goals. So obviously the state want to set up an independent judicial body that would be uh, capable of resolving authoritatively the disputes. Then the states would like to see that the audience, the people as such, would have a good understanding of adjudication process, and court also providing safeguards of transparency and openness of judicial proceedings. Thirdly, so the state authorities would like to have some influence on the judicial authorities in order to provide for their responsibility to a certain extent. So therefore, an international court should be responsible for their own decisions. Hence, the international community should have some control and review of it. And this goes to the three principles: the accountability, the transparency, and independency. So independency and transparency are very high standards, but accountability is something that we need to work on. And so this situation is far from being ideal, and there are mixed views on this point. So we can either agree or disagree with them, but still, so we know that this paper is very, very authoritative, and many authors would be making reference to in their articles. So thank you for
Спасибо большое,
listening.
Ханар Рашадович. Вы
Thank you
подняли
very
очень много
much. In
глубоких
fact, you
вопросов,
raised
каждый из которых
many,
заслуживает отдельного, очень
so
обширного
you raised
обсуждения. И
many
отношений
important
различных
issues. So these
областей
are
международного
in-depth
права, международного права прав человека и
points,
гуманитарного
so
права,
that come
общего
from
публичного права
international
и
law, so public
Конвенции
law,
о защите
international
прав человека
humanitarian law,
и,
European
конечно же, о
Convention on
роли и
Protection of
функциях
Human Rights,
Европейского суда и
and
всех
also on the
международных
role and
судов и
function of
соотношение
the
этих функций в
European Court of
деятельности.
Human Rights and
Действительно, вопрос,
other
который очень мало
international
изучен, потому что
courts, and
обычно
all these
фокус на
functions and
одной
all these points, I mean, are
из
really
этих функций, на одной из главных этих функций.
understudied.
Уважаемые
So,
коллеги,
and
вопросы Ханару
dear
Рашадовичу,
colleagues, do
вопросы,
you have
комментарии
any questions
по тому, что было сказано?
for our colleague Mr.
Мгм.
Gajiv?
Да, ну
Any
я так понимаю,
comments?
что многое, видимо,
Um,
осмысливается, потому что
I believe
действительно
that you
много
are still
вопросов,
thinking
которые
about it,
зреют
because
внутри и
so this
ждут,
has been a
видимо,
very
своей формулировки.
in-depth
Я вижу,
presentation.
что у нас
Probably
появился
some
Михаил Львович
questions
Гальперин. Михаил
will
Львович, здесь ли вы?
be
И
asked
да,
at a
вижу,
later
да,
stage.
доброе
So,
утро.
and as far as I can tell,
Тогда, уважаемые
Mr.
коллеги,
Galperin has joined
сейчас
us now.
предоставим слово Михаилу
So,
Львовичу.
and now
Итак,
we
Михаил
would
Львович
like
Гальперин,
to give the floor
доктор
to
юридических
Mr.
наук,
Mikhail Galperin, so
уполномоченный
Doctor of
Российской
Law
Федерации при
and
Европейском суде по правам
representative of the Russian
человека,
Federation
профессор
at the European
НИУ
Court of
Шире
Human
с
Rights. He's a
темой примирительной
professor of
процедуры ЕСТЧ
international law,
«Российский взгляд». Пожалуйста,
and
Михаил Львович.
he will be delivering reconciliation procedures at
Dear
ECH,
colleagues,
Russian perspective.
my
Dear colleagues, I'm
I'm very glad
truly
to see all of you here.
delighted to welcome you
Uh,
all,
I'm so
and
glad
it's a
to
great
be with you here in
pleasure
this conference today
for me to
because
deliver
it
this
was
report during this conference.
organized
So, and
by two
this
departments.
the themes
The
that we are talking
department where I have been
about
working
are
for the
in the
past 10
focus of
years and the
attention
other
of the
department
departments,
where I work
the
together with
department
Maria,
that I've
the
been
Department
working
for International
for
Law.
the last 10
And
years, and
clearly,
is
these
the national
questions are very
department.
important
So I'm
from the point of
also a
view of my
member of the
work at the
Ministry
Ministry of
of
Justice as the
Justice,
Human
and
Rights
I'm a
Ombudsman.
representative of the Russian Federation, European Court of Human Rights.
Now, I have
Therefore,
to say very briefly
this
about the conciliation
topics are of
procedures
great importance and
uh,
significance to
using
me.
the
So we'll be
European Human
talking
Rights
about
Court as an
reconciliation
example. I know that my
procedures at
colleagues from the European
ECHR.
Court
So
and
I
my
know
colleagues from
that
other countries will be talking
this
about this today.
topic will be touched upon
Well,
by
quite
our colleagues
clearly
from
that from the
ECHR and
pragmatic point
Strasbourg
of
Court
view,
as well. Right,
that
so
the
let's look at
government,
reconciliation
the
procedures. So if we
applicant
look at the
and the
role of the state as an applicant, probably
defendant
it's more
would find it
beneficial
better
for the
to
states
reach
to
an amicable agreement because the
strike a
applicant would not
settlement in
spend too
case,
much time
because in
on
that
all
situation the
the
applicant will
paperwork
not
wouldn't
have
have
to
to wait for
waste time for the
years
exchange
for
of
the
procedural
decision of the
documents,
court for human rights.
waiting
On
for
the
a
other hand,
judgment to be
the
delivered by
government, the
ACHR.
state,
And on the other hand, for the
should find it
state, it would be
better
beneficial
to
as
reach
well
amicable
to strike
agreements
amicable
with the
settlements before
Human Rights Court, because,
ECHR
firstly,
for several reasons. So
statistics
this will
improve,
improve the
uh,
current statistics
fewer
for
cases are
case
submitted to the
resolution
Human
at
Rights Court,
ECHR.
and I always keep
And in the
telling my colleagues
Ministry
at the
of
Ministry of
Finance,
Finance
I'm also
when I ask them for additional
every year I
funding
would
every
be
year
asking to
for
increase our
payments based on
budgets
the decisions of the
due
Human Rights
to
Court. I keep
ECHR
telling
judgments.
that it's the
So, and
money
I'm
that
always
our own
saying that these are
citizens
the money
receive.
that
It's our citizens that
received,
have
that will be
suffered from human
received
rights
by
violations.
Russian citizens. So the
So therefore,
citizens
they're
that
entitled
have
to
suffered
get
from
these payments quickly,
violations of their
effectively, and their
rights. So they
rights
have
be
every
restored.
right to receive their
I think
compensation
that what is
promptly
especially important,
and
what
to
we need to
have
think
their
about
rights
in terms of the
repressed to the
doctrines
fullest extent.
is the reaching of
So
amicable agreements between
amicable settlement,
states,
especially
considering that,
important in this dispute
unfortunately
between
rather
the
than luckily,
states, and
the number
now we've
of
seen an
such cases has
increasing
been
number
growing
of
at the Human
those
Rights Court. And quite
these
often,
types of
Russia
cases. So
i-
the
is the one who has
Russian
to answer under
Federation would
these
come as a
claims. And these
respondent
claims have
in
reached the
this
final
type
stage.
of cases. So
And
some of those
the
cases
court
at
has
their
already issued
final
the
stage
decision
of
on some of the
adjudication.
courts.
So
For
that's
instance, the
Georgia
Georgia 2.
2 case, and
And the
on
court
the
has already
21st
ruled that on January the 21st,
January, so the Grand Chamber
the
of
Great
ECHR
Human
will deliver
Chamber
its
for the Human Rights
judgment
Court
on the
will issue its
developments in Yuzhny,
decision. It's
South
the case related
Ossetia,
to
and
South
Abkhazia
Ossetia and Abkhazia in
2008.
2008,
It
or
also had a
Ukraine
very
versus Russia, for instance.
array of cases
And new
brought by
cases related to
Ukraine against
the
Russia
cases in
due to
the Crimea
developments in
and
Donbass and other
Donbass, and the
regions.
new
And we have
case,
one new
the Netherlands
case
versus Russia,
brought
related to the
by
crashing
the
of the
Netherlands
Boeing in
against
southeast Ukraine in
Russia because
2014,
of the
2014, and other
aircraft
cases
bombing in
where
the
we
south
need to
of
think where
Ukraine.
how it could
So,
be
and
resolved other than
all other
through court resolution.
cases that can be so
The
discussed and
court knows
probably
of such
resolved
cases.
through
Case number one
settlement.
related to the
The,
completed France,
the first
Norway,
case was
Denmark, Norway
Switzerland,
versus Turkey.
Denmark, and France
It was
versus
submitted due to
the Netherlands
large-scale
and
human rights
versus Turkey.
violations
So that was
and
the very
mistreatment of
first example
the
of a
arrested and
settlement, and that
incarceration.
the case was brought after the
That was in
coup
2000.
d'etat in
That
1980,
it was done
and
back
that
with the
at that time there
mediation
was the
of the Human
European
Rights Commission,
Commission of Human Rights that
which
was the
preceded the
predecessor
Human Rights Court.
of
So the parties
ACHR. So under
reached
that commission, the
amicable
parties
agreement,
reached a
and Turkey
settlement agreement in
undertook
order
an
to
obligation to
remedy the
correct
situation,
the
and then
situation.
the Turkey
And
undertook an
Turkey
obligation to report to the Commission on the
submitted
measures
information
that would
about
be
the measures
taken for criminal
undertaken.
prosecution
Uh,
for
the,
those that were responsible
the
for the
curfew and other measures
situation
were then
and also
revoked. The
committed some
second
war
case was
crimes.
Denmark
So
versus Turkey.
Denmark versus
The
Turkey.
complaint was
That was the
submitted by a
second
citizen of
case,
Denmark.
summer
In 1996,
1996. So
he was
one
detained by the
a
Turkish
citizen
police,
of Denmark was
incarcerated,
detained
and
in Turkey, and
charged with
charges were brought against him
helping the
for
Turkish
supporting
Labour
the
Party.
opposition party.
And the
And
parties also
again,
reached an amicable agreement.
an amicable
And
settlement
the
was
applicant,
reached for the
the victim,
compensation
was paid a
to
compensation
victim. So the
without
compensation was
admission of
paid
guilt
and
on
no
the part of
violation was
individual. But
found, but
overall,
in
with admission of
general
the fact
it
that
was
the
admitted
Turkey
that
does
in Turkey there
have
are certain
some
instances
individual
of
cases of
torture. So
tortures,
the
and measures
decision
will be
was
undertaken
made to
to
try and
struggle against
prevent
this.
this torture
And
from
then the Human Rights Council
happening, and
will
this was made
teach
part of the
Turkish
training
policemen,
program for
and the government
police
of Denmark
officers.
undertook an
And then
obligation to
the Denmark
finance a
authorities
special
even
bilateral
undertook
project for
to
the training of Turkish
finance
policemen in the
this
sphere of
human
human rights.
rights project
We can
to
discuss
be
at length
implemented in Turkey. So,
about the
but
nature
if we
of the
look at
amicable
this very
agreement. The question
nature
is quite
of
interesting. But like I
amicable
said,
settlement,
no
then
matter
I'd
what
say
the
no
nature
matter what the
is,
nature
the
is,
pros, the advantages
so
of this
there are pros
institution
and
are
cons
quite
of
obvious.
amicable settlement, and these are um, clear
as regards the
to
Russian
those
experience,
investigating the issue.
I should admit
If we
that
look at it
the
from a
above
Russian
described institutes,
perspective,
the
then
institution of
this
amicable agreements
the
and this
institution of
quasi-amicable
amicable
agreement
settlement and also this
in the form of a
quasi
bilateral
form
declaration,
of
which we're going to discuss
unilateral
today, is also
declaration,
used to
another topic that is
settle
included in our
disputes.
program,
So
because
they're used quite
these
widely in
methods are
Russia.
widely
In
used.
2017, for instance,
So by our
there were
country as well, and
533
as
amicable settlements were
2017, that
reached, 409 in
500
2019,
so declarations were sent,
492
then
in 2019, and then
2018
three
more
quarters
than
2020,
400,
over
and
300
now
amicable
this
agreements and
year has seen more than
bilateral
300
declarations were submitted.
unilateral declaration on the
What
part of the
complaints are we
Russian
talking
Federation.
about?
So
Because
now let's
it's
look at the
already an
type of
established practice,
cases.
and there are certain
So there
approaches
are subtypes as well, so that
or,
we are
uh,
trying
that we're
identify
using
in order to develop
together with the court.
the
Well, firstly,
practice of
it's complaints
amicable
related
settlements.
to
So first type would be
violations of
detention
rights during
conditions or
incarceration. Last year, for
pre-trial
instance,
detention
in the previous years,
cases,
it
and
was
in the
probably the
previous so
main number of
year of
amicable agreements
in the
and
past year,
bilateral
that was
declarations.
the
But
majority
as you
of
know, my dear
claims
colleagues, last
brought
January a
against
new
the
law
Russian
was adopted
Federation. But
that
probably
was
you're
developed by the
aware that
Ministry
a
of
new
Justice,
law
and it was
has been
taken to force and
adopted
provides for a
that
compensation mechanisms
implemented
due to
national
violations of rights
mechanism
during
to
incarceration. And in
counter
this respect, the number of
improper
complaints
conditions of
were
detention.
these
So
complaints
this
were
all
relocated
these
to the national
claims
level. Basically, as
relating
regards
or
the cases
involving
where
some
the violations are
complaints
already over, where
about
the people are
detention
not in prison
conditions.
anymore,
So they are now
so
being dealt with at the
the order
national level,
for
especially for those persons that are
compensation
no
has
longer
changed.
detained. And then
The
we do
compensation
have
mechanism at
this
the national level now
mechanism of
works. Therefore,
compensation
the number of
in
amicable
effect
agreements
at
is
the
going to go
national level.
down at the end of
So
this.
I
And
believe
we
we'll
hope
see
that
some drop
at the
in
end,
this
we will
type of
see, like in the
cases.
other areas,
And similar to other mm,
but with respect
cases
to
that
the
involve
failure
also
to
some
comply with the
violation
court order on
of
time, all
the
these
terms for
cases will finally be
enforcement of court
transferred to the
decisions,
national
or
level,
some
and they will
delay
get
and
off the agenda of the
delays
European
in
Court.
delivery of
An
decisions. So I believe
Another
so those
set of
cases
complaints is
will
mistreatment during the
not
first hours
appear
after the detainment and
in
no
great numbers
investigation of such
before
facts.
ECHR.
Another new
However, we
area
have seen a new type
where
of
we have been extending the practice
cases
of amicable
that can
agreements
be
is complaints
concluded through settlement,
for sending
and
the
we are talking
accused to
about remote
remote prisons.
penal
It's the
settlements, so
prisons, the colonies which are
those
located
places that
far
are
away
far
from the
from the
place of residence
residence
of the
of
accused, his or her
offenders, of inmates,
relatives, and
and
therefore it's
because they are
the loss
far
of
from their
family ties.
relatives,
You
so
know,
they
colleagues,
don't
that
have
this April
proper
a new law was
communication
adopted
channels. And probably you
that
know
was
that
also
it
developed by
was
the
in
Ministry of
April
Justice
this
together
year
with
that
the
the Ministry
colleagues from the
of Justice,
committee
together with the
from
counterparts from the Federal
uh, the
Penitentiary
prisons.
Service, so that they
So the law
drafted the
provides that
legislation
people
to
should
ensure that the inmates serve their
serve their time
prison sentence
not far away from
in
their home,
areas that are
and
closer
there are
to
clear conditions
the
where a
place of
person
their
could be
residence, or probably in the neighboring
sent to a
regions.
prison which is located not in
And
the region of the residence of the
this is
accused.
the
So
type of
finally, this
complaints
category of
that we would like
complaints will also get off
mm,
the agenda of the European
to
Court.
retain within the
So
national
these
jurisdictions,
rights will
that we
not be
would
violated.
like
But
to see
I'm
will
not
be
going to disclose
reduced
a
in
big
numbers
secret that
before ECHR.
no matter what we
And
discuss with
still
my
we
colleagues from the
held
European Court,
meetings with the ECHR. We talked to the secretariat,
when we have
and
our
when
working
during
meetings,
our
when
working
I
meetings,
go
so
to
when I
Strasbourg, when my
personally
colleagues
visit
come there,
Strasbourg, when colleagues
that there's
come
always
to
a
visit
dilemma.
it, so there's sort of a
We need to
dilemma,
find
because
a
we can
balance of
see
rights.
this
On one hand, there's
unexpected
a right
balance of
for
rights. So
proper
the right to
treatment during
decent
incarceration, or
detention,
the right
penitentiary
to
conditions, or
stay
the right
in the
to serve your sentence
geographical
in
area
your area of
where you
residence.
reside. Our
So,
country is
and
big, new
this
prisons
may
are built in
be a bit
various
conflicting,
regions,
because
so it is
we
difficult
have
to
a
plan
vast territory, and
where there are
it's
more people who have committed the
like
crime
guess.
and will be
So because we
therefore
need to see what
tried and
there is
accused.
more
And quite
populated with
often
prisoners, so
we see
inmates, and
that
where to set
colonies in the
up
center
this penal
are
settlements, because if we
are
look at
full.
certain
And the
areas
question there
in the central
arises
part,
about
there's penal institutions
observation,
will
for
be
instance, the residence
overpopulated,
area per
and there
one
will be
accused person. On
issues
the other hand,
with
colonies
the
in the Far
square
East or in
meters per one
Siberia
inmate, and at the
remain
same time we'll
half
see
empty.
some penal institutions in
So it's a logistics
Siberia
issue
and the
in a way.
Urals, so they will
Clearly,
be
the
less
government has to
populated
solve these
and
issues.
even
On the other hand,
half habitated. And I
it
believe
takes
we need
time
time to address all of these issues and
to
to
build
try
new
and
colonies
build new
which
penal
would comply with the high
institutions, I mean, in
requirements of the
line
European
with all European
court,
standards,
the high
and
requirements to
also
the
it will
entities
be
of the federation
located
where there's
in
a
the
great number of
areas where
residents.
many
Therefore, some
people
people have been
have
convicted
been convicted with
to incarceration.
prison sentences.
One other
And
categories
we could
where the Russian Federation
refer to
doesn't
other
insist
types of
to
cases that shouldn't be
consider
brought on
complaints.
the merits
For instance,
hearings before
ensuring
ECHR.
attendance
So this
of
could
the
include
convicted person
complaints
in the
and
court proceedings,
civil cases
or
such as involving
illegal
a court
incarceration
hearing, then
without
pre-trial
any
detention that runs
justified
over a
reasons.
longer period of time without
Luckily,
any good
this
reasons for it.
class of
So,
cases
and
has been
again, so
leaving the
we
agenda of
see
the
that
Human Rights Court more and
these
more.
cases
And
are
very
not
few
brought in
cases
great
of
numbers to ECHR.
extend
And plus
lengthy
this
court
final
proceedings.
category, so the protraction and enforcement of judgments that
Usually, the
have been
European
delivered against the
Court for
state.
Human Rights, and we should admit,
So if we look
adopts
at the position
proposals
of
of Russian authorities
ECHR,
on
then
one side of
ECHR will be accepting these
a regulation of such
applications for
cases. I
unilateral
will be quite
declarations
frank.
from the Russian
Probably we
Federation.
don't see
So I'll
understanding on
be
one class of
upfront,
cases.
and that in
It's
that way
complaints for
misunderstanding
ineffective investigation
in the
uh,
type of
due
cases
to
that
in case of
involves
homicide.
the
My
deprivation
colleagues
of
understand what
life,
I'm talking
in
about.
the
It's first of
cases
all
that
cases related
don't,
to
do not involve the
counter-terrorist
state.
operations
So I'm
in the
referring
Chechen
to
Republic
these
and overall in the Nordic
counter-terrorist
Caucasus.
operations in the Republic of Chechnya,
There are
in
cases when
Northern
people
Caucasus,
disappeared,
when
people were
so
killed,
some
but
people
but
disappear,
there's
they
no
get
direct relations
killed,
to the
but no
agents of the state.
direct
Therefore,
connection is
these
established
cases
with
have
public
existed for a long time. We have
agents.
cases that
So
have
some cases
that
date
began in
back to
2002,
2002 and
2003, 2004. So it's
2003,
quite clear that
2004,
not only in
so
terms
from
of the
the
Russian criminal
Russian
investigation
criminal
law and
procedure law,
according to
and even from
standards,
some
investigation
standard
standards, it is impossible to
statute of
identify
limitations
the
over
person involved
it
and
is
to get all the necessary
impossible to
evidence.
find the truth and to
Still,
find
the European
those that
Human
are
Rights Court
responsible for those
refuses to
crimes.
close these
But at
cases
the same
and
time,
demands
the
that a new effective
ECHR just
investigation be
doesn't
carried
want to
out.
accept unilateral declaration for these
Well,
type of
here,
cases, and they insist that
like I
fact-finding
said,
finding
it is
missions should
impossible
be
for obvious reasons.
properly
I can also say
conducted.
that
But I already
this
explained that for
a
a number of
renewal of
objective
investigation,
reasons, the
and we can see this
fact-finding mission is
in the practice of
impossible.
Supreme
So
Court, for
even
instance,
in the jurisprudence of the
we can
Supreme
see that
Court of the Russian Federation, we
individuals,
sometimes see that with,
when we're discussing,
the
talking about
victims and
relatives,
the
many of them clearly
relatives, right, would lie.
want
They're seeking the
to
truth and they're
identify
waiting for the
who
decision. They
killed their
want to find
relatives.
those people that are
But in many cases,
responsible for the death
people
of their relatives. But
go on living,
uh,
15 years have passed,
15
and
years
basically
have
they have
elapsed, and some of
to
these
become
people
the
have
aggrieved
already
party
adapted to
again,
their
the
new
victim again. They
life.
have
And
to
now, so when we
be
bring
involved
back
in
this
investigation again
fact-finding
15
mission, they
years
have to
later.
uh,
This makes them
take
go
on the
back to the
role of the
situation where
victims, and
which they
this
have
will
already
bring
survived
them back
this
to
situation
the
of a
past
trauma that
trauma, to that
ended 15
very
years ago. So this is also another aspect
traumatized
which we should
experience that
not
they lived through
ignore,
this
I believe.
15 years ago. And this is yet
And we see here that
one
in
of the
other
aspects
countries,
that we
in
need to
similar cases, for
consider.
instance,
So, by the way, if we look
the
at
European Court does not
other
consider
countries,
such
Poland, for
complaints.
example, we see
Well, we
that
hope that,
ECHR would
and I
be
live with this hope,
accepting unilateral
as the Ombudsman of the Human Rights Court,
declarations from Poland. So,
that
in
in various
respect of
problem
this
areas,
type of
including these
cases,
problems
so
areas, we will still
this is one of
find
the
an
problematic
understanding, we'll find a compromise with the
issues in
Human Rights
our
Court in
interaction with the
Europe.
European Court of
This will
Human
help to
Rights,
improve the
and I do
work of the
hope
Secretariat
we'll be
of the
able
Human
to
Rights Court
resolve it.
and to
We'll be
take
able
some of
to
the burden
optimize
off
our
the Human Rights Court
interaction, and we'll be
and
able
to
to
look at
also
the
to
complaints which
reduce the
still await
caseload
their resolution.
before the court,
So,
and probably
to
to
finalize my
refocus
speech, I would like
towards
to say
more
what
pending
outlets we
cases.
see for the
So there
development
are
of this
certain
institution.
aspects that
we
we
have been
could
working
describe
on the
for the
draft of
development
the
of this institution,
presidential
because
decree,
currently we are drafting the presidential decree
which will
to
adjust the
vest the
regulation on the ombudsman.
plenipotentiaries
And the ombudsman
with
will also
this
be
amicable
able to
settlement, even
reach
at the
amicable settlements
stage
during
of
the stage where
enforcement,
the
when
resolution
the
is already
Committee of
enforced. There's a
Ministers,
great number of cases
because
that
many
reach court, then
cases
they
that go through the court will then reach
are
the
under the supervision of the
ministerial
Council of
committee.
Ministers, and we see
And
similar situations.
again, these are the
There's an
same
effective
situations
investigation,
that
etc., etc.
we
The
face,
same
including
applies
this effective investigation
to the legal status
that
of
is
individuals.
missing, and probably
For
sometimes
instance, it is
investigation is
impossible after
impossible,
years have
again
passed,
because of the
or it is
lapse
impossible
of
due to
time
the
or some
Russian
provisions in
law.
Russian
In this case, we
legislation.
will also see
So we take
opportunities
this type
for
of cases, probably we
applicants
can
to be able
provide
to
more, we can provide some
receive a monetary
financial
compensation.
compensation to the application, so they can receive it in an
We discussed this.
individual way. I
The
mean, at
Council of
the
Europe
level of the Committee
contains
of
this idea. We
Ministers,
discussed
this
it with
has
the
been
General Secretary of
discussed with the
Europe last
Secretary General and
October,
with
and she
the
fully
European Union. We
supported
believe
this
that,
idea. And we have
so
done year
this idea was
2021, this
upheld by
new
the
mechanism will be
European Commission,
established
and we
and will
believe that
expand the
next year
ability
we'll
to
be able
use
to
amicable
set up
settlement
this mechanism
conciliation
up and
procedures
running,
as part
and
of the
it will
European
help
mechanism,
also
and it will give us a
extend
new
the
impetus
practice
to
of
ensure
enforcement of
protection of human rights.
ECHR judgments
Thank
and
you very
provide us
much.
with a new
Спасибо
impetus
большое, Михаил
to better
Львович.
Thank you,
Напомню,
protect
что
Mikhail.
вам нужно
human
I
rights.
believe,
50
I remember that you need
Thank you
to
very much
перейти.
for
go
Я не
listening.
at
могу не
Thank
задать
you
2:50,
very
вопрос
much for your
but I
presentation.
think I'm
относительно
But
obliged
I
to ask
have a
a
question
заключения и
question
исполнения особенно
about
гражданских
to
отношений
ask
по российским
as
делам.
how
to
Понятно, что у нас будет
amicable
amicable
settlements
обсуждение,
are
settlement.
планируется
reached
And I
and
know that
законодательное
concluded.
Nikita
исполнение по
Kalamis, I
российской
mean, will be
So,
специфике.
covering
Понятно, что
enforcement
looking
если
at the
мировое
aspects.
Russian
соглашение
practice,
касается
Right, but
clearly,
допустим,
if an
from the
amicable
Russian
компенсации,
settlement is
это
about
perspective, the
однозначно
compensation,
amicable
касается.
settlement
Но
this
ведь
is
about
бывают и мировые
simple
соглашения,
situation. But
которые
there are
compensation and
предусматривают
settlements
совершенно
financial
иные
which provide
вещи.
compensation.
for
And
other
it's
acts.
Например,
quite
For
easy
замедление
to
меры
instance,
do, but
пресечения,
if we're
например,
talking about, for example, some
changing
actions such as
какие-то
detention
процессуальные
to
изменения
another
в
measure
гражданском
or
measures
деле.
or
other
С точки зрения
procedural
actions
российского
in
measures,
civil
законодательства,
cases.
как
civil
можно
In the
исполнить
procedural
Russian
мировые
law,
aspects.
соглашения?
how
I mean,
Социальный
from
such
the
кодекс не
settlements can be
Russian
enforced?
предусматривает,
Because
legislation, I
например,
the
mean,
такого
what is the
основания
way
procedure
in
пересмотреть
code
which
does
судебные
this
not
can
provide
преступления
be,
for any
или
reasons
принять иных
to
процессуальных
revise
this,
such
решений.
this
court resolutions.
question can be addressed
Yes,
if
this is a very good
legislation does not
question.
provide for any
Indeed,
judicial
we
review
see
of the
cases
measures it
that
previously imposed. Yes, that's
we
correct.
can
Just
pay
the
money,
compensation and money. I mean, that's the
monetary compensation.
financial aspect that
We need
is
to think
feasible
about it.
at the moment, and we need to
Overall,
think about it. And just the representative
the
of the
authority
Russian
of the
Federation
ombudsman
at the
at the Human
European
Rights
Court of
Court,
Human Rights, it should have that role and function.
well,
I
the
mean, on
authority
how
is
to
to organize
organize
for the
the
enforcement of the
enforcement of
resolution. And the
ECHR
authority
judgment,
is
and this is the
described
very
in the
power
resolution,
that has
in
been
the decree of the
enshrined in
president.
legislation by the president's decree. So I
But
believe
there are
that we
not
should, the
enough
scope
authorities for other
of this
agents
power,
of
that the
such a
scope of the
process.
representative
So it is
function
a good
should be
idea to raise
also
this issue,
broadened
to look at how
in
the
order to see
law
how
can
can we
regulate this.
Большое
better
спасибо, Михаил Львович.
regulate
Thank you very much,
this
Коллеги, у
Mikhail.
кого-то есть
So,
еще
colleagues,
legislatively.
has
экспресс-вопросы
anybody
к
else
So,
Михаилу
has
Львовичу,
dear
которые
colleagues,
могут
got
thank you
any
very much
quick
because
questions?
Mr.
Because Mikhail
Bogdanov
has to
has to
go
leave. So,
to
if you have
another
any
to attend
further
another
Нет.
meeting.
brief
No?
questions,
Да.
so
Ну, у
you
меня на самом деле вопросов
Right.
много,
are
но я не
invited
I
смею
have
to
вас
lots of
ask them.
задерживать.
So,
questions,
I
but
Спасибо
have
I
большое,
many
что
questions, but
вырвались
think
I
you
will
have
not
to
be
go. Thank you very
taking
much.
much of your
I
time.
hope
I
you
ask you
ask
because you
the
can
questions later on.
communicate with me
Большое спасибо, Михаил
later,
Львович.
and
Thank
thank
you,
you very
Mikhail. Thank you
much.
very much.
So,
Уважаемые коллеги, мы
dear
Dear
colleagues,
colleagues,
we
продолжаем
would
we
like
наш
to
continue
разговор,
continue
нашу беседу,
our
и у нас
conversation.
сегодня, к
conversation.
сожалению,
So,
группа
Unfortunately,
unfortunately,
очень
and
a
два
very
очень важных и
two
интересных
very
there's some
important
доклада
speakers
important
are not be able to
topics, and
attend.
о мерах
unfortunately, so
дружественного
we
They
урегулирования
want
в
to discuss
Европейском суде
amicable
по правам
settlements in the
schedule
человека
two
European
и
topics
Court
о
on
for Human
применении
Rights
amicable
односторонних
and the
settlement and
деклараций
application of
ECHR
ЕСЧ.
and the
unilateral
unilateral
declarations
И
declaration
я бы
of
здесь
the
тогда
before
хотела еще
ECHR.
the
общий,
European
So I would
Court
like
of
так
to
Human
сказать,
Rights.
общий
So these are the
give
two
you
контекст
topics
того,
would
как эти меры
the overall
more
применяются.
context
Понятно,
of
что это
how
для
vividly
вас
these
before
measures
the
известно,
are
но вдруг
audience.
кто-то из коллег не
I
used.
can
знаком с
summarize
общим
Maybe
probably
some of the
контекстом.
provide
content
you with
know
this
the overall
general
В
context.
последние
context.
2 года
The
Европейский
And
past
суд по
over the
years,
правам
past
the
2
человека
years,
ECHR
the
применяет
European
actively
Court
достаточно
using
of
экспериментальную
Human
процедуру,
Rights
quite experimental procedure,
been
which is called accelerated communication.
applied this
They began
pilot
using it in
procedure
2019.
that is called
And this year,
streamlined, fast
2020,
track,
the
fast track
ECHR
communication.
decided whether to
So
continue
it's
using it.
so the decision will be
Nikita will
taken
tell us
to
in greater detail about the
proceed with this
outputs.
practice or not. So
As part of
Nikita,
this
I think,
accelerated
will
communication,
touch
the
upon
idea of this procedure is that the parties
topic of greater settlement. So
get
when
an
we
opportunity
look
first
at fast-track
to try
communication,
and
the
regulate
idea is to try and
dispute in a
settle
friendly way,
the
amicable way.
dispute
And then,
before,
if this agreement is not reached,
before bringing it before
court proceeds
ECHR. So if the
to
parties fail
consider
to
the
settle,
case
then the case
in the
will be
red.
heard on the merits, and
Questions are asked,
then the
which the
exchange
state
of
answers, and
observations
then
will
all goes
start,
along
and
with
this will
the
be
usual
followed by a
way.
very classical procedure that has
So
been established by the
basically,
European
this
Court
procedure
of Human
of
Rights.
accelerated
So
communication
this
and amicable
so-called
settlement
fast
as
track
part
communication
of the
and
usually
amicable settlement as
usual
part of the
communication mechanisms
communication
raises a number of issues.
procedure at large,
In particular, with
raises
respect to
certain
what
points as
the
to
parties can reach,
what actions can be
what would be the
performed
actions
by
that
the
this
parties as
amicable
part
settlement.
amicable settlement, and
So
uh,
usually it's
that
about
has
monetary
been
compensation, but we
mentioned that
understand that not
we
always
can
this is the
be
aim
realistic,
of the
and
applicant
it's
when
more about
people apply to the ECHR.
compensation, and
Quite often this is
it
not
is
the
not
measure which
necessarily the
can
measure
correct
that
the violation
will
or at
help
least
us to
compensate
compensate
for
for
its consequences.
violation or probably
That's
to
one.
satisfy the
Two,
party concerned.
that many
And
applicants also
secondly,
find it important
for many
to
applicants, it is also important that the
find important that
court,
the
the European Court
ECHR
of Human Rights,
states
finds the
that
fact
the
of
violation has taken
violation.
place.
So in that
So therefore,
perspective, if there is
amicable settlement,
settlement, so
friendly agreements
probably it may just,
people are afraid that their
neglect
moral aims,
this
their moral
moral
satisfaction
goal
would be
that is
nullified
being pursued by
because
the
amicable
applicants
settlements
in
are not published, as far as I know.
referring
Therefore,
their
there's
cases
no
to
such
ECHR, because amicable
publicity
settlements
with
are not
respect to the
published, they
consequences,
don't
the
create
outcomes of such an
any
investigation. And finally, as we
publicity.
have
So,
said,
and
amicable settlements are reached in accordance with the
finally,
established
amicable settlements will
classes
be
of cases
reached
where
for
there's established
very
practice of the
specific
court.
types of cases that are
These
well
are very well
trained
established
in
categories of cases
the
where the court has
ECHR
already
jurisprudence, where the
established that
court
there's
has
structurally
already
systemic
identified
problem.
some structural or
Overall, this
systemic
practice does not
problems.
apply
So
to
this
categories where
jurisprudence doesn't
there's a
cover
number
other
of
types of
court rulings,
cases
but
that
it
have
does not
many
have
judgments, but they're
the
not
status of
that
a
well
very well
trained
established.
in the
Therefore,
jurisprudence.
here,
So,
friendly settlements
therefore, we see that
face some
sometimes it is
problems. In such
difficult
cases,
to seek
the
an
16
amicable
weeks which
settlement,
are
because
given to the
usually it is
parties for a
16
friendly, for
weeks
amicable settlement,
during which the
are
parties
to
amicable
the usual
settlement.
time
So
it
additional
takes
16
to wait at
weeks
the European
are
Court. In
added
cases like this,
to the period of
for the
ratification.
applicant,
That means
the
that
time
the applicant will have
is
to
extended
wait
for
for
another
another
4 months
4
at least.
months
So
minimum
this can be
before
also a
he
problem.
gets
So
the
delineation
judgment
between
European
categories where the
Court of
government
Human Rights. And again,
with some probability
this
would
is
reach amicable
yet
settlement,
another
then
type
it
of
makes
cases, for
sense. And there
example,
are
for which
categories
the
where,
state will be
again,
willing to
we
settle.
see
And we
governments
know that
don't
there are other types
concede
of
to such
cases where
settlements. And in
the
these
state
cases,
is not
this means that the
ready
applicant
to settle, and if the state
extension
is not
of
ready to
the
settle, then
usual
the
time it
applicant will
takes to
have
the
to face a
European
longer
Court.
term
So,
of adjudication before the ECHR.
alongside with clear
So
advantages
looking
related to
in
the
terms of
the
time
time
periods,
where the
so settlement
agreement
is
is reached,
beneficial because if
we
it
should
is
also
reached, then
understand
that
that quite
reduces
often the
the
amount
period
paid under
of
such settlement is
adjudication, but at the same time, if we
lower
look
than
at
the discounted
this from the
amounts
financial
that are usually
perspective,
ruled by
then
the
the amount that
ECHR
the
in
applicant
its
receive
release.
is less than
But
the
still,
amount that can
there's a
be
lot of advantages with the
set by
ECHR. But like I said, there are
ECHR
questions
in
related
the
to the
judgment.
outlooks
But
of
still,
this
there are
regulation in more
prospects of
complex
using these
cases.
mechanisms, and probably
And the
they are
issue to related to
less
the
bright in
publicity
complex
of admission of the guilt
cases,
for those
yet
who find it
this
important. In my opinion, the
aspect of the case
issue
being high
remains,
profile because the applicants want the public
and
to know about the case.
this issue will
Probably
be
this will
solved,
not be
or
achieved
at
through
least we will
this
see
mechanism
answers
of
in the practice of
settlement. Probably the
ECHR.
ECHR
Dear colleagues,
jurisprudence will
maybe somebody would like to
find
say
some
something, would
way,
like to comment
again,
on
to
ask a
make this
question
kind of case
before we
known
proceed
to
to
the
the next
public.
speaker.
So, do you have any
Then it is
remarks
such a
or
pleasure for me to give floor
questions?
to Nikita Kolomiets,
Not for the moment. So
uh,
I then would
from
like
the
to give
Department
the
of the
floor to
Enforcement of Council
Nikita
Ministers.
Kolomiets, lawyer of the Department of Execution Council of Ministers,
Council of Europe.
and
He'll
his
speak about using of inflation
topic would be enforcement of
practical
settlement
and
agreements
theoretical
between
aspects.
applicants and states.
I'm sorry, enforcement of
Theoretical
amicable
and
settlements,
practical
theory and practice.
issues.
Thank you very much. Good morning. First of all, I would like to thank the organizers, and Maria. I think this conference is very important. I agree that cancellation procedures have a great future. Can you see my presentation, please? So my topic is enforcement of amicable settlements between the government and the applicants in the after realization of the human court. And furthermore, to continue what Mikhail has discussed, I would like to point out that amicable settlements are one of the ways to transfer the resolution of the problem to the national level, alongside with effective measures of protection at the national level. So this is what Mikhail discussed. For instance, incarceration conditions. Previously, there were lots of amicable settlements reached, or a law compensation was passed a short time ago. So this issue was really transferred to the national level. This is very good. This is the way it should be. In this way, amicable settlements already played a role. The same apply to issues in other aspects. Starting from year 2012, we've had quite an effective means of protection at the national level. So lots of amicable settlements are not reached in the European Court anymore. Same practical applies to cases from the so-called Polyakov group, which relates to cases when the accused persons are sent to remote regions to serve their time. So these amicable settlements would also play their function in this way. Or Mikhail Galberin has mentioned cases related to counter-terrorist operations in the Northern Caucasus. Here, as the Council of Ministers believes, there's also a good outlook to transfer this problem to the national level. The Council of Ministers of the European Union has offered the Russian authority for a long time to establish a single humanitarian body that would deal with not with the investigation of concrete cases, the investigation of violation of Article 3 of the Convention, but rather with looking for the dead bodies of the people killed. So this would be a good beginning, a very effective beginning, both from the point of view of the local population and the international community. That would be a great step forward. This does not imply investigation of the crimes committed yet. So establishment of a single body for such cases could, to a certain extent, transfer the questions, these complex questions to the national level. Whether such an amicable agreement is useful, the Council of Ministers of the European Union has underscored this on many occasions, and it even passed a special resolution in the past where the Council of Ministers noted how important it was to continue investigation, to reach amicable agreements wherever possible. And they underscored that if such an agreement is reached, then proper enforcement should also be guaranteed. The Council of Ministers also underscored that although the amicable settlement is for the parties to decide, still it can become a means to make the work of the court easier, and also to reach a satisfactory resolution for both parties. After this resolution, Protocol 14 was developed, that came into force in 2010. It strengthened the role of amicable settlements, and it said very clearly that settlements would be then transferred to the Council of Ministers for enforcement. As a result, the rail settlements became stronger. They became not only a means to take the case off the agenda of the European Court, but also a res judicata, a case that has been considered, which is now mandatory for the parties, becomes chose jurisdiction. The court places a greater role on amicable settlements, as Marina has mentioned. Starting from the year 2019, the period for where the parties had to try and reach a friendly settlement was extended. Previously, everything was mixed. 16 weeks were allocated to the parties to explain the idea of the case and to reach an agreement, and now the first 12 weeks are allocated to settle the case through amicable settlements. But my task today is to focus not on the case of consideration of the case in the European Court, but on the subsequent case after the case was considered by the European Court. And here the key role falls on the Council of Ministers. At the moment, after Protocol 14, this is directly mentioned in the Convention. Basically, the procedure is very similar to what was previously when the enforcement of the resolutions. There's no greater difference between the enforcement of both types of resolutions. So I'll remind you of main points so that not to spend too much time. Overall, enforcement of amicable settlements, like enforcement of resolutions, is that states have collective liability. So there's a council of representatives of the states that decides to what extent a particular country has carried out or not carried out such a resolution. So they're liable in a collective way. And the Council of Ministers resolves lots of current issues, very important issues of the operation of the Council of Europe, such as the budget, personnel, working methods. To a certain extent, the work of the European Court for Human Rights uh, as well. They meet every week, but at least 4 times a week. The Council of Ministers meets to discuss the enforcement questions. As regards the methods of work and methods of supervision, I can mention that there are standard procedure for most cases that are then submitted to enforcement, and the enforced procedure applies to the cases where there are problems, such as cases where there's a pilot resolution, etc., etc. And maybe last but not least, is that discontinuation of supervision over enforcement of the amicable settlements and resolutions of the European Court can only take place where all the necessary measures of individual measures and collective measures have been taken. The Council of Ministers, after its political resolution, has pointed out quite often that it was necessary to use amicable settlements. For instance, I'll mention just a few cases. Kunish versus Bosnia and Herzegovina regards failure to enforce a number of resolutions by Bosnian courts. And the Council of Ministers said that the court identified the cases of violation and demanded that Bosnia and Herzegovina undertake reasonable and adequate measures to enforce execution of to enforce such resolutions. Or Rezmevesh and Bragdarin versus Romania. This was about mistreatment during incarceration. The Council of Ministers also underscored that during the consultation phase, the governments have to reach more amicable settlements using bilateral declaration. Or Yuri Nikolaev and Javner Group versus Ukraine. this regards the failure to enforce resolutions by European courts, and the Council ministers urged the country to comply. And while these reforms are undertaken, unilateral declarations should be used. Against this background, the Russian cases look very well, because let's say one of the greatest group, the Kalashnikov group versus Russia. The Council of Ministers did not mention anything about the amicable settlement type because it was not necessary. Russian government, the Ombudsman office, have been working quite actively in this respect. And as Mikhail Galperin has already mentioned, in this class of cases, several hundreds of amicable settlements were reached. Just to give an idea of how many settlements were reached and how many complaints were submitted, I'll give you an idea. In 2017, around the European Court uh, uh, stopped considering more than 500 complaints, and no amicable settlements were reached on more than 1,000 complaints, which means that one-third of all the cases in this category over some period of time were taken off the agenda of the ECHR because an amicable settlement was used, which means a very good result of the Ombudsman's office. Lots of problems were taken off the agenda, so we didn't see several hundreds of resolutions against the Russian Federation because this work was carried out to reach amicable settlements. As we already mentioned, uh, uh, the Council of Ministers, according to our internal statistics, received around 350 amicable settlements, and most of them have already been closed down. If memory serves, only 100 are still considered. We should bear in mind here that in many cases, one agreement is reached on several cases. So 350 settlements can mean several hundred or maybe several thousand applicants. So we need to look at the statistics in detail to understand how many applicants are behind these settlements. And actually, I would like to point out here, I would like to draw the attention of the academic community here, because we have a research department, but still we don't have enough resources to count this all and to make necessary conclusions, to offer recommendations as to what to do in the future. Maria Filatov has already mentioned that there are two types of amicable settlements. Simpler ones, without any major obligations on the part of the state, where you just need to pay the money. Over the past 10 years, all the countries have already reached about 4,000 of such amicable settlements. Usually, such cases are closed down quite quickly. And there's a second type, with such obligations, additional obligations on top of the monetary compensation, where the authority has to undertake an obligation. Around 331 cases of this type were considered over the past 10 years. I'll give an example of an amicable settlement with obligations, because it's an interesting case. We can look at cases in Turkey. Simides arrested versus Turkey. This group of cases relates to a refusal to provide access to title in the northern part of Cyprus, or the group of cases related to the freedom of speech and which relates to journalists in Turkey, so Öner and Turkey, and it relates to a number of amicable settlements which were reached during the consideration phase. During the enforcement stage, the parties have corrected all the consequences of the violation. And in March 2020, the Council of Ministers has mentioned this with satisfaction and ordered to prepare these cases for closing. An interesting case in Polish cases, Bak, Majewski, and Rutkowski, it was about the lengthy court proceedings. The amicable settlements concluded before the European Court Under these settlements, the government undertook firstly to pay monetary compensation, and secondly to undertake steps to stop such types of violations. Or Moldovan versus Romania, it's about measures against the Roma people. Consequences of a failure to enforce amicable settlements are similar to failure to enforce the resolutions of the court. I'll give you a number of documents here on this slide where you can find consolidated information about this. When the case is considered in a standard procedure, then it is transferred to the enforced procedure. Then such a case can be considered more often by the Council of Ministers. Then the Council of Ministers would take very tough decision where it would urge the authority to rectify the problem. Certain interim decisions can be made. Diplomatic pressure methods can be used. For instance, officials can exchange letters. As an example, this does happen. For instance, there's a case of Garibashvili and Cincinnati versus Georgia. This relates, among other things, to ineffective investigation and mistreatment at the police. And in December 2016, the Council of Ministers expressed its concern due to lack of significant progress on a number of cases, which were in the consideration phase, and they reached amicable settlement during the consideration phase, and then the Council of Ministers transferred these cases to the strengthened procedure. As a result, a number of cases were closed several years later. Enforcement of unilateral declarations by the European Court. Here, the European Court exercises control. I hope that Ms. Listich would make a report on this, so I did not prepare any major facts about it. All I have to say here that there's a very interesting resolution, Yaronovich versus Latvia, the Greater Chamber that adopted a resolution that you should not treat unilateral declarations formally. In this case, an effective investigation under Article 3 was considered. The applicant also complained against mistreatment at the police. And during the consideration phase, the European Court proposed using amicable settlement, but the applicant refused. So the court finalized the case by a unilateral declaration. I'll remind you that a unilateral declaration is similar to amicable settlements which another party refused. So the government offers certain conditions and the applicant refuses. This was the case in that particular situation. If we have enough time, I can stop it in great detail. This is where the government of Latvia undertook to take all the necessary measures to stop such violations in the future. And furthermore, the applicant was given the right to use all other means of legal protection. The settlement, for instance, said that this would not in any way reduce his chances to use any other types of remedies in the future. Furthermore, the applicant would have a right to use other types of for accessible rights. And the fact that after the first consideration of the case, the applicant went to the national law enforcement bodies of Latvia, and he was refused to restart the investigation. This resulted in violation of Article 3, despite the fact that a unilateral declaration was concluded previously. So this is where the European Court interpreted this unilateral declaration quite broadly. I'd like to point out here that there's not a great number of publication on the difference between the unilateral declaration and amicable settlement. And interestingly, there was a publication in the blog of Philip Lichek about this Georgian case, which I have mentioned here, Garibashvili and Cincinnati. I'm sorry, Cincinnati, where the amicable settlement was not enforced, and the applicants tried asking the European Court to restore the case, to include the case back on the list. Attempts were also made to ask for a unilateral declaration on a number of other cases, so that the court would reconsider the cases that ended up in a unilateral declaration. And the author notes that quite often on unilateral declaration, the court would restore the case, but it wouldn't do so on amicable settlements. So in my personal opinion, I don't see a major problem there, because enforcement of the unilateral declaration is what the court supervises, and the Council of Ministers supervises enforcement of amicable settlements. So they probably had to apply to the Council of Ministers, and then the consequences would appear. And Mikhail Galperin has also mentioned here the final stage. It's the fact that actually the amicable settlements are reached not only at the stage of where the European Court considers the case, but also after a resolution has been passed and it is enforced. This indeed helps to solve problems with the enforcement. As an example, the case of Alisic versus Serbia and Slovenia. These cases are related to loss of bank deposits after the collapse of Yugoslavia, and the bank deposits remained in the territory of another country. The Council of Ministers encouraged reaching amicable settlement between the governments of Serbia and Slovenia and the applicant. These were reached in 2015, and the settlement mentioned that as soon as payments are effected, the cases would be closed, and they were closed in September 2020. Another interesting example, Azerbaijan, the group of cases Mirzaev, Humbatov, and Tarverdiyev. In one of the cases, there was a complaint of Ms. Safarova against the failure to enforce the settlement, but finally the parties reached an agreement and Ms. Zafarova revoked her complaint. So the cases were closed in 2019. Another interesting point, Cyprus versus Turkey. Here, to reach an agreement, a whole body was established. These cases relate to north of Cyprus, including the real estate of Northern Cyprus. A whole commission for real estate was established that dealt with payment of commissions for loss of such real estate. And as at the middle of 2019, the commission had already considered 6.5 thousand complaints, and over half of them were ended with amicable settlements. You may have noticed there are no Russian cases, and as Mikhail has mentioned, a decree is being prepared for publication. The rights of the Human Rights Commission in Russia would be extended. If the ombudsman has a right to reach amicable settlements during the enforcement phase, this would probably help to better execute resolutions of the Human Rights Court. Thank you very much for your attention. I'm done. If you have any questions, I'll be happy to take them now.
Огромное спасибо, Никита, вам
Thank you very
за
much,
столь
Nikita, for
детальный, подробный
this very
доклад.
detailed
И,
and
конечно,
insightful report.
каждый слайд на
And
самом деле
clearly,
оставляет очень
every
много
slide
вопросов,
gives us lots
которые
of
хотелось бы задать и обсудить, и очень много
questions that
простора
we
для
would like
дискуссии,
to
потому что
ask.
тема, во-первых,
There's a
как вы
great field for
верно заметили,
discussion
мало
because I have
изученная,
mentioned
во-вторых, она
this topic
приобретает все
needs to
большее
be
практическое
researched,
значение,
but it
потому что
has been
количество
getting
этих
more and more
дел,
practical
которые заканчиваются
importance
дружеским
because
урегулированием или
many cases
односторонней
end up
декларацией,
in amicable
увеличивается. И,
settlements and
естественно, тут
unilateral
возникают и
declaration, as the number of
процессуальные
cases has been
вопросы,
growing.
и
So we have questions
вопросы
related to the
теоретические.
procedures, but also to the theory.
У меня несколько вопросов есть, но
I have
сначала
other
я бы
questions,
хотела
but
дать слово коллегам, если
before
кто-то
I
хочет
ask
задать
my
вопросы
question,
или
I would like to give
прокомментировать
the floor
то,
to
что в своем
colleagues. Maybe
прекрасном
somebody would like
докладе
to
сказал
comment
господин Коломеец. Уважаемые
on
коллеги,
what
есть
Mr.
ли
Kalamid has
вопросы
mentioned
к
in his
Никите?
report. Colleagues, do you have any questions to Nikita?
У меня тогда вопрос относительно
Well, I have a
российских
question
дел,
then
потому что
about
Михаил
the
Гурович этот вопрос уже задала, но хотелось бы
Russian
теперь
cases.
слышать точку зрения именно комитета
I asked this
министров.
question to Mikhail Gaspar,
И
and I would
правильно ли
like
я
to hear
понимаю,
the
что
point of view of the
по
Council of
российским
Ministers.
делам мировые
Do I understand you
соглашения
correctly?
заключаются только в части
In
выплаты
Russia, amicable
компенсации?
settlements are only reached with respect to payment of compensation.
Коротко, да.
Well, if
Тогда у меня...
briefly, yes. Yeah, it so happened that we didn't have an opportunity yet to estimate to what extent other actions that could be undertaken, to what extent are they would be successful or unsuccessful in the Russian Federation, because we don't have that any settlements in this respect yet. I wouldn't remember of any at least. This failure to enforce settlements has not been raised yet. Maybe
Да, и тогда следующий вопрос меня, честно говоря, удивило. Достаточно
another
небольшое количество
question.
мировых
I
соглашений
was
с
surprised by
так
very
называемыми
few
особыми обязательствами, о которых вы упомянули.
amicable settlements
То есть
with
в целом
special
300 с
obligations, which
небольшим
I've
за
mentioned.
10 лет на все страны, это,
300
в
over
общем-то,
10 years
немного.
for all the countries
И,
isn't many.
наверное, это сильно уменьшает
Maybe
потенциал мировых соглашений,
this
потому что, как
reduces
мы уже говорили,
the
зачастую
potential of
заявителей как раз
such
интересуют не
amicable settlements,
выплаты,
because
а
quite often
изменение
people
их
are
текущего
interested
состояния,
not in payments,
длящегося
but in change
нарушения.
of their
Да?
current status.
И в чем здесь, на ваш взгляд, проблема? Все-таки в
So,
отсутствии
in your
каких-то
opinion, what is the
процессуальных
problem here?
механизмов для
Is it because we don't have the
исполнения таких
procedural
мер, каких-то
mechanism
иных мер на стадии мирового соглашения, а не
during
на стадии
the
исполнения.
settlement
То
phase,
есть
but not
получается, что
during the enforcement
государство,
phase?
заключая такие
Turns
мировые
out that the
соглашения, каждый раз действует в
authority,
каком-то ручном
when they
режиме. Да? То
reach
есть
such
государство,
agreements,
например,
they
гарантирует
work in a so-called
прекратить
manual mode.
уголовное
For instance, the government
преследование или
guarantees
гарантирует принять
that
какие-то меры по
political
недискриминации. И это
criminal
все меры абсолютно
punishment would be
индивидуальные,
stopped.
эксклюзивные, которые
And this
требуют
is all
особого
in the
контроля. То есть они
customized
не
approach,
исполняются в
individual
рамках
approach.
каких-то
So this
нормальных,
cannot be
регулярных
enforced as part
процессуальных
of
механизмов.
a
Да?
regular
Или какие-то другие
mechanism.
причины.
Is that right? Or yes, you're quite right. A very good question, and you answered it very well. Indeed, it turns out that why are such amicable settlements reached with the special conditions? Because there's a special reason, a structural reason. Maybe this is just a number of reasons. The reasons why there are so few settlements is because statistics are not quite correct. 331 cases, but each of them can include can 331 amicable settlements can offer a resolution for dozens of cases. So European Court would take such case off the agenda, and then in the annex to such a settlement, the committee table with dozens of applicants. Let's look at the settlement for Poland, for instance, due to the lengthy court investigation. One of the resolutions mentioned that settlements resulted into a resolution of a whole set of problems. So maybe one agreement is enough to settle tens of problems, tens of cases, owing to the settlement of just one structural problem. I cannot say on behalf of my colleagues from the court to what extent this is a problem with the few cases. Maybe there are there's already enough, because I know even of cases where the court would refuse amicable settlements because the court believed that the issue is too serious to resolve it in this way. Because as you quite correctly said, a great number of amicable settlements is not published. Therefore, in some cases, the court continues considering the case itself. Maybe the problem does not exist, but we can ask this question to my colleagues from the court.
Да, у нас, к сожалению, на сегодня такой возможности не предоставилось. Во всяком случае, практикующим юристам сегодня, к сожалению, никто не выступает на нашей конференции. Я думаю, что мы обязательно при случае воспользуемся такой возможностью. И я все-таки еще не могу не воспользоваться шансом, потому что сегодня действительно у нас такой... Нам действительно повезло, что Никита сегодня согласился выступить, потому что он, на самом деле, кладезь ценной информации и много раз помогает коллегам в информационной поддержке, как осуществляется процесс исполнения. И я, конечно, не могу не спросить про постановление по Бурмичу, да, потому что это, я так понимаю, одна из таких очень громких новостей последних лет и в практике ЕСПЧ, и такой новый поворот методологии рассмотрения дел и исполнения решений Европейского суда. Если можно, Никита, в двух словах о сути этого постановления, о том, что оно значит для всей системы конвенции, для системы исполнения, и как это можно соотнести, может быть, как эту проблему, которая, собственно, выявилась в Бурмиче, можно решить с помощью заключения мировых соглашений.
Yes, the Burmich case. I would like to listen to the opinion of Ukrainian colleagues, because I remember this was a very difficult problem for them. And on our website of the department even published information. Dear citizens of Ukraine, please don't write to our department on the Burmich case, but submit your complaints right there, because there were so many that we were simply overwhelmed. We couldn't cope with this function anymore. It's hard to comment here. It was a very special situation. And whether this was successful or not, future will show. So unfortunately, I cannot comment anything in particular. It's still difficult to comment on the execution. We will see where it will all end. On one hand, the European Court was able to take a whole group off the agenda. On the other hand, there's still a problem with the enforcement. It's a very difficult problem. I'll be happy to comment on it if I knew enough, but unfortunately, I haven't been dealing with the Ukrainian cases. I know more about Russian cases.
Да, в любом случае, спасибо. Коллеги, я просто напомню в двух словах, хотя я здесь не берусь отвечать за исключительную точность информации. Дело Бурмич против решения по делу Бурмич против Украины было вынесено Европейским судом как реакция на неисполнение Украиной пилотного постановления по делу Юрия Николаевича Иванова против Украины, простите, и других дел, связанных с неисполнением решений против государства. Структурная проблема, которую государство Украина должна была решить, но не были приняты достаточные внутригосударственные меры, и продолжался поток жалоб в Европейский суд по правам человека на это нарушение. И в какой-то момент ЕСПЧ указал, что поскольку он уже, по сути, сделал все, что мог, указав на наличие структурной проблемы и дав рекомендации национальным властям по ее устранению, в этой ситуации продолжение рассмотрения жалоб уже не входит в его задачу, в его компетенцию, и это дело должно рассматриваться уже на внутригосударственном уровне. И, насколько я понимаю, все-таки в кооперации с комитетом министров, да, по исполнению основного пилотного постановлении. И, конечно, дело это
This had to
вызвало,
be done in
это решение
cooperation with the
вызвало
Council of
очень
Ministers.
много неоднозначных
So
комментариев, в том
this
числе
the
и
resolution caused
относительно
lots of
того, не
comments,
отступил ли суд в данном случае
very
от своей миссии, от
different
своей
comments.
главной задачи, от цели
Some
деятельности, да,
commentators
вынеся
said
такое
that the
решение,
court failed
устранившись, по сути, это не моя
to
оценка, это оценка некоторых
carry out
комментаторов,
its main
устранившись, по
mission
сути, от
because
решения
it
этой
basically refused to
остающейся,
solve
да,
the problem which
нерешенной
still
проблемы
remained
национального,
unresolved.
национальной правовой системы. Да, ну, спасибо большое за комментарий в любом случае.
Thank you very much for your
И
comment.
будем ждать развития событий, в
And let's
том числе и
wait
по этому делу. Очень
how
интересно.
things will continue to
Уважаемые коллеги,
develop
у
in the
нас
future.
сейчас
Dear colleagues, it's
11:24.
11:24 now.
Может быть, у кого-то есть еще вопросы
Should
к
anybody
Никите?
else have any questions to Nikita?
Или кто-то, может быть, хочет что-то
Or would
внести в
anybody like
дискуссию, свой вклад, в нашу открытую дискуссию?
to say
Тогда вижу,
anything?
что нет
No,
желающих. Тогда у
I see.
меня вопрос к
Then I have a
аудитории.
question to the
У нас, в
audience.
принципе, предусмотрено время на дискуссию до
We have time for
11:35,
discussion until
потом перерыв по регламенту.
11:35, and then we
Я
have a
предложила бы
break.
тогда дать
I would
слово
suggest that we give
Евгению
floor
Анатольевичу Фокину с
to
его
Evgeny
докладом,
Fokin now
и после этого доклада уйти на
with his
перерыв,
report,
потому
and
что у
then
нас
we
регламент
break
предусмотрен,
for
тогда это сократит нам
uh,
время
tea.
во второй части. Если нет возражений,
If you don't
нет
mind,
возражений. Тогда слово Евгению Анатольевичу Фокину, кандидату
then I give floor
юридических
to Evgeny
наук
Fokin,
и
candidate of law
научному сотруднику научного члена
and
лаборатории международного
researcher
правосудия
at the
в
lab
Рошеле
for
с докладом
international
«Мирное
law
урегулирование
to
споров в международном
discuss the
национальном правосудии,
amicable
сходства и
settlements,
различия». Пожалуйста, Евгений Анатольевич.
international and Russian law. Good morning, dear colleagues. Can you hear me? Well, firstly, I would like to say that to comment on the conference. The conference is very interesting.
I believe that this discussion is indeed exciting, and when we're talking about amicable settlements, I'm the one that specializes in Russian proceedings, and I can tell you that domestic legislation is not flexible at all. Probably we need to think about how to adapt the system and to align it with EC jurisprudence. So sometimes we have situations where people would bring ECHR judgments as settlements and just asking to follow them. I believe they just will not take them into consideration. All right, the topic of my presentation has been announced, and so I'm dealing with these issues at the intersection between Russian jurisprudence and international justice. So I was trying to identify differences and also identify some points in common. And it was yesterday that I was very attentive, to the broadcasting of our conference that addressed reconciliation. And I have some ideas to summarize the debates. And if we start with reconciliation and settlements in Russia and international jurisprudence, so what they have in common is the goal or the purpose. The purpose is to resolve these legal conflicts, so domestic justice and international justice. So the institutions just are pursuing the same goal and they are going along the same vector. And this elimination of a legal conflict also is a very effective way that can find itself in reconciliation or settlement. Because when we have court decisions or judgments, so these are not necessarily things that parties are hoping for or willing to get. It's just a settlement that can provide them with an opportunity to better protect their interests. So from the international perspective, I think we should also include politicization and judicial activism. These are the phenomena that are there and was settled. So for the state, It is also a way to protect itself from some politically motivated decisions or politicization. I'm not going to engage in this kind of debate, just talking about protection. And there is one important aspect which is to be mentioned. So in international justice, there is certainly a category of case or a type of cases where you wouldn't find any settlement possible because for the applicant it is more important to receive a judgment and to hear to the court um, domestic violence as an example of this type of cases. So I'm not aware of this statistics, but I believe that settlements are impossible for domestic violence because obviously in domestic violence you'll see the situation that it reaches the peak of tension and interpersonal conflict. Obviously, it will not be resolved through any settlement. So I'll be happy to know that I'm wrong, and still settlement can be used for domestic violence. But in any event, so I think we should not overestimate the function of settlement in justice. So reconciliation measures are very comprehensive institutions that can be used both as part of procedural and substantive law. Though obviously, some of the substantive issues are being addressed through reconciliation, again, in domestic practices and globally. My next thesis would be something that the audience will expect from me. But the thesis is as follows. Is the reconciliation just is it about possibility and in terms of national or international justice? So there's some sort of autonomy. So just the parties have to do something for themselves. So they need to try and find a way out of their conflict. So they need to be responsible for their proactive actions rather than sitting and waiting for a court decision to help them. So, in this respect, we see that the international justice takes time. And obviously, if you go with a settlement path, it will reduce this period of adjudication and you will be able to take some actions more promptly. And we have already heard about fast track communication. Obviously, there's the zone or the better limit between what the court does and what the parties can do. So the court has its own functions to perform, and still the parties have some role to play, and they need to undertake certain actions. So if we look at international jurisprudence. Now we see that it sometimes takes several years, say Georgia versus Russia before the UN court, and that case was never heard on the merit because the UN court just didn't find an amicable way out of the conflict. And the case was around developments in South City, and that was on the 12th of August, if I remember well, that Georgia applied to the UN court. And then the question, so the Madrid question was that they took a very specific period of time and they asked what were the actions undertaken by Georgia to try and sort out the conflict. And in fact, Georgia could not explain what was done during that period of time to reach a settlement. And we see that similar things are now happening in the Russian process, and it was 2016 that we started it. Also, some mechanism of reconciliation and reconciliation can be also considered amicable settlement and um, another development. So by 2020, we implemented some procedural documents for withdrawal of actions, and it's now a requirement for the plaintiff and the defendant, so they need to state their view as regards settlement or the possibility of settlement in their dispute. So that's the entire philosophy of reconciliation that we see in domestic practices and international ones. So from the international perspective, so reconciliation is something that should be done in the first place, while domestically, so we see that uh, the primary role is for the court, while reconciliation goes as a complementary procedure, as an, and I believe this needs to change. So, and we need to try and align better with the international practices in that respect. So, we should also think about implementation, probably procedural frameworks, but more importantly, we need to think about changing the mindset. It just the very idea of reconciliation in our society is perceived in conjunction with related science, psychology in the first place, and implementation will follow. So that the psychology of proceedings, psychology of procedures. I mean, this procedural psychology is not well developed in the society, and it is something that we should work on. And I would like to mention that in 2013, so there was a paper published in Ukraine about the psychology of court proceedings, and that was like the background against which we started to consider international justice and also domestic practices. So, because when we use reconciliation, just how to um, we think about um, so how to start reconciliation, how what to do. For instance, we have an applicant that just went through all the stages and then finally reached the ECHR level, and then the state would say, okay, we are ready to settle. So just for the person that have already gone through all the stages, I mean, it's more of a psychological question rather than procedural one. So I think this is something we need to think about. And also in our work, we studied the ECHR jurisprudence and we publish reviews on the website. So I'm just started to think about how to what needs to be done for the cases to be settled earlier before reaching the ECHR. So there was one specific complaint from the Russian Federation, and it's Perova family, and they were the followers of some Orthodox religious, so they sent their son to a secondary school that was a public secondary school, but at the school had a special religious program that was based on the basic religion. And then the family disagreed because they followed some specific religion. So they felt that their constitutional rights were violated, and they sought redress through the Russian jurisprudence, and then they applied to the ECHR. So they filed a complaint, and later ECHR did find a violation for their constitutional rights. So when I took the case file and I started to read it, then I just couldn't realize why didn't they settle it when the case was at the domestic level, probably school authorities or childcare agency could try and talk to the parents and reach a compromise just as regards their complaint. So, and this case dates back to 2009. So the case originated in 2007, And right now, so we see that the child or the school, the pupil that went to school is no longer a student, is no longer a teenager. He should be an adult. And I believe so. If we work better domestically, then we'll be able to reduce the number of cases that reach the international level. So these are also the legislation is in place, and some people say that just we need to try and just send cases from international level to domestic one, but instead of making these referrals from international to domestic level, then we need to first of all try and settle more cases domestically. So, and this is the legal stance that we need to make, and try to avoid the examples of that particular school that had religious program in Voronezh and they couldn't settle a dispute with their families. And from my point is that this reconciliation is related to other science and that we need to work with it psychologically. So thank you for listening. I believe that my fellow
Уважаемые
students will now
коллеги,
be
бывшие
raising
студенты
questions,
Гены
but
Анатольевича, и не только,
I'm
есть ли
also
вопросы по докладу,
happy to
очень интересное
answer
размышление, очень интересное
other
наблюдение.
questions. Just these are
Коллеги, у
very
кого вопросы?
interesting
И я обращаю
considerations
внимание,
and
Ольга Киселева написала в
observations.
чат.
So
Ольга
we
как раз
have
занимается сейчас делами
a comment from Olga
по домашнему
Kiseleva. So
насилию,
Olga Kiseleva
по
right now
профилактике
is
домашнего
dealing
насилия
with
на
domestic
национальном и
violence
международном уровне, и
cases and
подано
also
несколько
prevention of domestic
жалоб в
violence
ЕСПЧ,
at the national level
в том
because
числе из
several
последних, что я
complaints
видела.
have been
Оль,
filed with
поправьте меня, если я
ECHR.
не права.
And
Насколько я
so
понимаю,
correct me
ЕСПЧ
if I'm
коммуницировал
wrong,
одной из
but
последних
the
жалоб,
ECHR
которые
has
не были
already
исчерпаны
communicated
внутригосударственные средства защиты, то
one
есть тем
of the
самым
recent
признал, по сути,
complaints
де-факто их
saying that
отсутствие. Да, может быть,
the
короткий комментарий вы
legal
дадите?
remedies had not been exhausted yet. Could you comment on that case? Yeah, that's entirely correct. So one complaint was filed by the victim of domestic violence, and she was suffering within 2 years. So the victim and her representative just didn't see any possibility for bringing the person to justice because the existing code of administrative offense decriminalized domestic battery. So, and this is only an individual complaint. It is also very difficult to prove the guilt of the offender because you need to provide evidence, you need to invite witnesses. So, and this just creates huge impediments to any justice and protection for the victim. So, the therefore, so the idea was to collect the evidence to prove the fact of domestic violence. So then the complaint was communicated to the ECHR, and that was a very logical decision to make because there have been 3 judgments from the ECHR, and the Russian
Ольга,
legislation has
согласитесь с
no
утверждением Евгения о том, что это
ineffective
как раз одна из тех
or inefficient
категорий,
in
где
that
вряд ли
respect.
возможно дружественное
But would you
урегулирование, по
agree
крайней мере,
that
на
for
данном
domestic
этапе?
violence cases, you will hardly have settlement? Yes, I agree. Amicable settlement is more about agree with people, probably to meet, I mean, and to talk. But for the victims of domestic violence, so we need to ensure a systemic decision at the level of legislation that possibly some people will be willing to settle as a way out of their tragic situation, but obviously this will not help other people. So, and this will not make it a very effective, efficient, and also prompt and immediate
Большое
measure
спасибо.
of
Уважаемые коллеги, я понимаю,
response.
что мы с вами уже
Thank you
вышли
very
за
much.
регламент
And dear colleague, I'm
по
afraid so
перерыву, но
we're
мы чуть-чуть
running
сдвинем
out
его,
of time
потому что очень
because
интересный вопрос
we're
пришел от
covering the
Никиты
time of
Коломийца
our break,
в
and we
частном
received
сообщении
a very
в продолжении того,
interesting
что сказал Евгений
question from
Анатольевич. о том,
Nikita
как
Kolomeitz.
реагирует национальный
So the
судья,
question is that
российский
the
судья в
response
частности,
of
когда к
Russian
нему приходят
judges
стороны вот с таким заключенным мировым
to
соглашением о принятии, допустим, каких-то мер.
settlements,
И
how these
действительно вопрос
amicable settlements
неправный,
are
потому что,
taken by Russian
например,
judges in
заключается
general.
довольно много
So this is,
мировых соглашений
by the way, an
России
important
по
question
длительности
because
содержания
in
под
Russia,
стражей.
I mean, many
Да, и мы
settlements
понимаем, что когда человек
can
все
be
еще в
reached
СИЗО,
for
то
detention
ему, в общем,
periods. So
важны не столько
obviously,
деньги, не столько
we do
компенсация,
realize
сколько то,
that
чтобы
if a
ему меру
person is
изменили.
detained,
И
so for
вот
the
если с
detainees, it
таким
is
мировым
important to
соглашением или
have a
даже с
measure of
коммуникацией
restraint
прийти в российский
changed
суд, да, как, и
into
сказать,
something
что вот видите, Европейский
softer
суд
rather
указывает на
than
то, что у вас
receiving
необоснованное
money
не,
in return.
продление, не чрезмерно длительное продление
Then others
меры
applying to
пресечения,
European Court of Human
давайте что-нибудь с
Rights,
этим
saying
сделаем.
that
Понятно,
the
здесь
periods of
реакция российского
detention
суда, к
are
сожалению,
unreasonably
предсказуема. Может
long.
быть, я ошибаюсь, если у
And
кого-то есть другие, более
I'm
счастливые
afraid that
примеры,
the
пожалуйста,
response from
поправьте.
the Russian
Но
court will
действительно это, наверное, может быть проблемой.
be clear, and
И, ну, собственно, вот я высказалась, может быть, у
we know
кого-то есть
what they
какие-то
will
другие
say.
комментарии,
That
замечания по этому
probably
поводу. Никита, может быть,
you
вы хотите
have a
что-то добавить?
different opinion. Probably Nikita would like to say something.
Мой вопрос. Это может быть не совсем по теме, но очень интересный действительно вопрос. И насколько российские суды принимают во внимание то, что приносит им
You know, it's all about Russian courts and the way they take amicable settlements. For example, settlements can be brought, I mean, settlement agreements, so they can be translated, and then the Russian will be looking them through. And this issue has been already raised with the Council of Ministers, and it's Article 5 of the Convention that stipulates the conditions for pretrial detention terms, and just ECHR judgments are not necessarily taken into consideration. So there was one decision back in 2019, and that was para 7 of this particular judgment. And then there was a question addressed to the Russian authorities as to so how quickly can judges get translations, get translated versions of settlement agreements, because this translated agreement should be added to the database. I mean, if colleagues, if you experience any problems with getting prompt translated versions of settlement agreements, so we could do it, for example, when we sign a treaty. So there is one official version of a national language of an international treaty, and probably we could do it in the same way, in a similar fashion with the agreements, because as far as I know, so there are several translations that are delivered by translation agencies, by the Supreme Court, by courts themselves, and obviously much more time is spent on this, and the Committee of
Вопрос о
Ministers
переводе, тут я
has already
немножечко по своей
highlighted
прошлой
the
деятельности в
importance
курсе.
of it.
Да, вопрос об официальных
And
переводах стоит на самом деле давно, но по
you're
ряду
right,
причин
because we've been, I mean,
такое
talking about
решение
it
не
for a long
принимается,
period
потому
of
что
time.
все-таки очень большой
And
объем,
this
во-первых.
official
Во-вторых,
translation
тогда
is a
должен кто-то
tricky
на себя
issue
взять
because we need
функцию
to have
условно
someone
гаранта этого официального
responsible,
перевода, как это
say,
делается с международными
to
договорами.
ensure the
И в данной ситуации
quality of
такого уровня
translated
просто нет.
document.
Но опять
So
же, по
similar to
практике, и это
to
хорошо известно,
treaties.
все переводы
And
всех российских
as far
постановлений
as I know, so these
отсылаются
translations of
аппаратом
all
уполномоченного Министерства
Russian
юстиции, отсылаются в Верховный
resolutions
суд, который уже
is sent to
распространяет
the Supreme Court of the Russian
самые
Federation
важные
by
дела по
and
другим
then
судам. И у судов,
by
конечно
the
же, эти
competent
российские тексты
authority,
есть. Более
and
того,
then
регулярно
Russian
рассылаются
courts are
выдержки из самых важных
provided the
постановлений, то есть такие
translated
дайджесты по
versions,
свежей
and then
практике
in
ЕСПЧ.
addition to
То есть
that,
суды
we
это все
also
получают. Так
produce
что мне кажется, что здесь все-таки
digest,
проблема не столько в
some
переводах, сколько в каких-то других
review
методологических
of
и, может быть,
ECHR
психологических подходах, о которых
jurisprudence.
сегодня
So
говорил
that's
Евгений Анатольевич в том числе.
so those ECHR
Спасибо
judgments
большое.
are being translated, but I think it's
Простите,
mostly
да, мы
about
вышли немножко за регламент, но
about how
поскольку перерыв
judges
все-таки
are using them,
предусмотрен, я
because this material
предлагаю
is available
все-таки его
on their
сделать.
websites.
Давайте,
And
может
now
быть,
we
в
have
55
one
минут, если
break
нет
scheduled
возражений,
in
без
our
5,
agenda,
мы
and I
вернемся и
suggest
продолжим уже
we
тогда нашу
resume
вторую
at
часть.
5 minutes
Начнем вторую
to
часть.
12.
То есть без
So
5 мы
we'll
снова
start our
встречаемся.
session numbers,
Всего
our
большое
second session
спасибо.
for today. So see you at 5 minutes to 12. Thank you.
Уважаемые коллеги, предлагаю продолжить, возвращаться к нашей повестке. Ага. Я вижу, появился Адель Эльсиярович, наш первый докладчик во второй части.
Dear colleagues, I would like to welcome you
И,
to
собственно, мы
resume
готовы начинать.
our
Итак, во второй
session.
части нашей
And
сессии у
this is
нас несколько
the
докладов
second
по более
part of
общим
our
вопросам
session that
мирного
includes
регулирования споров и в целом
several
мирного процесса как части
topics of
международного права, сегодняшнего международного
settlement
права,
and
во
also
всех его проявлениях.
settlement
Адель
procedures as
Эльсиярович, вы
part of
слышите нас?
Да,
international
слышу,
law.
прекрасно.
And
Добрый день, очень приятно.
and
И я с удовольствием
Julian has
предоставляю
already
слово
joined us,
доктору юридических
and
наук,
I'm
профессору,
delighted to give the floor
заведующему
to
кафедрой
Doctor of
международного
Law,
права
Professor
Казанского
and the
государственного
Head of the
университета
Department of
Абдуллину
International European
Аделю
Law
Эльсияровичу. Прошу
of
прощения, в программе ошибка, у нас
Law
опечатка
School of
может
Kazan.
редактора, да, не досмотрели. Адель
Abdel,
Эльсиярович, пожалуйста.
Спасибо огромное, уважаемые
the floor is
коллеги.
yours.
Мне очень приятно
Thank you
принимать участие в
very
столь
much.
представительном форуме, который
And
посвящен действительно очень актуальным
I'm
проблемам правосудия,
very
примирительным процедурам,
pleased
их
to
кумулятивному эффекту. И,
take part in
безусловно, вы
this very
знаете, я бы так
important
сказал, это сегодня
conference
тренд,
that
который
covers the
определяет, возможно,
cumulative
и направление
effects of
развития нашей
reconciliation,
международно-правовой
settlement,
науки,
and this
науки,
is the kind
связанные
of
с исследованием
trend-setting
процессов региональной
event
интеграции,
that are
которые
also
сейчас стали, в
important
общем-то,
to the
явлением
process of
повседневным таким,
regional
поскольку весь мир
integration
вовлечен в те
that are
или иные
becoming
формы интеграционных
widespread
процессов.
and
И, конечно же,
commonplace
говоря об
across the
интеграционных
globe.
процессах, о
So
правовых
when we're
механизмах
talking
их
about
регулирования,
integrational
нельзя и не
processes and
упомянуть о проблематике роли
regulation
международных
and
судов,
mechanisms, so the
международного
role of
правосудия,
international courts
региональной
and international
судебной
justice,
системы, которая, в общем-то,
also
значительно
regional
роль в этой
judicial
степени
systems
достигает и играет.
have their
Вообще необходимо сказать,
place
что развитие
within the
интеграционных
system.
процессов, которые происходят в
So these
современном
are
мире,
the
и появление
processes that
достаточно
are
большого количества
unfolding in the
новых
world, and we
региональных
see the
организаций,
emergence of a large
свидетелем
number of
этому мы все
regional
с вами
organizations
являемся, активно
that we are
сопровождает созданием
witnessing today.
механизмов разрешения
So, and
споров,
this
в
goes
качестве
in
которых
parallel
выступают
with the
региональные суды и
creation of
трибуналы.
dispute
И это
resolution
представляет собой
mechanisms that
достаточно
are
интересный
represented by
феномен в связи с тем, что
regional courts
региональные
and
механизмы
tribunals.
разрешения
And this is
споров
a very
самым
interesting phenomenon because
непосредственным
the regional
образом затрагивают
mechanism of
интересы
dispute
конкретных
resolution
и, подчеркну,
also have an
суверенных
impact
государств.
on the
Учреждая
interests of
судебный орган,
specific and then
региональная
stress
организация может выбирать
sovereign
традиционно
states.
один из двух
So an international
существующих типов.
organization can
Международная
opt for
организация,
one of the existing
фокусирующаяся на
two
создании
types.
зоны
So that's the
свободной
international
торговли,
organization
делает
that is
выбор,
focused
как правило, в
on
пользу
the free
механизма
trade
по разрешению
zone
споров,
would opt
сходного
for
с аналогичным
dispute
механизмом в системе ВТО, который
resolution
предусматривает
that
создание
is
органа,
similar to
состоящего
the
из назначаемых судей, которые
WTO
и разрешают
mechanism.
споры
So the
между
WTO
государствами, и
mechanism
это логично,
consists of an
этого
ad hoc
достаточно на данном
dispute
этапе
settlement
развития
body
интеграционных
that is a
процессов, на
quite
данном его
sufficient
уровне.
tool at this
Организации, целью
stage of
которых является уже более
development
углубленная
for the
интеграция,
community.
да, организации, которые
And the
мы
second
называем
option
организациями
would
интеграционного
be
типа, да, не
going via
координационного,
the
включающие
integration
создание
path rather than
надгосударственных
coordination.
институтов и
And
общего
we're talking
рынка,
about is creating
достаточно часто
multilateral,
делают выбор в пользу модели по
organizations
разрешению
and
споров, сходную
market-based
с судом Европейского
institutions. And
Союза.
this
Судебный орган
kind of
подобного
institutions
типа
will be
наделен
similar to
правом
the
по
European Court of
единообразному
Human Rights.
толкованию
So the
учредительных
body will
договоров
be
региональной
vested with the
организации, и его юрисдикция
functions for
обязательно для всех государств-членов.
interpretation and
В этой связи нам
so
хотелось бы остановиться
jurisdiction
на
will be
моделях
covering all
регионального
member states.
судебного
And I would
механизма,
like to
сходных с
address the
судом
models
Европейского
of
Союза,
regional
учитывая ту роль
judicial
и
authorities that are
значение, которые суд
similar to
ЕС
the
сыграл в
European
развертывании
Court of Human
интеграционных
Rights.
процессов в
And
европейских
also,
сообществах, а позже и в
we know
Европейском
that in
Союзе,
particular the
представляется достаточно
European
интересным
Court of
взглянуть
European
сквозь призму
communities.
подобного
So that's
потенциала
just we
и
need
на
to look
судебные
through the
региональные
prism
механизмы,
that the regional
построенные по аналогичной
court
модели, но
mechanisms that
функционирующие
have
в
been
других
built
политических,
on
правовых,
this
экономических,
model but are
социальных условиях.
operative in
И
different
возникает вопрос, могут ли
economic and
быть
social
такими
conditions.
же
So the
эффективными
question is, can
в
we
процессе
ensure
углубления
just
и
the same
продвижения
level
интеграционных
of
процессов,
efficiency
как это сделал в
in
свое
the
время суд
process
ЕС,
of
определяя
integration?
основные
So we're
параметры
talking about the
европейского интеграционного
EU
процесса,
court.
и
So EU
иные
court
модели
and this role in defining the
судебных механизмов,
parameters of
которые
integration
присутствуют
process
в аналогичных
and
интеграционных
other
образованиях, которые
parameters that
строят
are
свои
also
модели
found
по
in
модели суда ЕС.
integration
И для этого нам хотелось бы
institutions that are
сравнить три
modeled
институциональных
on the
региональных судебных
EU
моделей. Это суд
court.
ЕС, суд
So
Андского
we'll be
сообщества
now
и трибунал
comparing
Южноафриканского
ANZ
сообщества.
court,
Развитие,
South
рассмотрев их сквозь
African
призму влияния на их
tribunal,
эффективность, в
and
частности,
EU
таких
court.
очень
And so
важных фактов,
we'll
как
be
политическая
looking at
поддержка,
them through the prism
легитимность,
of
доступ
political
частных
support,
лиц, длительность
legitimacy,
функционирования
the
и
access by
готовность к
private
решению
parties,
значимых и
so
региональных,
length
прежде
of
всего, проблем. В этой
free
связи достаточно
operations
кратко
and
постараюсь вот
also
эти модели
contribution to the
охарактеризовать. Если же
resolution
нам
of
говорить о суде
regional
Европейского Союза, да,
problems.
как о некой
So now
такой
we are talking
основной
about
модели,
the
да, о неком
EU
примере
Court of
судебного
Justice
механизма,
as a
присущего
basic
интеграционной
model and
организации,
as an
то необходимо
example
отметить,
for
да, сквозь
integration
призму уже
at the
прошедших лет,
judicial level.
нескольких
So through the
десятилетий,
prism of
что в
these
самом
past
начале
years and
функционирования суд тогда еще
several
сообществ, в
decades,
50-е
at
годы,
this
да,
very
его роль
inception
была в
back in
значительной степени очень
1950s, that
скромной.
was the
Очень
Court of
скромный в
European
деле продвижения
Community,
европейской
and
интеграции,
its
и
role was
ввиду
very
достаточно
limited in
слабой
the
поддержки в
process
тот
of
момент
regional
судоесть со стороны
integration, and
национальных
it was
политических
this
кругов на
he
данном этапе своего
it
функционирования, он
wasn't
сфокусировался,
supported
что очень
also
интересно и
very actively
примечательно,
by the
на решении
state. So
технических и так
given this
называемых
weak
процедурных
support,
вопросов.
the court limited
Однако уже в
itself
начале
to
60-х
technical
годов, то
and
есть, по сути, через
so-called
10 лет с момента
procedural
начала своей
matters.
деятельности, суд
Then
закрепил в своей
in early
практике, по сути,
60s, we
важнейшие
see that the
прецеденты,
EU
которые
Court of
сыграли
Justice
очень
then
важную роль в
set
развитии интеграционных
precedents
процессов
that
ЕС.
also
Так,
played a
например, в
major
решении
role
комиссии
in the
против Люксембурга
development of
1962 год суд
integration
ЕС
process.
оказался
That was
способен поддержать
62
и
decision
защитить
versus
гуманитарные правила,
Luxembourg,
когда он четко и
where the
однозначно
court
высказался в поддержку
upheld the
принципа свободного
communitarian
движения
rules
товаров и добросовестной
and it
конкуренции между
supported just the
государствами-членами.
principle of free
Безусловно,
movement
классически
of goods
фундаментальное
between
решение — это
members
Ван Гентен
of the
Лоус и
EU and
Костайна,
Genton Laws and
63-64 год, то есть это
Constein,
буквально через год
63,
уже, да, после
64.
дела комиссии
So
против
we see
Люксембурга,
year after
мы видим
year that
закрепление
was
фундаментальных
the first
принципов
case was
всей
the
правовой системы
versus the Commission of
европейских тогда
Luxembourg, and
сообществ.
then we
Это
see
и
that
верховенство
more
права, и принцип
cases came
прямого
into play,
действия.
and that
И,
was the rule
конечно же,
of
это
law,
было
the
очень важно с точки
ratification.
зрения
So
роли
all those
суда
principles
в
were
закреплении вот этих столпов
greatly
европейского
upheld
интеграционного
by the
процесса. Если
Constitution,
мы уже
and they were
взглянем на
enshrined as
70-е годы,
pillars
то такие
of
ключевые
European
параметры, да,
adjudication. Now we move
судебного, скажем так,
along the
творчества, как
timeline
Кассис де
and
Дижон
approach
79 год, Дассонвиль
70,
74 год, другие
79,
дела, мы
74,
видим, как
Dozonville,
суд все дальше и
Casson-Jones.
дальше идет по укреплению
Obviously,
принципов
there was
сообщества,
a clear
определению
trend
параметров
toward
компетенции сообщества,
enhancing the
исключительного ведения,
parameters of the
совместной
community and the
компетенции. И суд
vision. So
определяет
these
очень жестко, очень
common
четко те
competence
параметры,
and
в которых
also very
будет в
strict
дальнейшие годы
definition of
развиваться
those
Европейский
parameters
Союз,
that
трансформируясь
would
все
lead
больше и
the
больше, получая все
development of
новые
the
компетенции.
European
И
Union
здесь роль
and
суда
also
огромна.
acquiring new
А вообще
roles
необходимо отметить,
and
что
their
утверждение
competence
нового правового
in
порядка, который мы так
disputes. So
традиционно любим
the
использовать
new
в отношении
legal
характеристики
order,
права ЕС,
this is
и как суд
something that
назвал его,
we
да, в своих
often
решениях, в значительной
refer
степени
to while
стало возможным
describing the
также
EU
ввиду
and also this
существенной
EU order
поддержки
as
со
it
стороны
was
юридического сообщества
seen by
государств-член.
the
И я
EU
хочу на
Court
это
of
обратить
Justice,
внимание. Это национальные
became to
судьи,
be because of
адвокаты,
the support
академическое
that it
сообщество,
enjoyed
которое
among
встало
national
действительно
judges
на пути
and
защиты вот
practicing
этих
lawyers,
европейских
also the
ценностей и
academia
европейского
that
интеграционного
decided
проекта. И вот это
to
так называемое
support and
эпистемическое
to
сообщество,
uphold all
epistemic
those
community,
European values. So
протагонистов
we're talking about
интеграции,
the
да,
European
по-моему,
community,
все-таки это было
so that
решающим для
is
успеха
the
суда ЕС
driving
в
force of
начальные годы его
integration
деятельности,
that
поскольку оно
was
установило так
precondition the
называемые
success of the
симбиотические
court at
отношения
its
с
very
национальными
inception
судами,
because it
службами,
created that
тем же самым
symbiotic
академическим сообществом,
kind of
что в конечном итоге
relationship
и,
with
наверное,
national
позволило достичь
institutions
тех результатов,
and the
которые есть на
academia,
сегодняшний день.
and as a
И
result,
вообще
as brought
необходимо
these
отметить, что
results, the
оценивая роль суда
outcomes
ЕС в
and
развитии и
deliverables
продвижении
that we
европейской
see today.
интеграции,
So
можно сказать, что
obviously the role
суд
of the
ЕС оказался
EU
способен, вот
Court of
хочу это
Justice
подчеркнуть, внести
just
свой вклад,
turned out
значительный
to be
вклад в укрепление
capable
интеграционных
and
процессов
emphasize of
путем закрепления
contributing
в
to
своих решениях
integration processes
ключевых
by
принципов права
enshrining
ЕС,
the key
что было
principles
бы
of
очень
EU
сложно
law
достичь
in
лишь
its
политическими
decisions, but
инструментами.
otherwise
И вот в качестве
political
небольшой ремарки
instruments
хочу
would not help
сказать, что
to
вчера
do
буквально в
that
ГИМО в
to that
диссертационном
extent. It
совете
was
прошла защита
yesterday at
докторской
GIMO
диссертации Ильи Михайловича
that
Лившица, посвященной
Mr.
проблемам очень
Lifshitz
актуальным
defended his
взаимодействия
thesis
международного
addressing
финансового
very
права
relevant
и финансового
problems
права
of
Европейского
interaction
Союза. И
between
там, в
international
частности, очень
financial
важный
law and the
момент в
EU
работе, в
financial
диссертации и в той монографии, вот я ее
law, and
демонстрирую.
that's the
Вчера,
monograph
поскольку я
that
был
was
членом
published. No,
диссертационного совета ГИМО,
yesterday I was
вот, правда, сегодня уже я нахожусь
a
в
member
Казани, вот
of
так
the
мы сейчас
GIMO
мобильно все
panel, and I'm
передвигаемся.
now
Вот, в
speaking.
этой
I'm
работе, в
now
этой
talking to you
диссертации
from
очень важная
Kazan.
роль
You should be very
посвящена анализу действительно
mobile
роли суда
indeed.
ЕС, судебной
So, and that
практики, закрепления
dissertation is
тех
very interesting
принципов,
because
на
it
которых в том
describes the
числе
role of
базируется
EU court
взаимодействие
justice,
международного
its
финансового права,
jurisprudence,
международных
and also
финансовых
those pillars pillars that have been set up for finance law and also financial organizations.
включая
There
и экономический
are
валютный
many key
союз,
areas,
это вопросы, связанные с
including
оказанием финансовых услуг и
currency
так далее, с
union
новыми
and
брендами,
financial
криптоактивы,
services,
аудит и
cryptocurrencies,
так далее. И
and
здесь вот Илья Михайлович
audits,
очень детально
and so
тоже
on and
показал,
so
поэтому
forth.
я отсылаю вас
So
к его работе,
all these
монографии и
aspects are
диссертации.
described
Что
greatly,
касается
so
других
please
судебных
take a
моделей, да,
moment to
Трибунал
study it.
Южноафриканского сообщества
Right, let's
развития, в
look at the
частности.
tribunal
Вообще, это
for the
очень
South
интересное
African
субрегиональное экономическое
development
образование
community.
на
That's a
африканском
very
континенте,
interesting
которое, в принципе, мы
sub-regional
мало знаем, мало исследуем, хотя,
formation
в
in this
принципе, вот, в
continent.
общем-то,
So
и
it is also
последние наши молодые
understudied. We don't
исследователи
know
вот в Казанском
a lot
университете
about it.
буквально
Just our
несколько
younger
недель назад была
scholars
защищена
from Kazan
диссертация, посвященная
University
механизмам
have
защиты прав
decided to take it as
человека
a topic, and
в
it was
субрегиональных
recently they
организациях
have defended a
Африки. И
thesis
вот
on the
наш
protection of
соискатель
human rights in the
Владыкина Анна
sub-regional
Юрьевна очень
organization
детально
in Africa.
посмотрела вот эти
And so
интеграционные
Vladikina
процессы и
looked at
то,
this
как они
integration process and
воздействуют на защиту
their
прав человека.
impact
Мы с
on
вами
the
знаем вот
human
эту
rights
дисперсность
across the
механизмов
continent,
региональных
because we know
интеграционных
there's
на
some sort of
африканском континенте,
dispersion
да, вот
in
это
the
вопрос соотношения
mechanism, I mean, regional
субрегионального, регионального,
mechanisms. There's this
универсального уровня, да,
interaction between
правозащитного. Это
regional,
стал предметом
sub-regional, and
исследования Анны Юрьевны
universal
Владыкиной.
standards.
Так
So
вот,
this
Южноафриканское
hierarchy just
сообщество
came
развития
into the
на
subject matter
сегодняшний день
of
включает 16
study.
государств и регионов, то
So
есть это
these are
достаточно большое
16
количество государств.
states of the
И
regions
уже при
that are covered
разработке
by the
проекта договора в
jurisdictions,
1992 году
and it was
о
in
Южноафриканском сообществе развития была определена необходимость учреждения
1992
судебного
when
органа сообщества в целях единообразного применения и
treaty
толкования
was
права.
concluded for
Как
South
следствие,
Africa. And
статья
then
9 данного договора учредила
Article
трибунал
9 set
Южноафриканского
up
сообщества
South
развития.
African
При этом компетенция трибунала,
Tribunal,
как это было закреплено в
and
специальном
the
протоколе, включал в себя
competences of
обеспечение
the tribunal
толкования,
would
прежде всего, конечно же,
include
учредительного
first
договора и
interpretation of
рассмотрение
the
споров, которые могут возникнуть в связи
foundational
с его
treaty, and
применением, и
also
также
the
вынесение консультативных
hearing
заключений
and
по
deciding
запросам соответствующих
cases
органов. Ну, это саммит глав
and
государств и
disputes
правительств,
with
Совет
respect
министров и
to
так
that
далее. Это было
treaty.
закреплено в
And
статье 16
that
договора. Однако сам
was the
протокол,
provision
создающий
of
трибунал,
Article
не был
16.
подписан вплоть до саммита
However,
2000 года.
protocol
Ввиду
itself
опасений
on
того, что не будет
setting
собрано
up the
необходимое количество
tribunal was
ратификаций для вступления
signed
протокола
in
в силу, было
in
решено вместо этого
2016, and
одобрить
because
протокол решением
instead
саммита глав
they
государств и
decided
правительств.
to
В конечном
agree the
итоге
protocol
трибунал как
by the
судебный
summit
орган
of the
Южноафриканского сообщества
states,
развития
and
заработал
so the protocol
в 2005
and the
году.
tribunal
Первое дело
started
было
to
рассмотрено в
function
2007 году, то есть через
2005. So
15
the
лет
first
после
case was
упоминания о нем
considered
в
in
договоре, да, о Южноафриканском
2006. So
сообществе
that
развития. И в
15
последующие годы
years
трибунал
had
рассмотрел в общем
elapsed by
количестве
then,
18
and
дел,
then that
выносил
was
решения, утверждающие принципы права
18
сообщества
cases that
и
were heard by the
демонстрировал
Southern
очень,
African
так
Development
скажем
Community
прямо, значительные
Tribunal.
усилия по
And
информированию
so,
граждан
and
стран,
its
членов
mandate
сообщества
included
о
also raising
трибунале и его
awareness
юридических
of the
возможностях.
residents of
И это,
South
конечно, было
Africa
прекрасно и
about the
как бы
tribunal and its
многообещающе. Но
functions, and
уже
it
во
was
втором деле,
a very
известном
promising
Кэмпбелл против
development
Зимбабве
by that time. And there was
2008 год,
Campbell
трибунал попал в
versus
достаточно сложную
Zimbabwe,
ситуацию, когда защитил, по
2008,
сути,
that the
фермера Майка
tribunal
Кэмпбелла,
found itself in a
обратившегося в
very
трибунал
tricky
с
situation. That
жалобой
was
против
Mark
правительства Зимбабве,
Farmer, the
зачастую
farmer,
против
that
специальной
applied to
программы
the
земельной
tribunal in order
реформы,
to
принятой в Зимбабве.
in
Ну,
order
совершенно
to
очевидно,
raise
какая
his
была
voice
реакция в
against the
Зимбабве,
land reform
которая
in
не
Zimbabwe.
только
So the applicant
фактически
won,
сказал, что
but
нет, мы не будем исполнять этого решения,
but
оно
the
для нас
state,
не имеет
so the
никакой
government of
юридической
Zimbabwe,
силы, и мы не
did
хотим вообще
just
этого делать, да?
denied, and they
Но
said that
более
they
того,
didn't want
по
to enforce
инициативе
the
Зимбабве
decision
был
because the
запущен
decision
юридический
was not
механизм, да,
there.
определение
But
легитимности
Zimbabwe, by the way, started
Трибунала
this
Южноафриканского сообщества
mechanism
развития,
of review,
назначение
like
вообще-то
the
беспрецедентной
legitimacy
независимой
of
международно-правовой
South African
экспертизы
development community.
по
They even
статусу
called for an
трибунала. Это тоже,
international
по сути, очень
expert
интересный момент.
examination
В
as
конечном
regards the
итоге,
status of the
вот, когда
tribunal
же
that was
министр юстиции
unprecedented
Зимбабве заявил,
in
что трибунал вообще не
jurisdiction,
имел
and then
юрисдикции в
the
отношении
ministers,
Зимбабве, да,
the
то
president
уже
of
стал
Zimbabwe
вопрос о
said that this
будущем
tribunal had
этого
no
судебного
jurisdiction over
механизма.
the Zimbabwe,
Вот. И на
and
саммите
that
2012 года
questioned
главы государств-членов сообщества
the
решили, что
future
необходимо
of the
начать работу над
attribution.
новым
And then the
протоколом о статусе
summit
трибунала,
was
компетенции
convened, and
которого,
so they
подчеркну,
decided to
ограничилась бы
develop a
лишь только
new
толкованием
tribunal, and
и
whose
применением
mandate
положений
would be
договора о
restricted to the
Южноафриканском сообществе
interpretation
развития и
and the
протоколов к нему,
application of
относящихся к
the
спорам между
agreement to South
государствами-членами. То есть,
African as a
посмотрите, насколько радикально изменилась вообще судьба этого судебного органа, этого трибунала, и, по сути, до сих пор его деятельность приостановлена. До сих пор никаких юридических механизмов по завершению изменения статуса трибунала, даже в том усеченном виде, который был определен на саммите 2012 года, этого нет до сих пор. Это поразительно, да? И вот это, конечно, модель, которая начиналась действительно очень благостно, закончилась достаточно сложно. В этой связи также хотелось бы обратиться кратко к суду Анского сообщества. Анское сообщество тоже очень интересное региональное образование, но уже в другом регионе мира, да, это Южная Америка. Стороны основатели Анского сообщества были вдохновлены, я другого слова не подберу, примером Европейского Союза, на создание общего рынка через создание надгосударственных институтов. И в этих целях они восприняли европейскую институциональную систему. То есть, по сути, шло копирование. Да? С 1996 года, после подписания Токийского протокола, Анское сообщество концентрирует свои усилия на либерализации торговли. И это главное для них. Уже к 1979 году стало ясно, что существует очень такая четко осознанная потребность в создании судебного механизма в рамках данного сообщества, который мог бы гарантировать единообразное, да, применение толкования права сообщества. И поскольку за основу также была взята модель суда ЕС, в 1984 году, по сути, по этой же модели и начал функционировать суд Анского сообщества. 4 судьи, расположены в городе Кито, Эквадор, и первоначально суд обладал полномочиями по признанию актов недействительными, но уже с 1999 года он обладал также иными полномочиями, среди которых в том числе такие важные, как прюдициальная юрисдикция, рассмотрение отраслевых споров в сфере трудовых отношений, в сфере интеллектуальной собственности, о чем тоже кратко скажу. То есть мы видим расширение компетенций. И очень интересно, что сообщество повторил ключевые положения судебной практики суда ЕС, утвердив принципы прямого действия и верховенства права Анского сообщества. То есть мы видим, что уже следование шло и практики суда ЕС. Не только там институциональная модель была скопирована, но и практика. Вот. Однако вскоре суд Анского сообщества смягчил свою позицию и заявил, что Анское сообщество, в отличие от правового порядка ЕС, не образует нового правового порядка какого-то уникального, да, и был введен так называемый принцип функциональной необходимости, да, он был введен в целях урегулирования коллизии с национальным правом. Он означает, что даже в сферах компетенций сообщества государства-члены могут принимать национальные законы до тех пор, пока они не нарушают право сообщества. Это вообще очень интересный юридический механизм. В этой связи, вот я могу только проиллюстрировать, да, практикой суданского сообщества, в которой он не встал на позицию укрепления права сообщества и не воспользовался имеющимися у него достаточно интересными и широкими полномочиями. Это дело Алюминия Рейнольдс, 1990 год. Это дело Sociedad de Aluminio Nacional, 93 год. Уникальная была возможность, да, следуя той же самой практике суда ЕС, говорить о принципах права сообщества и их закреплять. Но суд сказал, нет, национальные интересы выше, национальные юрисдикции должны быть в приоритете и, соответственно, не стал протагонистом интеграционных процессов. Да? Ну, также хотелось бы сказать, что абсолютное большинство дел, да, которые рассмотрел этот суд, рассматривает, это дела в сфере интеллектуальной собственности в рамках прюдициальных процедур, да, тысячи таких дел. Вот он сконцентрировался на решении интеллектуально-правовых споров, трудоправовых, других каких-то, и ушел в сторону от таких ключевых моментов, которые могли бы определить параметры дальнейшего интеграционного процесса в рамках Анского сообщества. Ну, как мы увидели выше, каждое интеграционное образование, по сути, будь то Европейский Союз, Южноафриканское сообщество развития, да, или Анское сообщество, да, и наши интеграционные, да, проекты, Евразийский экономический союз и так далее, отражает свой цивилизационный тип. обладает
and
собственными
communities. So
историческими,
these
социально-экономическими,
developments
политико-правовыми
have
традициями,
their own
что, естественно,
political
позволяет
and
говорить
economic
об
traditions.
определенной
They have their own
индивидуальности и
topology.
неповторимости, я бы
That
даже так
means
сказал,
that these
невоспроизводимости
institutions are
того или иного
unique,
опыта
and it
региональной
it
интеграции,
is
в том числе
impossible
с
to
позиции
replicate.
роли
So
судебных
the
учреждений в
experience of
развитии интеграционных
integration in
процессов.
terms of the role
Поэтому
of
даже вот
judicial
вчера, опять-таки, в ГИМО
institutions in the
присутствовали там
development
наши
of these
выдающиеся действительно
processes
специалисты
across the
в области
regions.
международного
It
права,
was
это профессор
yesterday
Абашидзе,
that
профессор
Professor
Валиджанин,
Abashidze, Professor
профессор
Valijanin,
Войников,
Professor
Калининград,
Vonika
профессор
from Kaliningrad,
Клиниченко, Мгла Кутафина, Алексей Станиславович Исполинов и другие.
Professor
И вот опять
Kalinchenko
возникли
from
эти дискуссии
Kutafina and
относительно права
Professor
ЕС и
Ispolinov.
места, и
So they
специфики
entered
этой
into these
правовой системы.
discussions
Но
and
в
GIMO
конечном
as
итоге мы
regards
приходим к
the
выводу, да,
role of
что даже вот
law
это
and the place
конструирование
of
модели
courts.
интеграционного права
As a result of it, we
целостного
look at
такого
the
явления,
integration
она
law
пока
is a
не
comprehensive
может
phenomena.
как бы быть
So
действительно полностью
the
эффективной. Поэтому
model
речь идет
itself
только о
cannot be
конкретных
fully
моделях
fledged, and we
региональной
just
интеграции и в том
can be
числе о
talking
конкретных
about very
моделях
specific regional
судебного разрешения
models,
споров
very
между
specific
государствами,
judicial
субъектами
approaches to
интеграционного
the
так называемого
resolution of
права.
disputes
Вот только об этом,
between
учитывая
countries or
особенности и
member states,
цивилизационный
these
характер, и,
communities.
повторимся,
So
невоспроизводимость
given,
в таком
this
буквальном смысле опыта
specificity,
конкретных
given
региональных
this
интеграций.
unique
Спасибо большое
experience
за
of
внимание. Спасибо.
Огромное
integration
спасибо, Адель
processes
Сиярович,
across
за
the world.
столь масштабный
Thank you
рассказ
so
и
much for a
экскурсию
very
в
extensive
три различных модели с большим количеством
presentation and
очень
also
интересных
coverage
деталей
of
относительно
all the
деятельности этих
models for
судов.
providing
Уважаемые коллеги,
more
вопросы
details
Адели
about
Сиярович?
the operations of the supranational courts. I have a comment to make. So first of all, I would like to thank you for the very exciting presentation, and it coincides with my interest and the interest of my colleagues because of Professor Lishitz. So that's here's the book just about international justice as a way of integration, and it's a monograph that we should have published. So my question:
Вы знаете, пока, к сожалению,
read it?
такой
Have you
возможности
seen it?
не было, да,
Not
поэтому если вы
yet,
нам вышлите эту
unfortunately.
работу, то мы
So
были
we'll
бы
be
просто
very happy
счастливы.
to receive this monograph.
Спасибо вам.
Sorry. Thank you very
Ну,
much. I just
естественно.
wanted to advertise my
Right.
I have a question.
Понятно, что
A
прогнозы
very
в нашем
brief
деле это
question.
дело очень неблагодарное, да, в
Obviously,
нашей
as for
профессии.
projections,
Умение
I mean, you
все-таки
can
с
never
учетом
be
вот этого
very
глубокого
accurate,
анализа, в том
but
числе
given
цивилизационного
this
фактора, роли
in-depth
цивилизационного фактора
analysis of
в развитии того или иного интеграционного
the
образования,
development of
не могу не спросить,
integration
на ваш взгляд, каковы перспективы
processes and
деятельности Суда
formations,
ЕС и
I
его
would like to
вклада,
ask
возможного вклада в
about the
развитие
prospects for
интеграционного
EU
образования Евразийского
Court
экономического
of
союза.
Justice and probably
Спасибо
its
вам большое.
contribution
Действительно,
to this
если говорить о нашем
integration
евразийском
formation
интеграционном процессе, да, и, соответственно, тех
EU and
инструментах
probably
судебных,
Eurasian
которые там
Court,
присутствуют,
so the
вот
Eurasian
буквально,
Court,
я не знаю,
Eurasian
буквально
Court,
2 недели
and
назад
also the
на базе
mechanisms
Суда
that are
Евразийского
included.
экономического
So
союза
I would
прошел
like
тоже
to
очень серьезный форум,
say that
посвященный
2
также международному
weeks ago we
правосудию.
had a
В
very
разных
serious
аспектах
forum at
рассматривались вопросы,
Eurasian platform. In this
касающиеся
forum
обмена
addressed
опытом,
just
межсудебного диалога. Я вообще
an
хочу сказать,
array
что наш
of
суд, суд Евразийского
aspects
экономического союза, я
ranging
другого
from
названия подобрать не могу,
interaction
кроме того, что
to
это наш суд, да, это наше интеграционное, да,
interaction to
образование. Вы
integration. As
знаете, является
Eurasian
настолько чутким и
Court is
тонким,
our
и тонко
integration,
настроенным
but
инструментом,
it is a
включающим в своем
fine-tuned
составе прежде всего очень высоких
instrument
профессионалов,
that
судьи,
is
которые представляют,
composed
да,
of
два судьи, вхожих в
judges
Государственный
with the
суд, мы прекрасно
highest
знаем, механизм формирования
qualifications.
суда. Каждый из них
And
является очень высоким
each
профессионалом,
of these
который,
judges, as I
являясь
said, are very
судьей этого
prominent
судебного
specialists. They
органа,
have the
вместе
highest
с тем
level of
очень четко
qualifications. So
представляет те
they are
задачи,
members of
которые
the
стоят перед
judicial body. At
региональной
the same
интеграцией,
time, they are
которые
very
стоят перед Евразийским
well
экономическим
aware of
союзом,
all those
и
tasks,
используют все те
challenges
механизмы, которые
facing
предоставлены учредительным договором,
Eurasian
касающимися в
integration,
том числе определяющим статус
and also
суда.
they rely
Поэтому
on
в
the
этой связи я
founding
вижу и
chapter that
уже
also
имеющуюся практику,
defines
да,
the
и
mandate
уже
of the court. So I
та
see
практика,
that
которая формируется и будет существовать в ближайшее
this
время, это очень важно. Знаете, я
case
отмечу
law
такой
that is
момент.
emerging will
Если я
have
говорил вот сегодня в
a role to
выступлении о
play
роли суда
in the
ЕС, и в
future.
том числе
Right.
о
My
поддержке
presentation
представительского
today
сообщества,
was
да,
about the
академического,
role
национальных
of
судебных
EU
институтов и так
Court of
далее, то
Justice
вот
and also
также
the role
наш
of
суд,
national
суд Евразийского
institutions
экономического
and
союза, да,
organizations.
перед тем, как
And
вынести
this
какие-то
also
решения, да,
applies
очень
the
проводит
Eurasian
широкие
Court to
обсуждения,
our courts.
направляет
And before
эти
we reach
материалы
any
по ведущим
decisions,
кафедрам
we will
научным центрам России, Беларуси, да, Кыргызстана, Казахстана, Армении и так далее. То есть идет широкое обсуждение. Мы отправляем свои заключения экспертные, мы отправляем свои материалы, мы даем свое видение. Да? И вы знаете, я тоже хочу отметить, и другой есть вот этот инструмент воздействия эпистемического сообщества. Посмотрите на аппарат суда Евразийского экономического союза. Кто там работает? Молодые, талантливые, мотивированные, амбициозные специалисты. Я говорю, по крайней мере, у наших российских ребят, да, которые окончили МГИМО, высшую школу экономики, другие ведущие вузы. Да. Это кандидаты наук, защитившие диссертации, Кирилл Энтин, и другие там ребята, и Дьяченко, и так далее. Могу называть очень много, которые, понимаете, обучаясь в том числе по магистерским программам, другим каким-то образовательным механизмам в европейских университетах, американских университетах, да, в университетах Азии, они привносят вот этот опыт, да, в деятельность суда, да, работая над тем или иными материалами, да, выступая со своими позициями. И я вижу, как это воздействует. И когда наш суд Евразийского экономического союза говорит, а вот в практике суда ЕС было так, а вот Костайнель определил такой принцип, мы можем этому последовать. А вот в деле Ван Хентедлоу здесь был, понимаете, для меня это радостно. То есть мы видим готовность смотреть разные модели, мы видим готовность смотреть практику, мы видим готовность смотреть вот эти этапы развития судебной модели, которые мы должны пройти, чтобы достичь каких-то высоких результатов. Да, это сразу не возникнет. И как это происходит. И также отмечу, что идет очень интересный межсудебный диалог. И традиционным для нашего суда ЕАЭС стали встречи на уровне глав судов, в том числе судом ЕС. Кюн Леннертс — это большой гость в Минске, и, соответственно, наши судьи, председатели суда и замы судей, они очень частые гости в Люксембурге. Идет этот диалог, обмен опытом, обмен мнениями. Понятно, что без этого не обойтись. И, конечно, с этой точки зрения, мне кажется, что весь тот потенциал, который дается учредительным договором, другими актами, который в качестве базиса определяет суд ЕС, он позволяет им достигать многого, и, по крайней мере, вот те решения, которые мы уже имеем и можем комментировать, и есть достаточно большое количество литературы, показывают, что, на мой взгляд, и на взгляд на наших коллег, суд идет в правильном направлении. Поэтому я, по крайней мере, могу так оценить.
Большое спасибо, Андрей Ярович. Уважаемые коллеги, если нет возражений, тогда мы переходим в другую область международного правосудия. Я с особым удовольствием приглашаю Александра Петровича Евсеева, кандидата юридических наук, доцент департамента системы судопроизводства уголовного права, факультета права Высшей школы экономики, докладом «Сделки о признании вины в международном уголовном правосудии». Пожалуйста.
Plea in international criminal justice.
Thank you, Maria Anatolyevna. The topic of my report today is the so-called plea agreements in international criminal law. I would like to say right away that international criminal law, the main task is to reach international reconciliation. This reconciliation by judicial means, by means of international litigation, can be reached using two models. Model number one is the model of the so-called of classical adversary litigation, which we know since 1940s, which is closely related to the originators of international litigation. And this is why this model is called universal. The European National Criminal Tribunals, first generation and the second generation, I mean, International Tribunal on former Yugoslavia, International Criminal Court, third generation tribunal, work in accordance with the same Nuremberg model, where there's the defendant party and the accusing party, there's a court and there's the accused bench. People who are accused of international crimes such as crimes against humanity, genocide, acts of aggression, and the adversarial procedure is used to identify their guilt, and these can be both rank and file personnel, but also or the so-called big fish. The biggest example of this is the former president of Slobodan Milosevic, who was tried by the International Tribunal for former Yugoslavia. And then they're tried and accused, and therefore victims feel to some extent that the person guilty of the victim's suffering has finally been penalized, convinced to a certain penalty, and therefore the situation will never be repeated when the victim and the other person meet face to face, which was the case quite often in former Yugoslavia. After the International Tribunal for Yugoslavia refused to consider certain cases, many criminals fell out of the attention of this former court. And then national courts in Bosnia and Croatia tried considering this cause. One way or another, the Nuremberg model is the classical model. There are also the losers and the winners in that particular court ruling. And in addition to winners and losers, there will always be people who aren't satisfied in this Nuremberg model. Analysts, observers, and scholars who will always challenge the results reached during that court proceeding. I think that Professor Abdullah, who spoke before me, and Alexander Mirzaev can be used as good examples of this. Alexander Mirzaev criticized sharply the operation of the former tribunal of the tribunal in former Yugoslavia, all the way to a number of mistakes that were made by this tribunal in course of consideration of bigger cases. Such Serbian politician Milosevic and Lovašević. In the past years, where we live in a postmodern world, where there are no eternal truths, where everything can be challenged or ridiculed, we see more and more of the so-called South African model of justice take place. It's justice for truth. You buy justice in exchange for truth. This model was used at the international level when the South African Republic transferred to the democratic rule after apartheid in the late 1980s, the early 1990s. But over time, this idea that justice can be exchanged for truth, or rather, that certain evidence can be given in exchange for an amnesty, started to getting ground not only at the national level but also at the international level. If we look at the latest court sittings, the so-called special court chamber in Colombia, which was made on this basis of the Cartagena Agreement of 1980. Ничего не слышно. Judges from Peru, from Ecuador, from Argentina, from other countries offered a case when the friends of the court would have greater rights. The friends of the court were entitled in Colombia even to participate in the meetings of the judges. Only they didn't have a right to vote on a particular case or particular guilt of a person.
So in these court chambers, in Justice for Peace, the South African operation was also used. When the person accused of international crimes in the course of civil war in Colombia would tell most of the truth or all of the truth about the accused person, about this person's contribution, if I may, in the civil war in Colombia. But in exchange for that, the person would be amnestied, or at least would uh, or the possible conviction would be sharply reduced. So this mutually beneficial cooperation between the defendant and the accusing party. On the other hand, what in the Anglo-Saxon tradition is called bargaining starts to gain ground in international criminal litigation too. And in the most uh, clear form, the idea of bargain, the idea of pleas, the idea of exchange information is used in so-called plea agreements, which are known to the international criminal litigation starting from the 1990s. Back in the 1993, the Security Council decided to create the International Tribunal on the former Yugoslavia and to adopt its charter. And then later on as well, when the so-called rules and procedures for proofs for the former Yugoslav tribunal were adopted, the first judge of the court, as Argentinian said, remember later on, she produced from her bag the rules for procedures developed by American Bar Association, and she began aggressively insisting on adopting these rules. The rules and procedures that the judges adopted are to an extent are a copy-paste photocopy of the US rules on criminal proceedings. Researchers back then in the 1990s pointed out that Rule 62 of the Charter of the International Tribunal on former Yugoslavia is a duplicate of Article 11 of the respective rules in the US, which provides for such a plea bargain. Why do these plea bargains in international law have a wide ground? The reason for this is not only the influence of the Anglo-Saxon examples, or not the active position of Judge MacDonald during the establishment of this tribunal, because we need to point out that in 2003, these plea bargains were included in the Charter of the International Tribunal on Rwanda. Clearly, in addition to the influence of the Anglo-Saxon machine and yes, litigation machine, we can see at least a number of other factors why these plea bargains were included into the national litigation process. It is no secret that investigation in international criminal courts uh, uh, can take many years. The good example of this is the situation with Radovan Karadzic. Initially, he could not be found for 10 years or more. Then, starting from the early 0 years, he faced the International Tribunal for former Yugoslavia. Mhm. Uh, And last year, the second chamber convicted him to life imprisonment. And overall, this trial with respect to Radovan Karadzic started from the time he was caught and delivered to The Hague and all the way to the last year's conviction in second instance took about 10 years. As we all understand, 10 years, even for international criminal law, international criminal courts, is very long. And plea bargains are in compliance with the procedural economy. They help to save
resources, funds, time, both of the accusing party and of the defendant party, but also of the court, because it's quite clear that during large international military conflicts, be it in Rwanda, be it in Colombia, be it the civil war in Yugoslavia, the number of persons committing international crimes, including war crimes, is not restrained only to large ladies. Actually, basically, every person guilty should be punished. But if hundreds, maybe thousands of people were involved, how many human man years will it take for international courts to convict all the persons who are guilty? Guilty of various crimes. Furthermore, plea bargains are also widespread because they help to reduce the risk for uh, to, to reduce the risk of reducing the penalty for the accused person. Well, we see that the idea of these plea bargains is quite clear. I don't think I have to dwell on it for a long time. The main document here that gives us an impetus, gives the impetus to international criminal investigation is indictment. Previously, it was issued by the prosecutor. This indictment includes a number of paragraphs of which are charged to the accused. And with respect to all these paragraphs, or most of them, after the indictment is read out, although this plea bargain can be reached at later stages, then the defendant is offered to reach a plea bargain. After consultations with the client, the attorney can either agree or refuse such a plea bargain. In case it is agreed, they start negotiations to what extent, in what part, defendant would admit their guilt, and what bonuses, if they agree, they can expect. Usually, such compromises are reached not with respect to the entire text of the indictment, but probably only the most serious paragraphs. In case such a compromise is reached, it is recommended to stop criminal proceedings and to appeal to court to issue a softer conviction, a softer penalty for this person. But what is special about international criminal litigation, unlike similar plea bargains at the national level, is that, as I said, that the international criminal courts only deal with the highest war criminals, which cannot simply be forgotten after a plea bargain is reached, because uh, the purpose is to establish a historical narrative, but and overall, in order to overcome the national problems, national offenses that have been accumulating over time between the parties involved. Therefore, such plea bargains, such plea agreements have to comply with a number of other requirements which cannot be seen in the Anglo-Saxon right countries. For instance, a plea bargain reached the International Tribunal for former Yugoslavia have always been published. That's one. Two, they were always under control of the court. After the court would approve such agreement, the court tried answering the following questions. Has such an agreement uh, been reached voluntarily? Has the party been informed, correctly informed about the legal consequences of
admitting their guilt, which would manifest itself in the plea bargain. Whether the text of this agreement give an opportunity for any double interpretation, and indeed, is there a wide evidence base for the accused party to admit the crimes of which with which the person is charged? Because clearly, because the accused person is a weaker party uh, uh, in such a litigation, and sometimes the accused person can agree to a plea bargain out of because it would be afraid that otherwise it would not be able to take part in this lengthy and very expensive litigation at the international level. And only after the court is sure that this plea bargain is reached voluntarily, that the person understands all the legal consequences of this agreement, that indeed there's a wide evidence base that would prove that the person was involved in war crimes. And after that, the International Tribunal can approve of such an agreement. And briefly, without abusing your time, I would like to focus on the problems that arise in view of this institute of international right. Clearly, international criminal process, which is influenced by the Anglo-Saxon models, does not establish the material truth as how it happened uh, in, in fact, but establish rather the formal truth. Establish the evidence provided by the defendant by the accusing party. Uh, and the standards of providing evidence in various countries are different. But overall, we're talking here that we should be proceeding from the standard of beyond reasonable doubt here. So in this case, the courts only establish formal truth. They think that that the truth is what they think is truth, based on the evidence provided on the standard of proof, uh, which the judge thinks apply. But the purpose here, not only to punish the guilty person, but also to establish a certain chronicle of what has been really happening in the course of a particular military conflict. Therefore, what can be considered, where parties can reach a consensus on admittance of a guilt, can also be legitimized at the level of the community from which the accused person comes, or can be legitimized in the eyes of the public opinion. Because people can believe that the accused party was simply willing to make its life easier. Second, in the first years of the international tribunals, not all attorneys understood the legal consequences of a plea bargain. And all the handbooks on international criminal law uh, describe this jealous status. He had this Serbian attorney. He was a Bosnian Serb. He was charged with genocide in Srebrenica, and he agreed to a plea bargain. Well, he was certain that despite he admitted the guilt, uh, further court litigation would continue. So, uh, like it always happens at a national level, because admitting guilt, as we remember, cannot be considered the only and the satisfying, uh, cannot be the sufficient evidence that the person is guilty. And he was quite surprised that after he admitted his guilt, uh, uh, he was charged. So, very briefly, the most important points related to the international plea deal practice. So I'm exceeding my schedule already, so I'll be happy to answer your questions.
Ну, собственно, работа с вопросами у нас как раз, я думаю, сейчас,
Right.
потому что
I
мы
think we
действительно
can
немножко
answer questions
выбиваемся,
right now,
и нам еще нужно
but
итоги. И, Александр
unfortunately,
Петрович, я тут
see
не
the
могу не
schedule.
спросить, потому что у меня тоже вопрос
Alexander,
возник.
I
Как вы
think I
думаете,
must
вот
ask you
все-таки
one
перенос
question.
таких национальных механизмов
Transferring
на уровень
such national
международного
mechanisms
уголовного
to the
правосудия
international
не
level
выхолащивает ли саму его
doesn't
суть?
it make the
Поскольку
entire
речь идет не об
idea
обычных
hollow, because
преступлениях,
we're not talking
которые
about
рассматриваются в национальных
ordinary
правопорядках.
crimes
Все-таки речь
considered
идет
at
о
the national
преступлениях,
level.
которые не имеют сроков
It's
давности
about
и по
crimes that
масштабам своим не
then
имеют в себе
cannot
ничего
expire and
похожего, да,
with
в
respect to their
национальных
scale
правопорядках.
can
Поэтому в
then
данном
have a
случае
precedent at the
не
national
жертвуем ли
level.
мы,
So aren't
собственно,
we
неотвратимостью наказания и понятием
losing the
справедливости и
fact that
возмездия при заключении?
we're talking about justice? Yes, thank you. 2 points here. The first point is that the international criminal litigation, there were sources for rules and procedures and legal norms. Then the source was the national level law, and it was in particular typical for international courts was certain competition between various legal and procedural systems. Which system at the time where the rules and procedures were developed for a particular international court at a later stage as well, uh, as legal practice was accumulated. So which of the systems would preside and would be able to lobby as many norms as possible? When we talk about international procedural laws, we should remember that we're not talking only about Anglo-Saxon law or US law, but basically about procedure mechanism and that are uh, 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 and that happen everywhere from US, Canada, even to Australia, and to a certain extent even in India and Israel. Therefore, then in the early 1990s, when the tribunal in former Yugoslavia was established, this Anglo-Saxon influence was quite strong. But then, several years later, when the rules for international criminal court were developed, many institutions were criticized or corroded. If we look at the Roman Statutes of the International Criminal Court, we will see that a number of norms there, a number of rules there, have undergone a certain transformation. For instance, litigation at the National Court for the former Yugoslavia, for Rwanda, didn't have a situation of the Chamber for preliminary proceedings, which would consider whether the evidence provided by the parties is reliable. Mm. For tribunals on Rwanda and Yugoslavia, this was simply impossible because there the chamber would work uh, and no connection. Mm. So this did not exist either with the Yugoslavia court tribunal or the Rwanda tribunal. So therefore, these rules have been changing. The continental law countries have taken more influence, and these institutions will transform over time. But the persons who designed the charter of the tribunal from Yugoslavia and Rwanda wanted to use the data bank, all the rules and procedures that had existed since 1945, that had not been used since 1945, since the tribunal for Tokyo and Nuremberg. The models that were clearer, that were
Большое
more
спасибо.
widely
Уважаемые коллеги, мы должны
advertised,
закончить в час.
finally were
И
used. Dear
исходя
colleagues,
из
we have
этого,
to
поскольку у нас еще
thank you
подведение
very much.
итогов,
Dear
я
colleagues,
бы тогда
we
хотела
have to
отложить свой
wrap
доклад,
up
потому
at
что не успеваем уже мы его,
1
не успеваю его уже огласить. Но обещаю
p.m.
опубликовать
So I think I will
что-то по этому поводу,
transform,
потому что уже у меня
postpone my
такое
report to a
желание,
later
мысли по этому поводу
stage,
есть.
but it will
И
be
Ханар
published.
Рашадович любезно
So
согласился подвести итоги нашей
Al
сегодняшней дискуссии,
has
которая
kindly
была
agreed
очень
to
разнообразной,
sum up
охватывающей самые
the
различные
results of this
аспекты
discussion.
мирного урегулирования международных
It
споров.
covers various
Поэтому Ханар
aspects
Рашадович с
of
удовольствием
amicable
предоставляю слово вам.
settlement of international laws. So, Mr. Ilshadov, you have the floor.
Мы вас не слышим, не слышим, не
We cannot
слышно,
hear
не
you.
слышно.
We cannot hear you.
Да, опять почему-то звук отключается.
Yes, you know, the sound
Реагирует на мой голос.
switches
Я
off.
хотел бы... Сейчас слышно?
Can you hear me now?
По-моему, уже слышно должно быть.
I think you
Слышно,
should.
слышно, да, конечно,
Yes, we
слышно.
can hear. Yes.
Да, я хотел бы,
So,
во-первых, поблагодарить
first of
за
all, I would
очень
like to thank you for this very insightful discussion,
благодаря
and I would like to thank you for selecting the speakers and
сообщений,
structuring
сегодня услышал.
the agenda properly.
Я бы хотел бы довольно вкратце сказать.
I would like to be very brief.
Отметить,
Well, we should point out that when I was listening to Mikhail Galperin, I thought that ever since I started working with my university, I had to deal with a particular regulatory norm that was prepared at the Ministry of Justice. And I saw that the Ministry of Justice was playing a very positive role. And this is happening owing to the role of the Ombudsman for Human Rights. They not only initiated these amicable agreements, they also, quite interestingly, do their best to prepare, to initiate draft laws. This was the case from the very first days. For instance, these metallic cages were taken out of courtrooms, or other legal acts were also adopted. And these are quite an important part of the operation of the ministry. So, what I want to say is that we would like to welcome the fact that the court does this. I witnessed many court hearings where the court would adopt special declarations, or where the court would reach a settlement between the parties in accordance with the existing rules. Unfortunately, I cannot hear
Да, очень
whether
хорошо, мы
I can see
слышим,
whether
да,
you can
все
hear me.
внимательно слушаем.
Да, и тут, конечно, очень важно сказать о чем.
So, it is important to mention here that, you know, I was writing an essay on implementation of rulings, and I saw an article of an Italian scholar. He commented on the Pinto law, I believe, about lengthy procedures. This law was used to make the appeal instance of the Italian court to accelerate these procedures so that compensations can be paid before the laws were changed. And he saw that there was a budget shortage as a result because it was initially the cost was 150 million euros and the amount would grow, so this was not resolved. You know, so when we see the Bormich case, we should admit quite frankly that this is outrageous. On one hand, we saw there's a whole stream of these complaints, and the court does its best by using the procedures to reduce the number of complaints. But in fact, the court has to strike a reasonable balance, a proportion, because the citizens do have a right to appeal to court, because this was the idea of the Human Rights Court, to consider complaints so that complaints would not be rejected. So there was a reasonable reaction to such a decision to reject the complaints. When I worked as a judge, uh, uh, I saw a number of cases where we would not understand uh, what was offered for settling a case, because the violation called for a certain court resolution, because it had to bear the educational component, or particular actions had to be undertaken. Furthermore, I have to say that I welcome the expansion of the rights of the Human Rights Commissioner. This will happen when the presidential decree is published. This is very good. Secondly, I would like to refer to the excellent contribution, excellent speech, although I liked all of them. So I would like to refer to the report by Mr. Adel Abdulin about international courts. You know, the process of establishment of international courts, we're not politologists, we're not political scientists, but we know that it depends on many processes that happen worldwide. There was a time when these resolutions were adopted on a wider scale. Now this has stopped. But this depends on civilization clashes and other political processes worldwide. He said very well about the role of these international courts, but the most important role, which he also described, is to what extent national courts and their solutions would be using these resolutions and would be referring to them in offering their arguments, and to what extent they would enforce, and to what extent they would teach about it. Because we cannot compare them directly. We cannot say the role of the courts of the European Union is as strong as the role of our local courts. Because when you talk to a lawyer from any level, you see that they first refer to the law of the EU. You would not be able to talk to that person referring to the laws of Italy or another country, because they would always refer to the laws of the EU. So this should manifest itself in the level of education offered at the university. And last but not least, the role of international courts that Mr. Alexander Zevzev has mentioned. And here we talk about the standards of proof. I wouldn't say that general right had a negative influence on international practices. I would look at it from a different perspective. We should be say to what extent this general right played a progressive role. We should not try to establish a clash, a conflict between the two types of rights. You know, a short time ago, I was dealing with the problem of a role of national courts, and when I looked back into the history, in the way the courts developed, we saw that courts developed owing to general law. This continental system was established in the late 18th or early 19th century, when court college started to change. Furthermore, the International Criminal Court was established at a later stage. So it is better regulated with respect to processes for offering evidence. We cannot compare it with the court that was established before the Rwanda tribunal. So I think that this is where the integration will play a major role. But most importantly, this idea of integrative and comparative interpretation of law. And in this respect, the role of international laws has yet to be researched. This is up to us to promote it, to research it, to recommend it in our publications. Overall, I would like to thank all the participants of today's roundtable and to say that indeed, as I was listening to you, enjoyed it very much. I would like to thank you, Ms. Maria Filatova, as the co-organizer of the conference. Thank you very much. Thank you.
Спасибо большое всем спикерам.
Thank you very
Насколько я
much.
понимаю,
I'd
запись
like to thank all the
будет,
speakers.
на YouTube идет запись, и она будет выложена, запись всех материалов
The recording will be there.
И,
Everything will be
Тимур
recorded on
Викторович, тогда я
YouTube.
передаю вам
And
бразды правления, дальше ждем инструкций, как дальше. Спасибо
Timur,
еще раз
I give
огромное.
the floor over to you. Thank you. Ms. Maria Filatov, thank you very much for giving me the floor. I would like to thank the organizers, the speakers of the conference who made very interesting and very insightful reports. I think that the topic related to international law has been sufficiently covered in our conference, and the conference participants will be able to draw parallels between the national and international laws. Dear colleagues, thank you very much for your fruitful work, for making this conference so good. I cannot help thanking you. I think I'm obliged to thank Maria Filatova, who, as a member of the program committee of this conference, has organized and moderated the session, and she's performed so well. Thank you very much, dear Maria. Esteemed conference participants, so we're going in accordance with the schedule. We now have a lunch break. We have been working since 10 for the past 3 hours. I think we deserve a right for a snack. We will resume our conference at 13:30, and we will start working on session 6, institutional organization and legal regulation of conciliation procedures. I hope that the number of participants will remain as it is now. I would like to thank the listeners who joined us on our Zoom conference and those who are listening to us on YouTube. Dear conference participants, thank you very much for your attention to our event. After the lunch break, we will resume it. Thank you.
Спасибо.
Thank you.
Спасибо, всего доброго.
Thank
Приятного
you.
аппетита. Всего хорошего.
Спасибо большое. До свидания.
Госпожа Полонский, добрый день. Мы рады вас приветствовать. Евгения Павловна, добрый день.
Добрый день, Тимур Викторович. Также приятно вас видеть.
Очень.
После обеденного перерыва.
Надеюсь, это будет приятное послеобеденное развлечение, которое будет не только приятным, но и полезным. У нас последовательность докладов отражена в программе. Если мне память не изменяет, у нас первой выступает Наталья Ивановна. Добрый день.
Отлично. Добрый день, Тимур Викторович. Добрый день, Евгения Павловна. Это вы у нас сегодня модерируете. Я видела. Большое спасибо за приглашение принять участие. Вчера, к сожалению, не могла полноценно все послушать, но то, что услышала, уже буду использовать в своем докладе. У меня есть презентация, она такая немножко провокационная, но я надеюсь, что она запомнится, если можно ее продемонстрировать.
Я думаю, в качестве застрельщика и вы, и ваши презентации будут более чем уместны. Коллеги, я бы хотел обратить внимание на программу и как раз проговорить до начала официальной работы. Вопрос организационный. Последовательность спикеров приведена в программе. Вот. У нас Наталья Ивановна и госпожа Полонский, вы сами будете транслировать презентации или нет?
Можем сами, если функцию демонстрации. Сейчас, минуточку, тогда отключусь. Демонстрация.
У нас все возможности для этого есть.
Ну прекрасно. Тогда я сейчас в PowerPoint зайду, секунду.
Для меня тоже, как вам удобно. То есть я могу, в принципе, свой экран просто дать и все.
Угу. Давайте таким образом поступим.
Хорошо.
Вот. Хорошо. Так, коллеги, 30 минут предлагаю начинать.
Добрый день, уважаемые коллеги.
Good afternoon, dear colleagues. I would like to welcome you to this final session of this excellent conference. So unfortunately, it has been organized online, but at the same time, we gained a lot through this mode of communication. So we have listened to just different speeches and presentations that raised many unexpected even points that relate to reconciliation and mediation. So there are many things to think about. And our concluding session will be about institutional organization and regulation of professional activities for reconciliation. Obviously, we will cover many sectors and areas in this respect. So we may have also some provocational statements, and probably they will be followed by very active discussions, some theoretical or practical considerations. And I would like to give the floor to Natalia Ivanovna Gaidayenko so that she would deliver the first presentation. She is Senior Researcher Division of the Civil Legislation of Foreign State of the Institute of Law and Comparative Legislation of the Government of the Russian Federation. So she's an eminent academic and also a highly professional reconciler, mediator with many years of experience that is well known both domestically and internationally. So she will be describing functions, training and specialization and ethics of professional conciliators. So thank you very much. And I would like to share my screen now.
Будет более удобным.
Вот почему я выбрала эту заставочку.
Right. So this, why I've chosen this, because conciliator is in the midst of conflict. So whether it is institutional or appointed person, or if he or she is chosen by the parties. So, there's even fingerprints on the face that we can see. So, personally, this person has been subjected to some aggression by conflicting parties, but at the same time, managed to keep his face to stay safe and sound, just jokingly speaking. And now, seriously, we would like to first address the terminology. So, reconciliation is not equal to mediation, in my view. So, I took two definitions that were elaborated by retired judges. So, GEMI as one association, European Commission for the Efficiency of Justice, that set up ad hoc mediation group, and that group produced just a brilliant guidelines for mediators, lawyers, and also a handbook for judges on how to conduct reconciliatory proceedings. So, when we look at reconciliation, so we discuss, the pros and cons, and Olga Shevenyova and Tamara Abova was also mentioned because she described reconciliation and mediation as two different things. So what's the difference is about? It is about this expert component. Okay, if we look at the GEMI, so they believe that reconciliation is non-formal confidential way of dispute resolution, either mandatory or optional, which is conducted by an appointed third party, a conciliator that is impartial, neutral, and independent. And then the conciliator can also suggest a dispute resolution whether the parties fail to do so. And then we have another definition from the European Convention, and then it has a broader definition. So it does include confidentiality and an impartial third party, and also the right of this third party to make a suggestion or proposal without any binding effect as regards resolution of dispute. So this, to me, what important that we look at legal facts. So, and these legal facts are reviewed by a professional lawyer at the same time. So, also opinions of the parties are taken into consideration, are analyzed, and then a professional expert will suggest some ways to resolve their conflict. Reconciliation, and there are four approaches. So these come in different colors. So first, quasi good, so that services and bona fides such as facilitation and organization of negotiations when the atmosphere of confidence is being created so that party can quietly participate and talk to each other. Next, it's a quasi mediation that is based on the definition that has been adopted by domestic instances. So these are a quasi-integrated mediation. So it is integrated into the court proceedings, but uh, mediators will not be members of the court personnel or um, acting judges. So, and there is a certain requirement because if we compare mediator with conciliator, then conciliators do not have this requirement to undertake training because conciliators would be a retired judge that expressed his or her readiness to help the court and to help the parties to reconcile. And there is another approach which is quasi-friendly intermediary. So we are talking about an expert that will evaluate the two positions of the party and then come up with a suggestion as to how to resolve their conflict. And that's the strictest way. That would be quasi and court adjudication. So in that case, a conciliator will act as a judge because it will include the analysis of legal problems based on the case file. The conciliator will also voice his or her opinion regarding the positions that the parties taken in this dispute and also the legality and of their requirements. So if we look at common features of reconciliation mediation, the procedure, confidentiality, that's impartiality and independence of the third party, and that the absence of the right to impose a decision on the party. So conciliator has no right to do that. And this is the main achievement of the Singapore Convention because it reconciled the professional parties that insisted on mediation as the sole tool for dispute resolution, because after that convention was adopted, we see that reconciliation can be used as well, whereas reconciliation expert has no right to, as I said, to impose any decision on the parties. And that because the parties have to retain their autonomy as regards dispute resolution. So they should resolve their dispute the way they find it advisable or appropriate, so they can listen to the suggestion that has been put forward by a conciliator, or they may take their own decision so that the parties autonomy, the autonomy of their will. So it remains to be a key driver for reconciliation as well as for mediation. So conciliator and their role in procedures. So it's more of giving direction. So conciliators would be lawyers, and when we look at the regulations that exist in many countries, and including Russia. So conciliators will be appointed or approved by the court. In Belgium, for example, an expert, a court-appointed expert, can be then assigned to reconciliation. Though the parties may voice their suggestions or they put forward their candidates, so it is up to the court to have a final say, and they will decide on who will be conducting reconciliation. Next, the functions. So that's just providing services based on a. So if we look at mediator, so mediator will be providing services based on the mediation agreement. If we look at reconciliation, so the main function would be reconciliation as delegated by the court. So reconciliator will be acting as a voluntary aid to the judge, and then in the process of reconciliation, so reconciliator will be in charge of the process, and they will also make the legal assessment of the views of the parties, plus conciliators will be consulting each of the parties on their matters, but at the same time, conciliators must remain impartial and unbiased towards the parties. Next, restrictions or requirements. So some qualifications are required expertise as well. So to become a conciliator, a person needs to be a lawyer, to be a competent lawyer with good soft skills, so knows how to communicate with people, and the conciliator should know how to help people to enter into dialogue. And at the same time, she should also know these cultural features of the parties that they're working with, and also conciliator should have very high moral integrity, and all the judgment needs to be impartial and objective and trustworthy. So as for official positions, so conciliators shouldn't occupy the job post related to the administration of justice, and conciliators have no financial interest in the outcome of dispute resolution. Now we want to talk about training and specialist activities. So there is no statutory requirement for training of conciliators or mediators, no requirement for raising their qualifications. And I disagree. I mean, I don't think that is an entirely correct approach, because when we look at the functions performed by mediators versus conciliators, so their functions are similar. Even in the regulations, they use the functions of mediators. So that means that conciliators should have a very good ability to implement soft skills, communication skills. So there's something to be learned, and that some training is needed. And this is the example, by the way, that I took from France, the French regulations from the Ministry of Justice, because their idea is now to enhance the role of judicial conciliator in court proceedings. So in France, for example, conciliator can be a retired judge and any other legal professional. So a conciliator would be appointed for a district by a local court, because local court are responsible for keeping the register of conciliators. So, and then prior to the appointment, it is important to go through the training. So for 2 months, an aspiring conciliator would accompany professional conciliators that attend case hearings in courts. So after this 2 month period, feedback will be given, and if this feedback is positive, is the person is the right person for reconciliation, then he or she will be approved and then start their work for 1 year period of time. So after this 1 year of activities, then his mandate can be extended to 3 years, up to 3 years. So, and before that first stage, training is compulsory. And by the way, reconciliation is a non-paid volunteering job. In Russia, it is a paid job. And I believe so we could provide for some basic training and qualification requirements, probably the years of experience, and it is reasonable once people are going to be remunerated for their service. So they need to have, they need to possess the appropriate knowledge and skill. So, and what I like most of all is the feedback, so that this feedback is maintained. I mean, in France, and local courts also keep the register of conciliators. If we look at ethics, again, I borrowed from the French experience, and these are 7 points. I mean, probably nothing new to you, but many of these points, I mean, can apply equally to mediators, conciliators, arbitrators, and we have this point number 7 that make them equal to judges, and even emphasizes their role as part of the court personnel. So first, they need to be honest, independent. That's a second principle. So, and to be capable of resisting any pressure. Principle number 3, impartiality. Number 4, neutrality. Number 5, so keeping information confidential. 6, be diligent, and 7, so be be very cautious in their statements, not in order not to undermine trust and confidence in the court system. So this principle number 7 is similar to the principles that are enshrined in the Code of Ethics for Judges, and this is different from mediation because mediators are independent from the court as a rule. As a rule, so the mediators may get some referrals from the court, but uh, in general, mediators are out of the court system. Meanwhile, conciliators, they are part of the court, considered to be part of the court personnel. Therefore, they need to follow this principle of maintaining judicial integrity as well. So yesterday, but many questions were raised, and some of them are covered in my paper that has been published in the arbitrations journal. I explained. So this is a system of training. It is mostly meant for mediators, and it also explains that register is important, and instead of this uniform public examination, we need a training program to be able to select the most adequate people. And in my mind, there is a difference between mediator and conciliator. So conciliator is a lawyer acting within legal bounds, and then some defamation, also professional defamation, uh, can be mitigated by techniques, communication techniques, and soft skills that are used by mediators, because and that's the bottom line of my presentations. I would like to thank all of you to send this beautiful photo as a sign of my gratitude to you for listening, and I hope that I receive questions about my presentations. That's true. So when we look at the judicial conciliators, and we clearly see this difference between conciliator and mediator. So, you know, as a moderator, I would like to ask you, because you are writing papers, but at the same time you are a practicing specialist. So my question to you would be as follows. All these global results of judicial reconciliation are not that significant, but it is in place, and some cases have gone through this procedure. So if we look at it in its current form, I mean, is it aligned with the concepts that you described? Obviously, I don't have competence, I think, to make a comment on the system, because I look at media reports and I receive messages from the All-Russian Association of Lawyers. So, and they write that it was with the assistance of judicial conciliator that the parties agreed to do the following, but didn't know what was exactly done and what techniques were employed. And probably it is advantageous because mm, conciliators are retired judges. So retired judges are usually supported by the court, and therefore the parties would be very reluctant to make an opposition to conciliator. On the one hand, it is good; they will not contradict the conciliator, but on the other hand, so the parties will try and stick to the opinion of this authoritative conciliator. So it will be more about case resolution rather than settling the dispute. The, this very mechanism the mechanism the appointment procedure leaves much to be desired. And I emphasize that conciliators, are assigned at the local level. Register, reconciliation register is also kept at the local level. I mean, in France, and I believe that, for example, for instance, when a person works for many years in the court system, probably the locals would know him better than the higher instances, such as the Court of Appeals. And another important thing is feedback. So you will have a conciliator say that is very efficient, probably by word of mouth. You will know that people will increase the number of referrals, saying, okay, that's a great conciliator specializing on certain types of cases, say in child disputes or rental conflicts, so that just he knows this inside out, will explain to you all, and you'll be able to settle very quickly. So thank you very much. And now I'm just the strict keeper of the time limits, because we didn't mention it in the beginning of our session. In fact, it is 15 minutes that we have for each and every speech and presentation. So all topics are quite interesting, and I would like to invite you to stick to your time limit, and it would be even better if we have time for questions and answers after this session, because these are very topical questions, and we receive messages in the chat box. So we've just received a comment from Ludmila Karnozova. So that says that will bring forward a discussion, because terminology is a very debated aspect, and what kind of reconciliation, and then how to discuss the terminology. And I think we will further exchange our views during our Q&A session. And I suggest we move on. So, and I would like to give the floor to a good friend of ours from Austria, Rima Polonsky, who is the head of the Russian-Austrian Mediation and Law Center, Vienna, Republic of Austria, and her topic, legal regulation of the status of mediator in Austria.
Good afternoon. Can you hear me? Yes, we can hear you. Right, very well. I will share my screen now. I hope you can see it. Let's begin. I don't have to introduce myself. I have introduced already. So slide number 1. We can skip it now. All right. Who am I? I'm a certified mediator. Who's a certified mediator? I'll tell you a bit later. I'm a lawyer, and in addition to mediation, I also do consultancy. And my topic today is, like we heard, is special figures of legal regulation of mediation procedures in Austria. The most important role is family mediation, divorce mediation. Most mediators work in this area. And probably like in other European countries, in Austria, mediation in commercial disputes only became relevant with a 10-year delay. About 10%, 15% of mediators specialize on the commercial mediation. Others work in the family mediation sphere. A bit later about it. Mediation itself in Austria falls into the area of notary publics, attorneys, consultants, psychologists, and auditors. There are former judges, retired judges, who work quite closely with mediation, but based on my experience, these are judges who in the past also dealt with family right, family law, and they deal with family mediation at the moment. Divorces, partings, etc. Austria is one of the few countries where the mediation profession is on the list of the jobs. Starting from 2003, there's a federal law on mediation here, which regulates training mediation requirements to certification, to the academic status, and so there's also a list of certified and registered mediators at the Ministry of Justice. In Austria, there's a serious confusion in this respect too, because there's a lot of mediators who worked before this list was introduced. And the idea of mediation itself is not protected. It's not like an attorney. You cannot call yourself an attorney. You cannot claim that you're a certified, a registered mediator, which means that practically anybody can act as a mediator. The conditions for registration. So far, in accordance with the law of 2003, it has to be a person with at least 28 experience of the age, with professional qualification, has to have a training of at least 18 months, which includes practical parts and the theory. Quite close, quite tight schedule of education. First 6 months, quite tight schedule. Then the second and third half years, it's a bit freer, but still it has to be 18 months. There's a special curriculum which you have to have had for registration. There are mandatory topics that have to be covered. And there's the practical part, the supervising part. And meetings of mediator groups that share their experience and tell about the cases they had. Then an agreement has to be signed for professional liability up to 4,000 euros. I don't know of any cases where mediation could inflict such a harm, but still, if it happens, then the insurance company will pay this. And furthermore, you have to have a venue, an office where you need to work for mediation. As for residence permits, this is not mandatory. Maybe this may be a lawyer from Germany or from Slovenia, from Slovakia, or from any other country who passed had this training and was registered with the Ministry of Justice. Now, difference between registered and unregistered mediation is strong in some cases, not so strong in other cases. But overall, if mediation is carried out by a certified mediator, then the expiration would discontinue. Mandatory mediation can also be carried out by a certified mediator only. In case of family disputes, the first meeting, the court can only refer you for the first meeting only to a certified mediator. How does this look in the commercial court? In practice, it looks as follows. Quite often, judges refer to it only at a very late stage, not in the first meeting, but let's say 5 hearings have passed, and then it occurs to the judge, why don't send them all to mediation? And then in some of the hearings, 2 mediators appear on the left hand and the right hand part of the judge, and they start telling about mediation. At this stage, based on my experience, nobody would turn to mediation anymore because they're so deep in their conflict that they don't want to deal with mediation at all. If it started at a bit earlier stage, if people were educated, were explained that it would be a good idea, because litigation can take indefinite time in Austria, then parties would be more ready. But the judge community doesn't show that they understand it yet. There are certain conditions, preconditions, the law for people to turn to mediation. For instance, there's a subsidy from the government to carry out family mediation. But it can only be carried out by a certified mediator in this case. So there's a certain incentive on the part of a legislator. That said, mandatory mediation is a mediation between neighbors. The rest are just options. Then it is possible to legalize agreements that have already been reached. So basically, this judicial mediation agreement is basically an amicable settlement, which you can certify in accordance with paragraph 433A of the Civil Procedure Codes as a written mediation agreement and can be enforced without any further appeal to court. The difference in terms of enforcement of agreements concluded by certified and non-certified mediators does not exist. There is no paragraph on mandatory enforcement of an agreement that were reached in a situation like this. So it can only be enforced by reaching an amicable settlement during judicial proceeding or in pre-court proceedings. The procedural code then provides for any differences between certified and non-certified mediators. After the directive of the Parliament and the Council of My Defender Affairs 2008 came into force, requirements to mediators were unified. The directive aimed to reduce the time it takes for court hearings, to improve the work, to reduce the expenditure of the client, and to simplify things overall. In practice, in commercial courts, for instance, or in family courts for that matter, it is only a recommendation on the part of the judge. There's no mandatory requirement that mediation be involved. Still, this law, this directive, did have some consequences because a European law on mediation was adopted. It has been there since 2003. So European law on mediation is enforced in parallel with the Austrian law on mediation. And the European law on mediation is a practical copy-paste of the directive. As a result, there are three types of mediation in Austria, which does not simplify our lives. A mediator without a registration, a mediator inside the EU without a registration, and a mediator that works based on certificate, which tends to be quite interesting in terms of confidentiality, because certified mediators with the registration have to observe confidentiality. This applies to civil and criminal procedures. Mediator under European law on mediation must keep confidentiality based on the wish of the client, but cannot keep it as part of the criminal proceedings. But in civil proceedings, uncertified mediators can refer to their statement as a witness. I can say that they can violate the NDA with their witness statements. So you can see there's a lot of confusion because there are three laws that work that don't cross but still are valid in parallel. Furthermore, the Minister of Justice list includes more than 3,000 mediators, but only 500 to 600 work throughout Russia. The operational language, for instance, I see that Russian, for instance, is not on my list of operational languages, but still I have a status of the interpreter. This is true. I have the status, but my language is not specified. So in theory, I know the language, I cannot work with it. At the same time, Russian language is stated for 10 more people where I know they don't know Russian. Well, this means that this list is not too informative, not too accurate. The message of the legislator was good enough when this was created, but the fact there are mediators without certification makes certification a bit absurd. The fact that European mediation with limited context makes everything even more confused. So it's all very complicated and unclear. Mediation becomes an interesting fact, an interesting tool when there's international context. As long as it stays inside Austria, if it's family mediation, it is in demand, it is interesting, and indeed it does make sense to turn to a mediator as part of the proceedings in Austria because limits discontinue, and so there is a possibility to reach an agreement. I don't know how court proceedings take place in Russia. In Austria, it's like this. The first today is the first meeting, then 6 months later another meeting, then 6 months later another meeting. Then something happens, somebody couldn't attend. 6 months later, yet another meeting. So the first instance takes 1.5 to 2 years, which is an absolute standard. Then somebody appeals against it, and we have 4 instances, of course. So 6 or 7 years later, the person arrives to the Supreme Court. If the person is not lucky, then the Supreme Court will simply refer this to reconsideration. And the person was not divorced and still not divorced, and the person didn't get any alimony. The person hasn't been able to share the property, cannot see the child, etc., etc. So it does really make sense to turn to family mediator. As for international context in Austria, with international transactions, for instance, Austrian courts have not been able to cope with them at all. Suffice it to say that it is unacceptable for business because the transaction becomes obsolete, outdated. So this does not clearly contribute to development of business relations. And expectations of Russian businessmen with respect to accelerated resolution of conflicts cannot be justified in Austria at all. It all begins immediately at the stage where you need to explain the gist of the problem. I don't know whether this is relevant for Russia. It is highly relevant for Austria. All which is related to international issues is a problem in Austria, a serious problem. This is why most people turn to arbitration tribunals. Arbitration tribunals are slightly, or commercial courts are slightly different. Okay, 1 minute. I'm talking here about commercial courts. So in in business, businessmen quite often agree that they'll be referring to commercial courts. This can bring my presentation end. I hope that it will cause some discussion. I hope I will be able to participate in this discussion. Thank you for your attention. Yes, thank you very much, dear Rima Polanski, for speaking so openly about the problems that are there in Austria. And we realize that these problems are quite relevant to us as well. And we will ask you more questions during the discussion about the issues that you have. And we'll probably be able to take into account these pitfalls and to avoid them in our federal laws. So this will be a very valuable contribution, very valuable experience. Unfortunately, we have a very tight schedule. Therefore, I have to offer to my colleagues to postpone the discussion for the post-session time. I'm convinced that this discussion will be quite heated and quite deep. And now I would like to introduce to you the next speaker with a very interesting and out-of-the-box discussion of problems of code of ethics as uh, uh, during the labor disputes. I'll give the floor to Ekaterina Batusova, candidate of law, assistant professor of the Department of Theory of Law in Interdepartmental Legal Disciplines, the Law Department, Higher School of Economics. You have the floor.
Thank you very much. And I must say that all the speeches and presentations have been very interesting to listen to. And I would like to share my presentation. So I've just connected. If there are any technical problems, please let me know. All is fine. So we can see your slides and
Презентацию видно, все в порядке. Можно дополнительно раскрыть экран, окно.
If you want, you can enlarge your screen. So I'll try, and unfortunately I had to just change my location very quickly. So apologies for this slight delay at the very beginning. And back to the topic, and thank you very much for announcing its title. Just I know that there are many speakers on our program, and they also have important ideas to share with you. So we are talking about the Code of Professional Ethics, and mediators act as a source of regulation. So if this is adopted as a normative, as a local normative act for self-regulating mediators organization. At the same time, the Code of Mediation Ethics will contain provisions that are sometimes inconsistent and incompliant with the requirements of federal law 2010. So the legal status of the mediator also varies from one organization to another depending on its code and rules. So this code functions can be either limited or again broader. And we believe in order to increase the number of job responsibilities, so we can stipulate a provision in accordance with the trade legislation or with the labor legislation of the Russian Federation in order to ensure the rights and of mediators as employed people. So we see that there is no clear definition of neither rights nor responsibilities for mediators. So this question or this point should be brought to attention. And if we look at the existing legislation, then again, it doesn't specify the status of mediator. We look at the labor code and also at the decree delivered by the Ministry of Employment and Social Welfare of 2014 in Russia on the approval of professional standard as a specialist in mediation. And there is also a letter from the Ministry of Economic Development that says if the employment agreement is signed or is entered into with a mediator, then the mediator need to provide the documents in accordance with Article 15. And for those that act in the so that's for those that do not act in professional capacity, they need to rely on Article 15, and those acting in professional capacity, they need to again do it in accordance with Article 16 of the respective law. And also, it is a requirement for a self-regulating mediators organization to have adopted their own code of professional ethics. And now I would like to give more detail about professional standards. So these job responsibilities are divided into three components. So for those non-specialist areas, we can see that there are requirements and also the responsibility to comply with the code of ethics. And 3.2, it's the employment function that includes the preparation for mediation procedures, also the conduct of mediation and agreement on the conditions of mediation, and also completion of the procedure. There is another function for mediation and specialist field, 3.2, and again 3.2.1, that would be the preparation for mediation specialist sphere, and 3.2.2, that's the mediation itself, agreement of conditions and completion of procedures. So it's the required knowledge, the principles of mediations and code of professional ethics. And here comes function number 3, that's the high level of qualification number 7, the supervision and specialist mediation sphere. So that would be the analysis of practical cases and analysis of professional skills of the specialist under supervision. So the development of abilities and skills of professional self-analysis with a specialist under supervision. So for all these three sub-functions, there is no mention of the code of professional ethics because they are mostly concentrated on mediation practices and techniques. So these are the principles. If we look at the Federation law on mediation, that would the principle of impartiality, voluntarily, confidentiality, collaboration, and equality of parties. And if this is compared to the code of mediators of Russia, then we see like neutrality, transparency, openness, and respect towards participants, as the professional qualifications and bona fide. So again, these are the two sets. I have another example from the Alliance of Professional Mediators, and they include lack of a conflict of interest on the part of mediator, full transparency, and with as regards information about education and trainings, as guaranteeing equal opportunities to the party, just non-use of advertising or the principle of honesty, the principle of refraining oneself from any promises. We can also look at the code of ethics from Tula, trade chamber, that would be independence, diligence, and good practices. So these are the responsibilities. So now I prepare this comparative chart to, for instance, the mediator's code, that the mediator has to share the doubts with the parties, also discuss possible replacement of mediator, and comply with all the rules and principles and ethical standards, and also provided more detailed information about consequences and any risks associated with the parties' actions. And if we look at the professional mediators alliance, so they also include this expert examination of quality as part of mediators' functions. And as far as we can tell, there are differences in the legal status of mediators. So I believe this should be set forth either in the employment code of the Russian Federation, or certain provisions need to be redrafted in the federal law on mediation. So if we stipulate more clearly the legal status of mediators, will help us address this problem, because there are different code of ethics and they include more functions as compared to the statutory provisions that can be found in the legislation. So that's it from me, and thank you very much for listening. And I would like to thank you for giving me this opportunity to deliver my presentation. Thank you very much for your speech, because, by the way, you've touched upon this new dimension on this problem, which is the regulation of mediators from the point of view of employment legislation. And this is a very innovative approach to this problem, and through a comparative prism, we can look at national provisions and also compare them, with the background development with some provisions were in place before this federal law on mediation was enacted. So we have slightly changed the
agenda. And the first change was announced yesterday. So now we are going to invite Yelena Dunaeva. So remember that we promised yesterday that we will start institutionalization and reconciliation services, and there are three key speakers. Yelena Dunaeva, who is the head of mediation department with the Arkhangelsk Regional Psychological Medical Assistance Center Nadezhda, Hope, and her speech, okay, will be delivered as a video recording. Our colleague has prepared it and provided us with it. So her speech will be followed by Elena Belanogova on regional model of training service specialist in reconciliation. And finally, Mr. Anton Konovalov, talking on school and territorial reconciliation services, an institutional form of implementation of the restoration justice. And then we get back to the program as planned. So I would like to invite all participants of the conference and the audience to send their queries or questions to the chat box. And I would like to give the floor, not to give the floor, but I would like to demonstrate the video from Yelena Dunaeva.
Good afternoon, dear conference participants. I'm going to tell you about the regional system for support for reconciliation, restorative justice programs in the Arkhangelsk region. First of all, about the legal foundation for this activity. This slide shows you the norms of international law, mainly related to the documents of the UN that are related to this activity. The recommendation of the Council of Ministers of the Council of Europe's recommendation of the Council of Europe, of which Russia is the member. And this is the list of documents on which this activity is based in the Russian Federation. It's 3 decrees of the government that approve the concept for the development of the network of restorative justice services, the strategy for the development of these services, and the concept for the development of preventive services for underage criminals, and the order of the President of the Russian Federation on the decade of youth in Russia until 2027. This decade became the continuation of national strategy for the development of children's interests that was also approved by the presidential decree in 2017. It is expired in 2017. This word specified the development of a network of conciliation services aimed to settle conflicts. Basically, it was government order for the development and implementation of such an approach in Russia. So it is a very critical, important document that helped us to begin this work. It was back then that in the Arkhangelsk region, every second criminal case against juveniles, youths, was discontinued by court as a result of reconciliation. This affected the repeated crimes very much. This is why back in 2012, when we had a chance to have experts trained in Norway or by our Norway partners, we were involved in this process very actively. The ideologist behind the restorative justice in Norway is Nils Christie. He wrote that conflicts must be used instead of letting them getting deeper. They must be used by those who are involved in them. Municipal entities where trained mediators appeared were approved as experimental sites for introducing restorative justice programs between the victim and the offender. Today it's 10 municipalities and we have 13 territorial conciliation services in Arkhangelsk region. This slide shows you the 10 that work on criminal cases against youths. Furthermore, the Regional Committee for Youth Crime and the Protection of Youth Rights decided that our center, Hope Center, was assigned the authority of the coordination and organizational support for experimental sites that are implementing these cancellation programs. It is very important that uh, an agreement on interdepartmental cooperation was signed in the EU wording on May 21st, 2019 by 10 parties. They're all here on the slide. These include not only law enforcement bodies, but also the government of the regional court, the attorney chamber, but also the Northern Federal University. In May 2019, the new wording was adopted, but there were two versions before that. But these versions are amended over time, and therefore they're adopted in new wording. And they're signed by the persons in charge of the agencies listed here. So this new wording has made it more clear what the forms of amicable settlements are, and it also lists the cases on which mediation is carried out. It's criminal cases with respect to abuse, criminal cases, and cases on administrative violations with respect to family violence. The so-called rejected cases where the children under age commit crimes. Furthermore, uh, cases on administrative violations, for the first time, it's specified that there should be school-based cancellation services. They are now actively developed in the Arkhangelsk region. Furthermore, it also discusses underage convicts, who are serving time in the Arkhangelsk colony. The parties to the agreement established a working group that has been working on this. Annual roundtables were held at the regional court. The regional court was very active in this work. And members of this group have been developing regional documents for interaction. We have developed drafted 5 documents for each group of cases. It's a regulation for interaction on criminal cases with respect to youth crime. It's the order for operation with the rejected cases, the order for operation on administrative violations, family violence, adults against children, and the regulation for interaction on programs with youth convicts and victims of such crimes. So each of the category of cases have their own special details. This is why these different orders and regulations were developed. Let's use the criminal case as an example. I'll show you how it works. With a criminal case, mediation is possible both in the pretrial phase, when the application for mediation is submitted by the investigator, or during the court hearings, when this was not the case during the pre-court action. Then the judge submits an application for mediation. This is how it works. The investigator clarifies to the parties the idea of mediation, submits the application to the agency that was approved as experimental site. The mediator there carries a mediation program and either drafts a mediation agreement or minutes of the meeting if the parties have not been able to reach an agreement. And then the outcome of this mediation is submitted to the agency that submitted the initial application. Furthermore, a copy is sent to the Committee for Youth Criminals and Youth Right Protection. This slide shows the statistics about the 3-year of number of applications and criminal cases that were submitted to mediators. And we can see very clearly here that the number of such applications has been going down from year to year, from 417, and now it's now less than 300 in 2019. The greatest drop is observed during the pre-trial investigation and in courts. This slide shows the number of programs carried out for cancellation in criminal cases with youth criminals. This data also shows that the number of such programs has been going down. This slide demonstrates the specific weight of teenagers that uh, uh, committed another crime after mediation. In absolute numbers, it's 6 or 7 people out of the number of people who were involved in mediation programs. We can see that the specific rate has been going down, which is a reason to be happy. Because like I said, when mediation was only introduced, the main idea was to reduce the number of repeated crimes in the underage group. And this can be achieved with respect to mediation, with help of mediation. This slide demonstrates the system for regulating settling conflicts uh, uh, where children are involved in the Archipelago investigation. At the forefront of prevention are school cancellation services. Like I said, the number of these school services has been going up. They settle petty conflicts among the students. Furthermore, they also work with cases on administrative violations. It's conflicts between the students, but also uh, criminal behavior by school students. If there is such a service, then it settles the conflicts. If it doesn't exist, then this is the level of territorial conflation services. But territorial services mostly aim to do mediation on criminal cases, and only then do they deal with other classes of cases, including those that involve family violence of adults against children. And the most serious stage is the Arkhangelsk prison colony, which works with convicted teenagers. Our center, Hope, offers training courses for restorative mediation. We're licensed, we've developed 4 restorative programs. They're all here on this list. Program number 1, titled Mediation in Restorative Justice, is 40 hours long. And this program is used to train mediators for territorial cancellation services. Or number 3, for instance. It's an additional program. So the first one is the basic program. And the first one deals with family violence against children. It has some special features. We train mediators on family violence under program number 3. Program number 2 applies to school-based services. Program number 4, family conferencing, is also where we offer training. Training is aimed to reach practical results. You can see this. We use role plays and we train people to act as mediators. Problems that we have been facing since 2018. I think I should be quite frank here. First of all, there's this serious problem which occurred in 2018. The investigation department of the Ministry of the Interior of Russia circulated a letter to its regional offices where uh, they were instructed to engage in more active measures, and they started implementing very actively what this instruction said. As a result, the number of applications for mediation was reduced, and instead, the courts started to get more requests to enforce various punishment measures, which was very bad. We have been getting applications on cases of family violence against children, and this year, restorative justice, the original court discontinued its support for restorative justice because the court said we will not deal with it anymore until there's a law. We discussed it with our working group. We discussed the figures which demonstrate these activities. You can see these numbers on the slide. The measures, the number of measures undertaken in the year 2019, 2018, and the conclusions by the prosecutor's office of the Archipelago Station with respect to application of Article 47 of the Criminal Procedure Code. The number of teenagers who were submitted to that article in 2018 was tripled as opposed to 2018. This is why I said that the number of cancellation programs dropped. So this level has not been going down. At the same time, requests by investigators are submitted formally to the court, and sometimes they're unjustified. These measures are not cancelled, although the law provides for such a possibility. And the number of cases discontinued due cancellation of the parties as a result of the number of people that committed another crime, a repeated crime, has been going up since that time. We can see here the overall data about repeated criminals. So this number is much higher. What does it take to make this experience stable? An experience on interdepartmental cooperation is a very important step. The stakeholders must be interested. Regional documents on the interaction are required. It takes trained mediators. There is also the regional committee on the rights of youth has to use its capacity, and this has to be taken into account. And a coordinator of operations of the regional services has to be there. But most of all, we need support on the law. We need a law that would specify very clearly that it is possible to implement cancellation programs, in particular with respect to criminal cases against youth criminals. Thank you. Despite the video effect, still, we would like to thank Yelena for her excellent contribution, in which it showed both institutional foundations of how restorative justice programs are carried out in the Arkhangelsk region. Yesterday, we heard already that there are two regions in Russia, the Arkhangelsk region and the Perm region, that have been taking a lead with respect to the number of restorative justice programs as part of the All Russia Association of Restorative Mediation. And this experience is indeed very interesting because this is a live practice, a real experience to which we should look when we try to solve problems of reconciliation that our legislators can solve. And in view of this, what Elena is saying about legal regulation becomes ever more relevant. Evgenia? Right. So,
достаточно плотной программы, да, все-таки передать слово следующему докладчику.
I would like to introduce our next speaker, and I believe that's a very good opportunity for us to look at different regional models. So this is a model from Kemirova, and I would like to welcome Elena Belanogo, PhD in psychology, head of the Department of Restorative Practice and Reconciliation Service of the State Public Organization. Kuzbass Regional Center of Psychological, Pedagogical, Medical, Social Power, and also head of the research at the Social Center Judicial Legal Reform. And over to you. Can you hear me well? Yes, we can. Good afternoon, esteemed organizers and participants of the conference. I would like to thank for this invitation, and I want to present regional model of Kuzbass. In fact, the preparation of mediators is undertaken at Kuzbass Center for Restorative Programs, and we have regional concept strategy for the development of mediators. So the system of mediators and all reconciliation services were created with a bottom-up approach as a response to the need of the search for new methods and ways of works with people, with children from dysfunctional families. It's just 8 years ago that we started our training project, more based on the classical mediation projects, and first reconciliation services were set up based on these classical models. And then in 2013, we launched this regional network project. So after the launch of the operations, our mediators faced specific problems that hampered their development and even raised some concerns around the system as such. So that it was unclear how mediation mechanisms can be built in with the schools. And also it group conflicts and damage situations were not very well handled through the system, and some agreements were reached, but they were not performed. There was a lack of support from the school leadership, and also it was impossible to go through the conflict that involved the school administration. So we had this attempt in order to solve them, decided to analyze uh, an array of situations involving minors, and also looked at best practices domestically and abroad. Finally, we chosen just one model that could be adapted to many school children, and also escalated conflicts and restorative approach to the community and social environment and those involved in the situation. So restorative model, in fact, included two organizational formats. So one format can be built in a school, so it's a separate school that can be a part of the program. And the second element was a territorial division that can be set up at the pedagogical departments, also as part of minor offense creation at the municipal level. So there were criminal situations, family conflicts, and other traumatic situations involving school children, also neglect of children, and then social services and child care agents need to be involved. And there are specific principles of restoration and prevention, principles that were not very clear to all the stakeholders. So it was in 2015 that we started a very active collaboration with the Interregional Center for Legal Reforms. So our region just joined the nationwide movement in this respect, and it was in 2015 that we started up the Department for Restorative Practices and Mediation Reconciliation. And these include this reconciliation. So is it for Kemerovo city and Kemerovo region. We have also developed a program for training. This training program includes a training of trainers and also training of specialists for in reconciliation, and also volunteers in reconciliation. So the training includes the basics of reconciliation principles, techniques. These are courses that can be either carried out by organizations themselves or can be also subsidized and probably supported by certain grants. And we have another program that can be run at schools, and municipal authorities will help us, and we invite volunteers because we have chosen one school center. It's called Siberia Fairy Tale, and this is used as a platform for delivering this training. In addition to training events and seminars, will also prepare materials and handbooks, and this is done on a free basis to all of our attendees and participants. Next, the revision and supervision of all the programs. So our program includes several modules, and these one of them would be raising qualification of reconciliation specialist, and it is 254 modules. Hours, sorry, consisting of 7 modules. So these are the modules that the restorative mediation and organization of reconciliation activities, then group conflicts and community circle Number 3 would be restorative communication and and restorative programs. Then number 4 would be very complex and most difficult to deal with cases and family conflicts. And over the past 3 years, we were conducting the training courses under the comprehensive training program for sociological aspects and the assistance to minors that have problems with delinquency at regional level. So as part of our efforts at the social reintegration, and also we invited professionals from the Center of Legal Reforms. As for the conceptual foundations of our training program, those included restorative justice as a transdisciplinary approach, mediative method, and restorative justice to the resolution of conflict, and the concept, strategy, and the Russian model of restorative relationships in school. Again, the concept strategy for restorative justice in the cases involving minors. And so these are the forms and methods of training. So there are techniques such as simulation and restorative technique, case studies, analysis, mediation, and circles, conferencing, and other methods that are listed on the slides. As for the analysis of mediation practices and also reconciliation experience at Kuzbas has enabled us to highlight certain important aspects such as using discourse and communications, extending the knowledge base, and following the principles of restorative mediation. So these are all the competences that need to be formed with the specialists for mediators. So it is very important also for them to master the basic notions and concepts so that they could work with. And we have curators. So for the curators, it is important to know the legislative base framework and also regulations that are in effect at the federal level and in Kuzbas in particular. Professional communications also need to be maintained with representatives of educational system, so child care systems, those youth crime committees, and all those stakeholders in the educational process. And we also noted that this interaction and collaboration also help create trust and confidence in mediation and reconciliation practices. Therefore, so we try and pursue this kind of collaboration through all the stages of our work, and there are different types of restorative programs. So these include restorative mediation, redress of damage, then circles, family conferencing, the school conferencing, and then restorative programs. So we obviously see that this is a unique competence, a unique field that brings together several areas. So on a monthly basis, would also deliver seminars and training sessions in order to upgrade the skills. And this would be other master classes or probably trainings, seminars, intervisions, supervisions. So we ensure the training of specialists in mediation, reconciliation that can further develop their skills and handle cases that or disputes that include conflicts between school administration and children and their families, minor offenses, other crimes and actions that can be detrimental to the community, and some problematic situations in families, dysfunctional families, and violence and cruel treatment of children and families, and some complex situations at schools include bullying from the peers and pedagogical multi-level conflict. When we look at the organizational model of training for restorative mediators in the region, and this can be used they can use as a platform our center, so our trainers. We can invite trainers from the regional center for legal reforms. So we could also use as a platform some premises with the regional authorities, so municipal authorities, or probably schools who are willing to participate. So when sites are designated, then a training will be conducted following this algorithm. So municipal authorities will first arrange a seminar for principals of schools and then will visit this site. So interactively, we'll explain the principles of restorative approach and also the idea of setting up reconciliation committees at school. So, and obviously, it's half of the participants that would agree to set up such reconciliation committees at their schools. Then we start delivering seminars either for module one or for modules one and two for those principals and school administrations that decided to undertake the project and continue this work. So the next stage would be sending school specialists to our center in order to take part in the seminars that explain how to organize and set up reconciliation committees. So it is very important to provide assistance to mediators and reconciliation specialists and also so that they can take part in our monthly seminars and they could send them to attend these events. So these are the deliverables of the results that we have achieved over the three-year period of time. So 54 um, so committees have been set up. We have 230 adults and 240 school um, pupils involved in the program. So 1,640 programs have been already completed. So another we look at the educational system, then we have 15. So 15 organizations, 75 specialists that have completed 360 programs on most complex cases, including crimes, actions that are detrimental to the community, family conflicts, and complex situation involving domestic violence, and also some complex situations in educational institutions. So we do the annual monitoring that helps us analyze qualitatively and quantitatively all the programs and the work of our specialists. So the results are quite positive indeed. And recently, there's another program that comes to the forefront is developing the program for municipal leaders and volunteers that are willing to develop this restorative movement in their territories in order to replace those people were dealing with reconciliation but may have already retired. We have a set of events, and some of those did not fulfill because of the pandemic, but we believe we'll be able to deliver them in the future. And our training program will not be disrupted by any changes in the legislation. Thank you so much for um, listening. So you have been very thorough and very detailed. So in your presentation, because you have explained the architecture and the very structure, so you also identify the areas of activities in the restorative justice, explain how to implement it. You provide us with some statistics. So I would like to wish you every success so that no problems would become obstacles in your endeavors. And dear colleagues, I would like to announce that we just go beyond our time limits, but I want to assure that all the presentation speeches that are included in the program, so they will enable our speakers to deliver their speeches, but still will stick to this 15-minute time frame. Moving from regions to Moscow, I want to introduce Mr. Konovalov, so representative of the Department of Education and Science of City Moscow. And the topic of his speech would be School and Territorial Reconciliation Services as Institutional Form of Implementation of Restorative Justice. So,
Yes, thank you
over to
very
you.
much. I hope you can hear me. Well, thank you to my colleagues as well who have told a lot about territorial school-based cancellation services. I think that many of you have already heard that in Russia there are two models, the mediation service and cancellation service. I'll be telling you about the school-based cancellation services, the model which has been developed by the Regional Center for Judicial Reform and for Restorative Justice Association. This is based on the ideas of restorative justice, which is closer to the topic of our conference. Furthermore, takes into account traditional legislation practices who have been looking at the practice of agricultural gatherings and other forms of people's rule. We cannot transfer them directly to the school level, but at least we try our best to keep this legacy. Furthermore, it is being developed by people who were members of Georgy Shadrovetsky group. The first cancellation services were established back in year 2000, on December the 16th, year 2000. So it's basically an anniversary, right? 20 years ago today. There was a first meeting, cancellation service held between a professor and a school students, held by 4 school students, 2 boys and 2 girls. We have been monitoring the practice of our association. There are about 1,500 operating cancellation services in schools, and 3 or 4 times more services have been established, but they have been working now and then. This means that we take into account mostly cancellation services that do reconcile, do carry out cancellation programs. Part of the services have been established in accordance with the order. There are people that have been assigned to this post, but they really don't understand what's going on or what they have to do. Or maybe they have just one meeting a year. Sometimes it's not due to problems because, for instance, the curator, the leader of this service may have been sent to training or maybe in maternity leave, etc. This year, special recommendations on mediation cancellation procedures were published for educational services. This was in July 2020, if memory serves, and we were also involved in developing these documents. So it touches upon the cancellation service and mediation services. I'll be telling you about the cancellation services. So I would like to answer to a number of concerns that are raised most often. I want cancellation services to grow in numbers. So question number 1 was, do cancellation services work with conflicts? Because I've been told many times that there are no conflicts at schools. I come to a school, they tell me, we don't have any conflicts. When we have conflicts, we'll turn to you. First, I couldn't understand. How is this possible? Because I was a schoolboy, I was a school student, I can remember very well how it happens. Conflicts there happen almost every day. So it took me about 5 years to hear. I finally understood that from the point of view of many teachers at school administration, there are no conflicts, but what there are broken noses, stolen phones, disrupted classes, unreasonable children, unreasonable parents. This is all there, but no conflicts. So I told them, you need cancellation not when somebody comes to you and says, I have a conflict. No, you need to do this when there are situations which involve bullying or disrupted classes or complaints from parents or children that disturb other children, etc., etc. So whatever occurs or wherever there is a violation of law, stolen phones, graffiti on the walls, etc. So situations like this, or maybe conflicts between students. So this is all what the school-based cancellation service can work with. 2, who needs this cancellation service? I've been having these questions. Well, I respond, What do you mean, who needs? Do we need a hospital, or do we need a fire brigade, or do we need courts? Maybe we need justice, maybe we need health people, maybe we need cities that never burn. But to reach this, we need hospitals, we need police, we need fire brigades, etc. Same applies to cancellation service. It's a tool to a certain end, a means to a certain end, to reach certain aims which we think are important. Next, sometimes we hear, good, you establish the cancellation service, all the conflicts will be settled there, right? A good cancellation service aims not to resolve all the conflicts, but to help other people in this educational organization to organize contacts between parents, the school administration, children in such a way that there are no conflicts. And if there are, they'll be settled in negotiations. So cancellation service works throughout the school space. Next, does the cancellation service really reconcile? What do you mean by reconcile? Cancellation is not just shaking hands, saying don't do this anymore, we all understand. No, this is not about it. In particular, if you consider it at school as opposed to the classical mediation, criminal cases or family cases, at school, it is not a problem to have everybody around you. The principal says, principal orders, everybody comes to this preventive council. Even sometimes people are brought to, with police. You prepare minutes, you even sign it. The question is about the type of communication for this agreement or the minutes to be then performed by the parties without any further reminders, without any force on the part of the police, etc. Because we've seen many minutes adopted, many agreements signed at the principal's office. Children sign something, parents sign something, and then they leave the office, and then they start chatting, writing in chats on blogs that they disagree, that they don't want to do what they were told to do. So it is important not just to sign minutes of the meeting. No, these resolutions must be executed and must remain within some framework. What is this framework about? This is what the website says on the very first page, szkolniejeprimierenie.rf, and it describes all the main principles of restorative justice, which we think can be implemented at schools. 1. People themselves should look for a solution, not anybody else, but people themselves. 2. Damage should be redressed. If somebody was harmed, if somebody was inflicted damage, then this has to be redressed. Nobody should leave this office offended. Nobody should feel they're still in offense. 4. People together have discussed what they're going to do to prevent things like this from happening again. So do is the key word, not just say, I won't do this anymore. No, you should really do this. And next, hostilities should come to an end. They should not be hostile anymore. They should restore their contacts, at least as classmates, so maybe business-like contacts, maybe not a friendship. And parents and their neighbors, people around them, should help them, not just swear at them. They should help them to go along this very difficult path to restore the situation. Then we believe some reconciliation is possible if all these values are implemented. But the problem is that initially people don't intend to implement these values. Each of them says, no, I have no conflicts with anybody. No, correct him, correct that professor, correct that student, correct that mommy, or correct this principal, or punish this principal, expel this student, replace the teacher, do as I want you to do. No, the task of the cancellation service is not simply to reconcile, or rather to intimidate, or to tell them that both are to blame. Or if you don't reconcile now, we'll expel you from class. No, this is not the task of the cancellation service. The task is to organize some type of communication. Initially, people come when they're in conflict, which means that they blame each other, they have emotions, negative emotions, they have claims to each other. They have certain behavioral patterns with respect to others, prejudices. people have to be taken out of this complex situation into a responsible position. What does this responsible position mean? They need to be able to listen, to hear, and to undertake actions to correct the situation. Nobody's going to do this for them. They will do this themselves. How can you take people out of a responsible position into an active, a proactive, responsible position? This is where the cancellation service can help. There are routine communications, but a lot of information is lost there. Sometimes people say, well, we come together, we talked, and what did you agree? Oh, we don't know what we agreed. And who's going to do what you agreed on? We don't know. There are expert communications. Expert communication is when somebody comes and evaluates and says, you should classify the situation. I understand you have your child has this problem, has that problem. I recommend you to do this and this. This happens quite often, but this is not the task of the service. But because in expert communication, people are not ready to accept this. People want to be heard and not to be classified. So the cancellation service does not classify anybody. It helps people to make themselves heard, to sit at the table, to voice their concerns, and most importantly, to do what they agreed upon. Therefore, it is critical for school services, cancellation services, to implement a certain process, a certain procedure, not just say, we have had this preventive council, we have used certain restorative elements. What are these elements? Was there a restoration program, a cancellation program? For instance, before a committee on youth crime talked to a child in the past, they would ask, did you have it in the cancellation programs? And the school administration says, yes, we talked to the guy, but you do have this cancellation program, because just talking does not mean that this program really was implemented. Likewise, does not implement there was any psychologist consultation or a similar thing, because psychology is not about just talking. It's a certain process, a certain procedure, with certain aims, certain purposes, certain professional stands, certain professional tricks, etc. Therefore, I also believe this can be included in the educational programs of schools. Clearly, there are situations where the school cancellation service would not cope with because it goes beyond the school. Usually, it's three situations: situation of a multi-level conflict at school, bullying where parents are involved and administration is involved. Sometimes complaints are submitted to the prosecutor's office or to mass media. We had cases like this in our practice. Furthermore, there's a case of a violation of law, something that will be submitted then to the court or the Committee for Youth Crimes, stealths, fights, and family conflicts with teenagers. Conflicts not between the parents, but between the conflict with a teenager that's who misses classes, who doesn't come home, who is involved in crime. So this is then submitted to territorial cancellation services. For instance, the existing centers of the education systems of social spheres, maybe NCOs. What is important here is that people there have to have, like my colleagues said previously, uh, have to have certain department, have to have a certain team that would deal in with this, so that when they come to a school on a request, not always do schools submit requests. So sometimes they're just a violation of law, and they have to go to schools to talk to the school or to talk to the Department of Education at the regional level, so that later on this service would not be asked to submit a report. No, they come there just to carry out restorative programs. In Moscow, this is what you get. People are invited to carry out restoration programs. The report would be about the program implemented, an action plan developed by the people, not just the minutes of the meeting. This is why, for it to be included in the job description, this has to be done. There should be regulations on how to work with the Committee for Youth Crime, so that when a person has reached an agreement, has corrected, and then the person is again summoned to this Committee for Youth Crime. In this case, the committee should say, you, dear family, have done a good job, so good that you trained your child, educated your child to organize himself or herself. Let us help you, but then then we will say that you're good. So in cases where everything has ended with in success, we should not be unhappy. We should say that the people have done a good job. So my timer is on. What I'm trying to say is that you have any questions, I'm ready to take them. I'm ready to comment. And thank you again to my colleagues. I would like to thank the association of the legal reform and the All Russia Association of Restorative Mediation. It works a lot in the regions for this principle to be observed by local schools. And last but not least, sometimes people say, can we, instead of establishing a cancellation service, because it means a lot of paperwork, we'll do something else? Yes, you can, but then it will be more difficult to prove what you did as part of what procedure, etc. Because the construct of the cancellation service itself aims to organize, to create a safe atmosphere for those who are involved in cancellation programs and for those who come there. Because it explains that this is not psychological work. This is a certain format according to certain rules, confidentiality, a voluntary based. You shouldn't insult the other party, etc., etc. So the format is there to make all the people involved safe. Anton, thank you very much. So you also have done an excellent report about the regional experience. You showed how knowledgeable you are, that you are involved in this process very closely. I wish you a lot of success with your initiatives. Because 20 years ago, they were offered and they are now being implemented for these initiatives to be scaled up to the level of the entire country, so that you could multiply your experience from Moscow to the regions, so that this socially important cause would bring its good fruit, would bring its effect. And I hope that the problem, which is the main topic of our meeting, legal regulation and how to meet the best balance between the theory and the practice, so that this problem is solved. So I hope that you and your colleagues from the Center for Legal Reform will be as a role model. So dear colleagues, we move on. In this session, the final session, we'll have a final report. Yevgenia Vaskova, Director of the Center for Mediation of St. Petersburg State University. My dear colleague, mm, I value your contribution as a moderator to this conference. So, my dear colleague has agreed to speak on a topic which may seem to be out of the scope of this conference. It's special features of mediation technology with tax bodies. But, you know, I think uh, this only is on the face of it, because, as we discussed in the previous session, if you allow me this self-quotation, mediation in public law has a totally different set of problems, and you cannot just copy-paste the experience from uh, other aspects. And if we start listing them, the aspects that have to be regulated in a very special way, uh, then we will see that the institutional foundation should also be looked from a different perspective. So, Yevgenia, you have the floor. You have the floor.
Благодарю вас, Тимур Викторович, и за теплый прием на
I'd like to
конференции.
thank you for this warm welcome to the conference, despite this online format that has been restrictive for all of us. And also there was an attempt from my side to come up with a speech that probably is not just within the common theme, but my colleagues have already presented their views and they explained these practices and expertise in the work with minors and juveniles. So we clearly see that this trend that just emerged before the federal law, so and then this trend developed through all the modifications and amended amendments to the federal legislation, and obviously it's on the rise. And all the points raised by my colleagues are very specific, and they require some private elements. But if we look at it from a public perspective, and I'm talking about tax disputes, and obviously this is something new to Russia, and it's 2010, so the law was adopted, and then in October later, some amendments were introduced. So there was a provision for using mediation and mediation techniques as applied to public relationships. So this federal law is well known to all of the practicing specialists, and obviously it is a bit conflicting because one provision now says, mediation law says that it would regulate relationships that arise from the application of procedure again to civil law disputes and administrative law disputes. And on the other hand, there is another provision that says that mediation procedure does not apply to disputes. So these, if disputes involve public interest, right? But what about tax relations and taxation? Obviously, this tax-related relations would include public interest in the first place. Why? It's because these tax relationships form the basis of financial operations by the state. So taxes traditionally have been a major source of income to the federal budget. It has been the source of budgetary revenue for all states, and everyone knows it. So fiscal issues and the public interest would dominate in this field. On the other hand, so when we look at the process of tax collection and calculation, we realize that it's a very complex and multi-step process. So relations as such are formulated, they are regulated, but at the same time there is room for negotiation and some possibilities for balancing the interest not between the state and the taxpayer, but the taxpayer and the tax authority. So fields for negotiations, they would emerge as a result of changes in economic conditions and economic situation. So when we look at this fabric of a tax legislation, so we see that the lawmaker also provides for certain discretion on the part of tax authority as an administrator of a tax revenue. In a nutshell, I would like to describe the scope for negotiation, and this includes a deferral of payments and also interaction between the taxation agencies and taxpayers during tax audits. And another area would be some reconciliation procedures at international level, at the interstate level, so that we'll try and just broaden the scope of application of tax law. And certainly this would include some negotiations and between taxpayers and tax authorities as part of procedures that are outside tax control mechanism. What I mean is that tax authorities can identify certain markers with the taxpayers or markers that would indicate some tax debt, and they would notify taxpayers of the presence of markers. So then tax authorities just invite taxpayers to re-evaluate their economic operations and reconsider the the documents that they present to the tax authority and the state at large. So the taxpayer agrees to the risk markers that have been highlighted by the tax authority, and the taxpayer can make adjustments or can update so all documents and pay taxes as appropriate. So this interaction has a positive side, which is in that it helps so it helps rationalize the use of public resources. I mean that we don't have to do many audits, and it is clear. So if it is possible to regulate, so tax disputes, but I want to differentiate between tax dispute and tax conflict, because this tax conflict that emerges, it may be prevented from turning into a tax dispute because it is a potential uh, possibility for conducting tax audits and then recalculating the tax base. So if at this stage, at the stage of tax conflict, we try and settle it, then it will help save public resources, and then it will be about the balancing act, whether they will be able to agree, they will agree or will not agree, or probably tax authority should be vested some with additional powers for mediation. Is it necessary to adopt extra regulations in this sphere? And tax authorities, tax consultants, and representatives of taxpayers also raise one question that regards the qualities of a person that can just act as intermediary in this emerging tax conflict. So the person that would help the both parties regulate or settle their conflict. So, and I believe that mediation procedure is a quite probably multifunctional or universal tool that can be used for this purpose. And I know that in St. Petersburg, by the way, there's one mediation agreement that has been entered into between a taxpayer and a tax authority. And by the way, the agreement was executed in November, and I know many other tax authorities would like to follow that lead. So, what's the idea and the purpose of this procedure? Well, that's easy to understand. So when we have tax authority and we have taxpayers, and when those markers are in place, and obviously they will not be documented under federal legislation. And the reason why is because the tax code does not stipulate any procedures outside formal audits or formal notifications, and they're not there, and they shouldn't be there. It's because the tax liability should come as a fixed amount. Otherwise, so this type of regulation would go against the, the principle of certainty of taxation and also constitutional provision to this effect. But on the other hand, so there could be direct negotiation as part of administrative regulations. And let's look at legal consequences. Probably will be able will see an increasing corruption, and these will negatively affect negotiations between tax authorities and taxpayers. Presumably, so trying and invite a third party to a conflict, a third party that would facilitate with the negotiation process, will make the entire procedure more efficient. So the scope of authorities, scope of functions of tax authorities, and also the subject matter of mediation agreement needs to be further discussed. I just have some ideas in that respect, which I don't have time to elaborate on, but I believe there's no need for further regulation. So we know that there have been cases where courts would certify and would approve such agreements between taxpayers and tax authorities, and as both parties are empowered to admit to or to recognize, acknowledge some facts that can lead to the recalculation of certain taxes. In addition to that, there could be the mechanism for the redistribution of burden or probably some admittance to the reduction of the tax base. And however, I wouldn't give you this straightforward answer as to the preservation of public interest. Probably tax authority would think against conducting tax audits if the taxpayer just agrees to certain amounts that are considered to be debts by the tax authority. If the taxpayer agrees to pay those amounts and to correct the documentation. So it could also be an instance of agreeing some conditions, and if we could reach an agreement as regards the facts at hand and probably some subject matter of taxation, or take property tax as an example. So there are different categories of property, whether it's tangible or intangible assets, and we know that some rules have been changed. So the accounting rules, and so because going from tangible to intangible obviously sometimes affects the calculation of tax base, and this the uncertainty of legal field, and it would be great that the both parties would have an opportunity to meet on a neutral platform in order to coordinate their approaches and for for the future periods, and this would reduce corruption and would also reduce the amount of court fees and costs. And again, looking at the role of an intermediary of this third party, because we have been already discussing this topic for several months, and so negotiations were held with the tax authority, and also notary services were involved. And so often during these discussions, I can hear an opinion that a person that is involved in the procedure needs to have knowledge in the taxation field, first of all. Then this person needs to be a lawyer, also needs to have some expertise in mediation. But again, if we try and be realistic, then I don't think that these requirements will help us develop this uh, institution of mediation in tax conflicts before we implement administrative regulations. I think that we need to understand properly the legal field, and we shouldn't be over restrictive with regulations. Otherwise, we'll just reduce ourselves in the number of possibilities. I believe these possibilities could be developed by mediators, because we have many qualified and skilled mediators in Russia. So they have, for example, great expertise in business conflicts and disputes, but they may not be lawyers. And just I would like to emphasize so that these are the issues that should be coordinated and agreed upon. And again, if these questions do not involve public interest, this group of questions is a narrow one, they are not going to change. So therefore, what we can do is we can just set up a group of mediators and we can provide them with additional training so it doesn't require any extensive training or extensive just the knowledge of the taxation process. Just they need to be clear about the environmental settings. But on the other hand, so I think this would help us to balance the interests of both parties, and we can also look at the models that are being employed for tax disputes. These models are standardized and they don't pay great attention to the economic interests of the parties. It's it depends also on the specifics of the disputes, be it property disputes or mindsets, because they have even this, mindset that sometimes undergoes professional defamation. And to conclude, I would like to say that I'm pleased to observe trends and developments and different directions. And I do hope that there will be progress with mediation in tax disputes. And I believe that we'll see the emergence and establishment of systems. For example, as my colleague explained, they have it in juvenile justice. Evgenia Pavlovna, thank you very much. And I believe so. Your speech was very opportune because you just described that institutional aspect that also we've been talking about yesterday and today. So right now, I would like to announce our session that will be questions and answers session, and we have enough time to have a thorough deliberation or discussion. So for all the presentations,
прозвучали, меня наводят на два глобальных соображения.
I have an observation to make. So my first consideration will be more about terminology, and second one more of cumulative. Confucius used to say that you need to change the names first if you want to change something in the governance structure. And Renaud Descartes, also mentioned that people would have so many difficulties if they could agree on the definition of words. And so we started to think about the conference when we were conceiving its title. So we wanted to be a bit provocative. And the idea was that from the perspective of law in this strict sense, reconciliation is part of justice, and reconciliation procedures are part of criminal procedure codes and also civil procedure codes. And we have Federal Law 451 that enshrines this institution in practice, for one. And we have seen that our conference has attracted attention from different stakeholders from different areas and from specialists that use different notions. And I would like to emphasize that those differences are we are not on the opposing sides, rather that we are like a united front, and we know that there is this global uh, reconciliation. So that implies dispute settlement, no matter the procedures that can be used for the purposes of settlement. That is more about the result, the outcome, rather than procedure. So if we look at procedures, then procedures can be jurisdictional when they're linked to a case, which is which is not necessarily a judicial case. So because we know juvenile commission, for example, may undertake this jurisdictional function. So jurisdictional versus non-jurisdictional. And during our conference, so we saw that several methods were presented as to how procedures can be conducted. So in this respect, I think we need to addressed them as reconciliation techniques, and those techniques have been described today, and also they were explained yesterday. So I have this thesis, and probably my thesis is supported by law this 451 of 2018. So this federal law emphasize specific aspects as applied to reconciliation in court proceedings, as there is a list of procedures that include mediation. So the mediation is such under 2010 law, so judicial reconciliation, and that is carried out by a retired judge following the preliminary resolution of the Supreme Court negotiation, then intermediation. So, and this list is open, and that most importantly, so our conference has shown what are the ways and methods that help extend the list. So we talking about techniques, this reconciliation techniques. Probably, I'm just coming up with new definitions, but that to the benefit of all, not that detrimental to the practice. So we've been talking about techniques of reconciliation and restoration, so the legal science that combines different speakers and actors. So I believe just for the jurisprudence, for the legal community, it would be a great thing if we could agree on a common understanding and definitions of concepts. So this would enable us to move to a higher level. So of this 10 years of mediation, we have gained certain experience. Then I believe they could take this law forward, and this would bring us to a more comprehensive regulation on, say, reconciliation techniques and procedures. And that regulation would institutionalize reconciliation in judicial proceedings, and also all those aspects that are outside the court proceedings, because as for court proceedings, those are regulated by procedure codes, and this can be discussed in specific areas of law. But in addition to that, we have many aspects that are outside that realm. Some schools, territorial divisions, they don't have this jurisdictional element in their operations. So I haven't heard it directly, but probably it was implied that our colleagues that are dealing with restorative programs, because it all boils down to human rights, the human rights of our minors and juveniles, their legitimate interests. So we need to strike this reasonable, fair balance between regulation and reconciliation. Once we agree on the terminology, we can then move on to discuss the next point, which is the effect of reconciliation procedures, or the possible, the potential impact of these procedures. And I believe that of greatest interest would be civil procedures that show many legal problems can be addressed through settlement.
Использование жесткой формализованной процессуальной формы. Но мы тогда даже, на мой взгляд...
Then we need to ask ourselves whether this practice can be used in other types of cases. So our conference has shown this very well. In public law, there's indeed a problem when such procedures face problems of public interest. Here, I would like to raise another idea, which I think would be quite relevant for lawyers in particular. But the idea is as follows. Legislation procedures have been widespread in private law due to the prejudicial principle. civil law and labor law know this visually. In public law, we're constrained by the principle of legality. But if we want to reach the positive social effect that can be reached using conciliation procedures, then why don't we adjust a certain amount of principles? For instance, the public principle, the legality principle, can be slightly amended. Then each department of public law should ask themselves, in what areas, in what aspects can we allow our stakeholders, our participants to reconcile? Where can we allow to settle the issues locally without any judicial procedures? Because all these discussions about regulation, public law finally go to court. In this case, with such approach, when in the industry of public law and tax law will probably be at the forefront here due to a great number of such disputes in that category. So then we will need to identify the borders, that outline the framework, and the experts who are not lawyers, people who have been promoting and testing various conciliation procedures, will have to offer technologies for reconciling, for settling such disputes. And then the cherry on top will be the question about the status of the persons that can be involved in the conciliation procedures. I think in this case we need to proceed from the pluralistic approach. Let 1,000 flowers bloom. But these flowers will be effective practices. So in the area of institutional organization, we need an interdisciplinary dialogue. So those who develop the technologies and the lawyers need to agree on the golden middle with respect to the requirements posed to people involved in professional conciliation operations and the freedom that is required for such operations. Dear colleagues, I apologize for a slightly lengthy statement. It's just a test ball. I'll be happy if my colleagues react to it, but also to other speeches that I have heard today, that we had today and tomorrow. Please share your opinions. I see a comment in the chat from Larisa Soboleva. I can see that this comment is similar to the comment from the previous day. Isn't mediation the golden middle already? Well, Larisa, if we open up the civil procedure code, I couldn't agree that this is the golden middle, because mediation is put at the same level with the other categories of cases. And then we will need to agree on definitions. Are there other conciliation procedures mentioned in the law, such as negotiations and other type of are different, or we take this pluralistic approach? Timur, may I jump into this discussion? Yes, please, because I don't see anybody who wants to say. And yes, Ludmila, you have the floor, please. Yeah. I waited for other persons to discuss. I'll actually continue what you started discussing. You know, I had a very active reaction to the report by Natalia. She's raised very important issues with relation to the definitions, to what we use, and what really means what. You know, when we talk, we need to agree on definitions. Maybe not here and now, because agreement takes special work. I would say that our restorative practice is more than 20 years old, and we have been able to reach an agreement one way or another. I'm grateful to my colleagues who have presented today their experience. And this experience demonstrates a particular issue that I raised yesterday. It says that restorative justice works not with conflicts, not with crimes, not with disputes. It works with situations inside which what is decisive of a particular situation, it may be a crime, maybe a dispute, maybe a conflict, or getting physical, bullying, etc. This is an important point. If you wish, this is a point about terminology. So, inside certain practices, certain communities, professional communities, or simply communities that operate, there are certain ideas of what is done and how this can be termed. This situation became relevant to us on one hand when we started to work and we realized that we need to adjust our standards for restorative mediation, because we also had a confusion in terms of definitions. And it is particularly relevant now because we propose, we offer the law on cancellation in criminal cases. I'm not going to repeat what we discussed yesterday with respect to this law, or how, for instance, we decided we should use the idea of cancellation. You know, I received this impetus to think during the report today. I get ideas when I disagree with something, usually. So it's like this. Two, maybe 3 points I would like to discuss. One, basically, this entire conference and its power lies in the fact that it has been able to demonstrate that there's this trend worldwide towards cancellation. This conciliatory approach, starting from one school all the way to international organizations. We had an excellent session today about the international level of problems discussed, and we see that this is a trend that permeates everything. So on one hand, it permeates everything from bottom to top. On the other hand, it is widespread horizontally over various situations. And this trend towards cancellation has been getting even more value, and even more hopes are pinned to it. You know, there's this trend. It began in law, for lack of a better word. It's what you may call therapeutic jurisprudence. This is not to say that courts should deal with restoration or should react in one way or another to such situations where rights of mentally challenged people are infringed. No, it's about a totally different aspect. Jurisprudence must be therapeutic in the broad sense of this word. It must increase the amount of happiness in this world instead of being repressive, because any jurisprudence is about justice, is about people or society wishing a better life. But as research ever since the late 1980s has shown, that for all the good intentions, that law, justice is about equity, about human rights, about everybody feeling better. In fact, this is not the case. We found that jurisprudence has a very strong repressive notion, a very strong repressive trend. We have seen that this trend for reconciliation is very serious. Clearly, it is not the only one, neither in law nor in reconciliation practice, but it is in great demand. Now, if we agree on this, then we need to understand that this is an alternative approach, an alternative to those practices that dominate, and the law that dominates not only in Russia but worldwide in other countries, including Russia. Now, as soon as this is an alternative, and many reports that we have heard here were touching upon this. they said that it was necessary to institutionalize these new growing positive practices, or even some forms of official regulation. And this is important. Institutionalization is an important task, but it is important not to exaggerate here, not to exert too much effort. Because today, when you read, when you get acquainted with individual forms of implementation of this cancellation approach in individual legal systems, or more broadly in social practices, you start to realize that you're being shown an alternative process, but a legal process. This is why yesterday we heard these comparisons and we heard these proposals saying that we need to regulate cancellatory procedures the way it is done, for instance, with respect to investigation activities. There's a good reason for that this analogy exists. So, legal thinking wants to take everything which is good and to conquer it and to put it into a rigid framework. This is why we heard yesterday that we shouldn't be in too great a hurry with detailed juridization. We do need this as a framework that would legalize this all. But on the other hand, we should rather be talking about a certain general framework instead of make it too specific, too concrete. Our law, and it lies very well along the lines of this therapeutic jurisprudence, which set the idea of conciliatory procedures. This is why we're discussing what, in real fact, conciliation is, what mediation is, what restorative justice is, etc., etc. This is what we saw in major discourses here. Me- those who implement mediation, who use mediation, it's because mediation today is a legal term already. This is why we're here. Whenever parties can use, they should use. Why cannot parties involve a third party to have their situation regulated, even when it is already in the field of legal consideration? Why should anybody be there who should allow this? Mediation is used not in the broad sense of this word. No. And people will even tell there's mediation and there is settlement. These are different nations, and the person should scratch the back of their head, wondering what the difference is. So we need to set a limit on this formalization. Although I don't have any solution, I just want to fix it. We need a balance, because as soon as we start working with this draft law, for instance, or previously we had to deal with formulation of our standards. We keep stumbling all the time over how to term this so that everybody would understand it as the same idea, to be on the same wavelength. But we need to be very cautious about it. This brings them back to the draft law, which introduced this idea of conciliatory procedures. I think this was a very good move, a very good step. It is important when we discuss what happens in Germany, in France, in Austria. It's important because we're not in a vacuum. The legal space today, as Berman said when he was still with us, when he came to the Institute of State and Law, he raised the ideas of global law. We don't just live in a single environmental situation or in a single pandemic situation. We also live in a single legal situation. So it is important to look at individual constructs, at how things work. But we have also achieved something, right? This is why this term conciliatory procedure. Let's have a look at it. What does this imply? What is included there? Negotiations, for instance, when parties talk themselves, but also mediation, arbitration. If the original term is conciliatory procedures, then if a person is involved, this person is a conciliator. This may include mediation. What does this form imply? Arbitration, including mediation, court, reconciliation. There can be court reconciliation, can be out of court reconciliation, right? So reconciliation does not necessarily imply something that is reached using the help of a lawyer or a retired judge or anybody else, or other procedure. Other conciliatory procedures, not necessarily arbitration procedures. This gives us, I believe, a good, very good foundation. I'm sorry for repeating this. I like your idea, which you voiced. So I think we need to agree, but first of all, we need to draw a difference, draw a line between what is different, what is not. Not to understand what exists in fact. In fact, we all only have this repressive approach, punitive approach. The official government structures are the main carrier of this approach. And there's a different approach, this conciliatory approach. And then we need to understand that we need unification only when we include this into the legal documentation. Thank you. Ludmila, thank you very much for, for this approach to the problem. I see that Yelena Belonogova has made a comment in the chat. Yelena, maybe we should... can you read it out instead of writing it in the chat? Maybe you participate in the chat. Well, this is basically what Ms. Karnozova said at the end. I was also trying to check there's interdependence between the phenomena, from the more common to the more concrete. And this is what Ms. Karnozova said at the end. Conciliatory procedure is a more general notion that can involve mediators, can be without mediators. It also depends on what type of mediation we're talking about, from the point of view of mediator or from a different point of view. An expert can offer a solution or maybe offer no solution. And again, the overall context is important. Maybe it is free, safe, informal, or it can be formalized. Some very similar to how it is in administrative bodies or how our investigative bodies works. Because from their point of view, they also create a safe atmosphere. What will happen to the victim during an interrogation? Nothing will happen. Just like nothing will happen to the offender. Is the investigation safe? Yes, it is. Is it safe in the court building? Yes, it is. Nobody will do anything to anybody. But why people involved in these procedures are internally so afraid? Why do they cringe? Why can't they say what they really feel? So probably we're talking about a different type of safety, psychological safety, where a person would really be able to say what concerns him or her, so that this is an agreement which meets the person's internal needs, so that the person would be satisfied with that solution, so that this would be the decision by the person, rather than caused by some sort of pressure, some sort of fear. Yelena, thank you very much. I think that we have points here where our colleagues can meet, can agree. The discussion in the chat is getting more active. Maybe colleagues, those of you who made your points in the chat, maybe you voice it orally. I see that bridges are starting to appear, but still we need to be very attentive to details. Larissa is writing that the term conciliatory procedure seems to be quite good, quite appropriate. I think this is very good. Natalia Gaidanka-Scher says there are conciliatory procedures, there are agreement procedures, there are prescriptive procedures. So in the logic of the approach which I proposed, I think we're proceeding from the technology, which, if used, will help to reach a reconciliation. And again, it is very important here to look at the difference, which we heard in the presentations by Lyudmila Karnozova and Yelena Belanogova. We need to take into account the procedure, within what framework and on what site, on what venue this procedure is carried out. Is it a jurisdiction-based or non-jurisdiction-based procedure? Clearly, it's difficult to draw a line here because we're talking about state and non-state procedures, but still there are various alternatives. So I think our dialogue is useful because it promotes the idea on and on. I can see that Konstantin Korsakov has raised 2 points. Konstantin, what would be the best way to do? I see somebody raise their hand. I would like to reply to the comment by Lyudmila Karnozova. She said that we need to whether we need to specify the procedure in the law or we don't. Clearly, human activities, in particular mental activities, cannot be brought boiled down to a law. This is not what I'm trying to say. Or psychological approaches in jurisprudence, in particular in criminal law, cannot be regulated by law. Although they are, it is prohibited, for instance, to deceive or to lie. There's a direct prohibition on lying. But what we're saying is that the fact that I'm referring to investigative activities, they have in a very broad rule sets. They set aims, procedures, and limitations. What can be done, what cannot be done. This is all specified in the law. If it is not specified, then I'll give an example. When the existing criminal procedure code was taken into effect, there was a paragraph you can only disclose witness statements when both parties agree. So when this norm appeared in the law, witnesses started to get killed, and then the law on witness protection appeared. Because it can bring unexpected fruit. Pressure, for instance, during the cancellation procedure. Pressure from any side cannot be ruled out. For instance, it is possible that the conciliator would also be exposed to such pressure. And this must be clarified, and the conciliator should also be protected by law. This is what I implied when I was saying that there should be a procedure. The procedure should be clarified. The rules for this procedure should be clarified. Because psychology has also its laws, doesn't it? It is prohibited, for instance, to use certain types of influence, right? This is what my message was. Thank you. Konstantin, thank you very much. I think that there's no conflict between these statements, whether this should be specified in the law or not. We're talking about what should be specified. I think that from the statement by Konstantin Korsakov, we can choose what can be used to demonstrate negative freedoms rather than positive rules in the law. This formula is used quite often in the Russian criminal procedure law. You should deformalize a pre-court investigation. When, for instance, we hear investigative actions that are accused of being elevated to the low level. So this is where we hear proposals to deformalize the situation. The steps to this end are a different story, but we can rely on the US experience here, where we hear the formula which I had just said, not positive rules that should be followed, but rather than negative freedoms. That said, guys, do the way you like, but the overall direction is like this. This is the final aim of the procedure, but in this procedure, we should not see this, or that. And the reason for this lies in the American Constitution, in the US Constitution. Amendment number 4, freedom from voluntary arrest. Maybe here in this example, or this, we will be able to find a methodology for building the rules that should be fixed in the law. And these prohibitions should be related to freedoms and rights. And the parties involved should not be deceived. The existing cancellation technologies will be within this, will be living, will be developing. Maybe we should use a parallel to court cancellation as a regulatory act. Should not be necessarily a statement by the plenum of the Supreme Court, but a certain act, certain regulatory document that is authoritative enough on one hand, and is not law on the other hand, that would specify the most typical conciliatory agreements, conciliatory procedures. So here, I think we could reach an agreement, a consensus between free reconciliators and lawyers who are very meticulous about every single phrase, every single letter. Lawyers and non-lawyers, actors, non-actors would be able to agree, and they would. So, colleagues, we continue. Anybody willing to say anything?
Ну да, я просто... Слышно меня, да?
Да.
Спасибо. Я просто, ну, там
Yes.
написал, потому что...
I send a message to the chat box. Just these reconciliation programs that are available at the moment, I wouldn't, I don't think that, the parties would conscientiously mislead each other. And you have the opposing party, for example, if the people feel that there is some threat or some pressure which is being exerted, so they will just quit the mediation process. And then if the mediator feels that there is some manipulation or again pressure, and then mediation will set the procedure back on its course and its due course. And we know that there have been situations where people try to use mediation to their advantage. So, and then we just refused. So we said, no, we don't want to be used by you in order to seek your own interest. If you to find information, if you want to punish everyone, or we just didn't agree to corroborate. And obviously, if you have two parties, it's only normal that they would have two opposing views. I mean, it's not about over cheating or misleading or hiding information. I mean, they just they see it into it. I mean, it's the subject matter of the conversation of those things that are important to each other. We're not talking about truth finding, just about people and expressing their feelings. That I feel offended by this, or I don't like this. I mean, there's no. If someone says that you are lying to me, say please, I want you to pay $200 million, and then the both parties say, I disagree. I don't have that amount of money, and then probably, why do you think that I should pay this 1,000 because your moral damage is 1,000? I believe it is less. So our position is such. So we want you to hear us, and we want share it. And And then Constantine says, yes, if there is the interested party can exert some influence on the mediator, so the other party would enter into the agreement, risking the threat of pressure. And again, so we haven't seen it. I mean, the procedure itself is not that structured that someone will be imposed or someone will be pressurized into signing an agreement. No, it will just not work. Just the procedure that as we run it, and it excludes this possibility. So thank you very much for your comment. And indeed, we need to take this experience into consideration. You've just explained one of the ways in which reconciliation procedures can be further development, and the outcome of this reconciliation can be also enshrined in the legislation, saying if the outcome is positive, then it has been signed off by the parties. If the outcome is negative, then the court case can resume and continue. And if it is out of court methods, then we can think of some regulations or just administrative acts that would lead to certain consequences. So I believe that our regulatory framework should operate as an algorithm that would provide options for all possible situations in life. So, any further remarks or questions? Probably those things that are of interest to you or something that we need to further discuss. So Elena Valentina is now, providing her comment. So the colleagues, for those that conduct preliminary meetings as to whether a dispute can be mediated, and also assess the risk of compulsion or coercion. So I think it can be another thesis from our conference that not all the situations can be settled through reconciliation. Just reconciliation technique are not an all-cure recipe for all sorts of situations. And that's the thesis, that we would invoke every time when we're talking about the efficiency of legal institutions, for example, Ombudsman for Human Rights, and so representatives of the Ombudsman is not a Superman. And so all the needs, just cannot be addressed by one person acting alone. And just the same principle applies to our field. Restorative justice, mediation, and negotiation, they will be efficient only when and as the parties themselves are willing to participate. And on the other hand, when we see that there is some opposition, for example, a colleague of ours has just put a thesis that saying that our society is a complex and includes many people, and there are some situations where a reconciliation will not work. So we need to try and protect people against any misconduct or probably further damage that can be inflicted on them by those people that aggravated their situation in the first place. I would like to add that to this conclusion, I fully support. It's up to an individual to decide. What to do and what and how to resolve a dispute or settle a conflict. So it's up to those involved in the conflict that will make this final decision. So self-determination, I think, the very development of this is this educational function that all of us have. Just making individuals ready to take this responsibility for their own actions. If someone decides to use force against another person, then again, it's the responsibility of the individual, and then he will have to live the consequences. And again, mediators and specialization. Mediators should have some specialist knowledge. So, for example, I'm a lawyer, but I don't specialize in family matters. And then if I need to deal with sort of conflicts, and I'll invite a psychologist. So a psychologist will help me, and then we'll work together in tandem perfectly well. And it's also up to the mediator to see how to resolve the conflict in the best way possible. So Natalia, thank you very much for your contribution. So, and I'm following our chat box, and I can tell that our audience is very active. So, to those, we are discussing many issues and many questions. And by the way, so it's like a drop of water that reflects all those arguments that have been put forward and the points that have been raised. So that goes to the core of the um, themes and the topics under discussion. So I just started this statement about criminals. Criminals or criminal communities. I don't remember. I cannot remember whether we have met them. It would be more of traffic accidents than juvenile justice, robbery, and probably minor cases. So for someone, I mean, a teenager, if he steals a mobile phone, then it's a criminal case. But if we're talking about like real criminal or repeat offenders, I think we need to think well before we do it. So probably we need more than one mediator, probably a team of mediators, and probably this will require a long period of preparation. Probably we will not set a face-to-face meeting with the person, but probably we'll do it online through Skype. And one more thing, so it's not the so the annulment of punishment or the reduction in sentence, alleviation of the sentence. It just if the offender comes to see the victim, and then he can take part in the conference and the meeting, and then it will be up to the judge to decide. So we have never ever promised it to anyone that reconciliation will help to reduce the sentence, because all we say is that yes, this can be taken into consideration by a judge, and then the judge will be looking at the case file, because it can be either discontinuous of the case, or it will be a sentence probably less strict. And therefore I don't think that someone will try and use this psychological leverage. I believe that it's more advisable to use this psychological leverage towards a lawyer or the defense attorney, because the result will be more evident and clear. And then I would like to mention the European Forum for Restorative Justice, and that was by Breivik. Remember Breivik, that man that killed many people? So Breivik is now in prison because his sentence is 23 years, and that's the maximum that they can. And then the question was whether restorative justice can be applied to his case. So that forum was attended by many colleagues of ours from the European countries, and so they split their opinions. And some people believe that no way, because he's a wicked man, and that's his crime was outrageous. And then I just remember that within our team, we were considering as a possibility, like why not? Why being so categorical about that rejection, or saying that he would never agree, but say this Breivik, he is in prison and he's been visiting by journalists and ladies, some rich people, and just he's just there popularizing himself. but probably there is like 0.0 probability or the likelihood that he may have this empathy towards someone, but you will never know unless a person comes from mediation trying to talk to him. So I remember the way that we used to talk to juvenile delinquents, and then they were saying that, all those things that we stole from warehouses, we just don't care a lot, but we're still very sorry about that poor lady that we stole two gooses from, or I'm still sorry that I broke the windows in school. So these are repeat offenders. And this man, he's very ashamed of his action when he broke the windows, and he wrote a letter to the school principal and apologizing for his conduct. And obviously Brevik himself could feel empathy for someone of those people that he killed. Secondly, so victims and their relatives, and probably for those it will be very important to hear that. So we could ask. I mean, we cannot say for sure that they don't want to hear this, the words that the person repents his action. So maybe apologies that can be sent as an email, or I don't know, calling them and saying that they're truly, truly sorry. And is it linked to punishment? In no way. So it has nothing to do with punishment. So if it's just the person is already in prison, and if he wants to somehow compensate, then why not? If the other party, I mean, doesn't oppose, but if he wants to do it in order to get his sentence reduced, then my answer would be negative. So I said, no, we never do it. We don't reduce the sentence, and we don't all help to get away from justice, but we do help people who believe that it is very important to talk to each other. And we know that just one case and reconciliation took place with a person facing death penalty. So that meeting took place and the death penalty was executing, and that was important to two of them. So they did want to hear each other, and they did want to stop this, the situation in their life. And then why not? So there should be the possibility provided to them, and then it's up to the court or the judge to decide on the serious or of crime, and also the series of punishment. So thank you very much for being so precise about all the points that are important, and the role of restoration and reconciliation in criminal justice. Mr. Jakubov also wrote in the chat box, and I would like to give the floor to him. Just Kazakh experience also covers what what we have discussed. And over to you. Right, coercion, or some attempts at coercion towards either the mediator. In Kazakhstan legislation, so an administrative court also has a specific provision that says that in breach of confidentiality, so mediator will be sanctioned by 20 minimum indicators. And then if in case of breach of confidentiality agreement, of this information is disclosed to third parties. Then secondly, so the cases of coercion or some compulsion, I mean, we are the mediators and we can protect ourselves, but if whenever we face any abuse, so unfortunately, mediators mediators sometimes face this kind of situations, and we have Article 21 that says abuse of powers by lawyers, judges, notaries, and mediators. And sanction would be up to 8 years of imprisonment with property compensation. So further, the provision says whenever the mediator abuses of their powers, then the party suffers a lot. then the sanction may vary from a penalty and to imprisonment. So, meaning monetary penalty. And this is a breach of neutrality. And this is not directly, related to the examples that have been brought here that when coercion may take place between the parties. So there's Article 251, as I said, an abuse of power. So that particular mediator was sanctioned, not very severely, but nevertheless a sanction was in place. And I would like to underline that its neutral stance is important. Now, I have conducted more than 1,000 mediations, so 1,200 to be exact, and just the irreversibility of punishment, so that punishment is unavoidable, right? But we are not lawyers. We cannot reduce the penalty or sanction. And I would like to agree with Anton because we are on the negotiation side. And then all those things that pertain to the merit, to the sanction, so they will be decided by a judge hearing the case. So I remember, so one mediation was included involved a fatality. So one driver, the hit a pedestrian. The pedestrian died. So the sanction was 6 years of imprisonment. And then we arranged mediation before the Court of Appeals took a case. So two mediators were invited, and then we signed this mediation agreement. The agreement was signed by the mother of the teenager that died, and the driver then agreed to cover all this, also to give his car. Though he had the second car, so he gave his second car to the mother, and then he also promised an amount of money. And as a result, the Court of Appeals reduced this prison sentence to 1 year and a half with on probation rather than serving a real prison term. And right, I underline, so that it's not our task to get the sentence reduced, but our task is to provide this possibility of having meeting with the party, and then so we can mediate, and then it will be up to the judge so to decide. And it is important because formally I worked with a police department, and then I even served as a guard in Saratov penitentiary facility, and then I worked as an investigator till 2004. And just oftentimes I met offenders and even pre-trial detention center. Then 90% of those detained, I mean, they find themselves not guilty for one reason or another. Right? Our justice is far from being perfect, and it's oftentimes so we see that those offenders that are detained, they don't have guilt, and this happens everywhere, even in other countries. But the point is that there are many people that are kept in the pretrial detention center that have not committed crimes, but they are suspects, and probably mediation can be used at this stage. So say if there is a person facing a prison term, then without committing any crime. So for them, I think mediation can be used as a saving exit so that they can agree. And I would like to thank Timur. I would like for your time. So we would like to thank you for your remark. And I believe so we just emphasizing the right points. And this last point even opens a new problem. I mean, So when we see mediation, how mediation can help these people that are detained but wrongly because they didn't commit it. For example, mediation may demonstrate to the judge that the person did not commit an offense, or they just can help them to get a reduced sentence. I think it works both ways. For instance, in Kazakhstan, if there is a suspect in the case, or a suspect, I mean, if he participates in the mediation, then it's not considered to be his admission of guilt. I mean, for most of them, I mean, those suspects, I mean, persons suspected of crimes, they will not admit to their guilt. So they meet mediators, and then the mediators say that I'm not going to ask this question whether will you admit your guilt or not, and they are very well motivated because they will not answer that question because they don't see themselves as guilty persons. And again, for instance, so if they say they didn't commit any crime, but still during the mediation they can meet with the opposing, with the victim, and they can agree. So and hence avoid prison term. So the applicant can instigate an action. For example, there is an offense and it's just a bit serious offense, and the applicant would file a petition with the court in order to discontinue criminal prosecution and criminal action against a particular offender. So that's the maximum outcome, and that's the goal of our mediation in criminal cases. So that this is what we are looking for. Want to get the mediation agreement plus the applicant's petition. Remember the traffic accident then with the driver killed the pedestrian. So because he was facing a prison term of 4 years in prison. That's the upper limit. But then, so that 4 years were turned into 1 year and a half on probation on the basis of the petition that they received from the victim's mother. So, and that petition was about imposing a sanction that was alternative to imprisonment, and that was a signed petition. So this is key. Actually, this agreement can help change the severity of sanction in higher sentence, be it trial sentence or trial instance or appellate instance or supervisory and going forward. Thank you very much. You have just demonstrated another positive effect of using mediation in social terms. So when we see an agreement between two persons, and this agreement can help improve the lives of people, and this is also very important to the state that is considered as a socially responsible state that takes care of its citizens. So that's very significant. And we, as lawyers, so uh, need to establish an institution to just make sure that these opinions are taken into account by the authorities. And I would like to give you another case that happened in one of the regions of Kazakhstan. So the seven, that was the original center, and the seven guys, what they did, they were stealing from the plant. So they were just they started with smaller things, and they were caught. So when they were caught, they turned into seven defendants. So we start our mediation then, and it takes us 3 days. So mediation is between the seven guys and the plant administration. So as a result of the mediation, so one person was sentenced, and the sixth person just were on probation. And then I attended one of the meetings, so and I raised this as an example. And then I had a remark, so a critical remark, saying that probably we will facilitate further crime from these people because the punishment should always follow the crime. And don't you think that you're making life easier for them? These were the remarks. And then I said, okay, let's see. So the seven guys, I mean, first time offenders, how many of them? So do you know how many? Yes, one, only one of them is a repeat offender. And six teenagers, six young people, they were just first-time offenders. And then my second question was, if we take this group of six, then how many of those have families? So, and then again, my question, so my answer to this question was that four of those young men had families, and three of them had children, one child, two children, three children. And then I was saying that existing legislation in Kazakhstan, unfortunately, just punishes the entire family, not an individual, because if fathers are sent to prison, children will not be able to see them, to communicate with them. They will, and to the point is, again, people are talking about this inevitability or inescapability of punishment, or certainty of punishment, right? That mediation helps, and we just helped three or six persons to save their lives. I mean, to save their future, because they kept their families and they stayed with their children. And I believe these are very good intentions. So the certainty of punishment, sure, punishment should be certain for crimes, but I wouldn't disagree with that. But still, I've mentioned that I worked as an investigator and I worked with the Interior Department, and I know what it means. I mean, if a person just stays for a day in the penitentiary facility, then he will be changed entirely for the rest of his life. And you just meet him for interrogation, and you see that overnight it will change everything in his life, in his head, and you will meet a completely different person the next day. So Valentina Belanogova would like to say something. Is that correct? Yes, so I would like to somehow balance those points that have been already highlighted by the previous speaker. Yes, from the family point of view, it is important. Also, from the point of view of first-time offenders, so it's better not to continue with the punishment. But restorative justice is all about the interest of the victim. It is important that so the victim, and I'm not referring to the plant or organization, so I'm talking about individuals that have suffered, because for any individual it is very important to have this transition from the victim state to a normal state. So there should be no fear about this offender. There should be no grudge or hard feelings against that person, so that people could speak up and just seek the restoration of justice towards the victim. So these are, because some forms they would just they wouldn't consider a victim as a human being, because even the victim or a witness, these are the people that they are considered to be those that help collect evidence against the defendant. So my point is that we need to remember about persons that are being engaged in these procedures, either at the investigator stage or at the stage of court proceedings, because this experience is very traumatic to people. I mean, it's good if we can reduce the sentence, but it is equally important to have, this restoration on the part of victims. So thank you very much for your contribution. And so I'm not, I will not dare to comment on the statements, otherwise we may have another heated discussion. And I clearly see that there is a change of paradigms in criminal justice. So, and we are just switching from oppressive and paternalistic model to social-oriented models that is geared towards resolution and peaceful settlement just now and here, instead of following the rules or the letter of regulations and sanctions. So I know we have a very exciting discussion, but also the time limit is 5 p.m. Людмила Михайловна, so I'd like to give you the floor. Right, because there is one thing that I want to mention, and I'm grateful so to our colleague from Kazakhstan for raising this point. And obviously they have this very diversified experience, but still I cannot help but comment on one of his statements. Remember that he was describing situations where innocent people are put behind bars, and then mediation. Just we are talking justice and mediation, and just here to that mediation turns out to be the only possibility for getting out of hands of the so-called fair justice. So the only, exit from there. So just the last resort. And I believe that this is a desperate attempt to help people. So mediation in criminal cases, there are international recommendation, and restorative justice is conducted where the parties so admit to the fact of crime. But as for no, this cases of innocent people, obviously, if it is not about money, but about the situation is such, so it's not about guilt. It's the situation. So what we have seen is that justice in its pertinent function, the function of protecting innocent people and prosecuting guilty persons. It seems that uh, justice fails at its own function, and mediation comes as a like secret saver. So the something that saves people. So remember, once we had a discussion about restorative programs, and then what was said then that people would seek mediation in as a desperate attempt to restore and protect their rights. So this is not the function of mediation to save the innocent, because this is a direct task of the justice system. And probably my colleague would disagree, but I mean, my reading of your reactions, I believe that we are all people, and if we see some injustice or we want to remedy the situation, I don't know, I don't have a solution that I can suggest to you, but I mean, without going into the analysis of the legal facts, but obviously if it is clear that the person is innocent, probably we can just restart the proceedings. And I remember also a colleague of mine used to say, just people are tired, they're so tired, they're exhausted because they're ready to pay to prove that they're innocent. I mean, this is just this problem is from another field, and I don't want to have it included in the agenda of mediation conference. And so thank you very much for your remark. That's why I wanted to clarify. So that's why I asked if mediation can help remedy judicial errors. I mean, we shouldn't confuse the two things, because there is the justice system. The justice system should work to correct judicial errors, and there is no reasonable place for mediation among those institutions that can help ensure this proper justice, because all the mediation techniques have a slightly different purpose. And dear colleagues, would you like to add something? Yes, and actually, I would like to praise Konstantin for his thesis. I just this first phrase just as opposed to the statement. So and then when the statement reads as a restorative justice in Russian for a long period of time, just sets the task of re-education, and it's the whole science, criminology that includes prevention, reintegration, and so on and so forth. Right, let's look at the function of the community. So this task of reintegration and re-education is really important. And we have been discussing that if we look at the scale, then on the one hand, we have criminal act and punishment.
Извините, случайно, да, не туда нажал.
Right. Sorry. And I would like to quote from Denis Chow, remedying the deed. And this says, for those people that committed crimes, we want them to have this self-confidence that therefore would destroy their dignity during a criminal justice. We want teenagers, we want juveniles to be responsible for their deeds. Therefore, we take all responsibility from them. We want them to become part of the society. That's why we isolate them from the society. We want their life to be bright and promising. Therefore, we denigrate them, make them useless. We want to have trust in them. That's for we place them in places where there is no confidence. We want them to be kind. Therefore, we place them among people that are cruel. We want them also to be peaceful, and then we place them to those people that are bad, and then we don't want them to become cool, and that's why we place them in the places where these cool features are praised. We want them to be successful, and therefore we put them in the places where they're surrounded by people that are not successful. So we want them to be very self-regulated and very beneficial. And therefore, we put them in the places where they've been exploited, and they do not develop. So that's the characteristics of our justice system that has been delivered by one of the judges. Right. So if we have a traffic accident and say this teenage driver driving a car, or probably, he sees a person walking with his mobile, and probably he'll be just calculating his years in prison. I don't think that it's the case, because usually teenagers would be acting as a group. So if among friends, so that's very rarely that they would calculate it as an individual action. So this restorative justice includes some mechanisms that help prevent, reintegrate, and so on and so forth. And we have this criminology as a theory, John Bradway, and the book, by the way, is published on our website, and that's two types of shame. So this shame that connects a person to a problem, and that's the second type of shame when the society is ready to accept the person once the person changes themselves. And these are the statements that are proven by examples from many countries, and he just put forward his thesis, and he also writes that it's shame that if people sincerely um, think that they are sorry for what they did to other people, and then they just stay in the safe environment and they think about what happened, and just what did he do, and not about talking to a lawyer or the defense attorney, just give him some space for reflection. And probably if you meet with the victim, so if he sees the victim, it's not because it's the law will not cry, the code will not weep. So just the victim, the real person that will come to meet him and explain so how hurtful it is and how bad it was. So we see that there's a lot of description of restorative programs, and there are many articles and papers on this anger, on the promise and reconciliation, forgiveness, and this empathy is a feeling, because it is very important, because they don't have it from the very beginning. That's why we believe that these restorative programs are very important. So they're important to those, I mean, to breed the seeds of good things. Even compensation, for example, that he gave his car and that he offered his money, probably even didn't they people didn't ask him to do that, but he wanted to do that. Was his goodwill, and obviously he did want to reduce, I mean, his sentence, but at the same time he wanted to somehow remedy the situation. If we do some bad things to other people, probably we want we want to do something good instead. I mean, it's very bad situation where we see that the only thing that person wants is to have his sentence reduced. But it's more about, I mean, personal communication. It should be monetized, or it should be put only to the in the amount that is calculated. And it's all about life situations. I mean, some people just cannot find a job, and then a guy stole a just very cheap car from elderly couple, and they explained that that car was important to them because now they couldn't drive to their cottage home, and now they're left without food. And it's all. It's not about the car. Then it became clear to the teenager. So then he realized that probably he could bring that food to the poor old elderly couple, and that's all about the reflection, okay, the compassion, the empathy, and also trying to plan what to help, and how to be accountable and responsible, also the mechanism of justice. So there's just the two parties realize that their actions will be just, and they will not try to evade that responsibility. I'm talking about responsibility, not punishment. I mean, that would prevent further crimes. Now, these are other mechanisms as opposed to this fear before punishment or sentencing. Thank you so much. And we have seen yet, another insight into the logic of restorative justice and justice at large. And we are talking about the functions, and more importantly, if we go back to the title of the conference, we can truly see the benefits of restorative justice. And I believe justice should go like second, and the predicate, I mean, restorative, should be put in the first place, because restoration is key. So going from negative to positive, and obviously these changes need to take place within this public system of justice. And I clearly see that there are heated debates in the chat rooms about two global approaches. So there's a legal approaches that were formulated at different period of times, and under the influence of various factors, they modified the features slightly. And the second category would be non-legal approach. So legal approach and non-legal approach. A non-legal approach would suggest a new logic or highlight new aspects. So this very, I think, this discourse that can go on forever, and that I think creates this cumulative effect. So we have one platform that brings us together to share our practices and insights, and we see this the areas where we can apply, or the areas we can disagree or agree. And these, provides material to the academia, to the representatives that will be writing papers and articles, and also it will be also beneficial to practicing specialists because they'll gain a better understanding of the terms and concepts they're working with because they're well aware of all the practical aspects and now clearly will set the context. And this context demonstrates practices and approaches both at regional level and national and even international. And I suggest so we take a pause in our discussion at this point, and I would really welcome the publications of your speeches and presentations because I believe our discussion has been fruitful, and I represent the organizing committee, and therefore I would like to thank all participants of the conference that joined us today and that took part in the deliberations yesterday. So thank you all for your efforts, to maintain this online conferencing, and I know this is not the most easiest way of communicating, so I thank you very much, esteemed colleagues, and I'd say even dear friends, for all of your efforts that you put into this conference to demonstrate your very active participation and just sending your questions to the chat box and raising hands and personally communicating. That is vitally important for academic discourse. So secondly, as I said, we are looking forward to receiving your papers for publication. So you can just visit the website. So it's quite easy to remember. That's the website of the conference, and then you can send your papers. So just, and that's it will be till the 20th of January. Okay, 20th of January. That's okay. The deadline, I repeat, is the 20th of January 2021. So we believe 1 month provides such a sufficient time in order to put together your papers and material, because these are not articles, because if these are academic articles, of course you need to provide 0.7 of this printed paper. So, and that's an exact number of pages of words that should be on the page. And our conference has been recorded, so you can find them a link to the first day, and the second day will be recorded as well. So all the links are active, and you can use them. And you can also use the material of our conference. It's with my deepest gratitude that I address Evgenia Vaiskova that helped me to moderate this session, this final session, sixth session, and Evgenia was also a member of the organizing committee of this conference, and made a great contribution towards its preparation and delivery. So my sincere thanks to you. Now it's 5 p.m. sharp, and I believe we have decently fulfilled our program, and I would like to thank all of you for taking part in the conference. And once again, I'm looking forward towards receiving your publications, so because these are important ideas that we want to publish. And welcome to our next events. Thank you and goodbye.
Спасибо.